It is my duty to lay before the House, pursuant to subsection 41 of the Privacy Act, a special report from the Privacy Commissioner entitled Investigation of Unauthorized Disclosures and Modifications of Taxpayer Personal Information at the Canada Revenue Agency. Pursuant to Standing Order 1083H, this report is deemed to have been permanently referred to the Standing Committee on Access to Information and Ethics. Tabling of documents. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. Pursuant to Standing Order 109, the government responds to the 20th report of the Standing Committee on Procedure and House Affairs entitled Becoming a Candidate in an Election, a review of the criteria. The government wishes to thank the committee for their work on this important matter. The government is pleased to see that all 7 legislative amendments recommended by the committee have been incorporated into Bill C-25. I understand there was an attempt to get it emailed, but just in case it hasn't been emailed, Mr. Speaker, I'll table the documents.
The Honourable
Parliamentary Secretary, the Minister of Canadian Identity and Culture, Minister responsible for official languages, and the Secretary of State Sport. Mr. Speaker, pursuant to Standing Order 32.2 and pursuant to the decision on treaties, I am pleased to table before this House the agreement between the Government of Canada and the Government of the Republic of Korea on cooperation in audio-visual co-production in Gatineau on April 22nd, 2026. Introduction of government bills.
Secretary to the Government House Leader.
Yes. Thank you, Mr. Speaker. Pursuant to Standing Order 36.8a, I have the honour to table in both official languages the government's response to 34 petitions. These returns will be tabled in an electronic format.
Introduction of government bills, statements by ministers, reports from interparliamentary delegations.
Member for Port Moody Coquitlam.
Yes, good morning, Mr. Speaker. Pursuant to Standing Order 34.1, I have the honour to present to the House in both official languages the following reports of the Canada-China Legislative Association 25th bilateral meeting in Ottawa, Ontario and Vancouver, British Columbia from December 1st to 3rd, 2025, as well as the Canada-China Legislative Association co-chairs annual visit to China, Beijing, Hangzhou, Shanghai, Shenzhen, China from March 16 to 2026. Merci.
Presenting reports from committees, the Honourable Member for St. Catharines.
Thank you very much, Mr. Speaker. I have the honour to present in both official languages the 26th report of the Standing Committee on Procedure and House Affairs entitled Main Estimates 2026-2027. Vote 1 under House of Commons, Vote 1 under Leaders' Debates Commission, Vote 1 under Office of the Chief Electoral Officer, and Vote 1 under the Parliamentary Protective Service. And while I'm on my feet, Mr. Speaker, pursuant to Standing Order 104 and 114, I have the honour to present in both official languages the 27th report of the Standing Committee on Procedure and House Affairs regarding membership of the committees of the House. If the House gives its consent, I intend to move concurrence in the 27th report later this day.
The Honourable Member for York South Weston Etobicoke.
It is my honour to present in both official languages the 8th report of the Standing Committee on Foreign Affairs and International Development entitled A War on Civilians, Addressing the Human Toll of the Conflict in Sudan.
109, the committee requests that the government table a comprehensive response to this report.
Dépôt de projet de loi.
Introduction of private members' bills. First reading of Senate public bills.
Motions. The Honourable Member for St. Catharines.
Mr. Speaker, if the House of Commons gives its consent, I move that the 27th report of the Standing Committee on Procedure and House Affairs presented to the House earlier this day be concurred.
Those opposed to the honourable member moving the motion will please say nay. Agreed. The House has heard the terms of the motion. All those opposed to the motion will please say nay. Carried. Presenting petitions, the honourable member for Hastings, Lennox, and Addington, Tyendinaga.
Thank you, Mr. Speaker. I am rising today to table several petitions signed by thousands of concerned constituents who are calling on the government to immediately halt the Alto high-speed rail project. They cite a number of very legitimate concerns, including heavy-handed expropriation, dividing up communities with no level crossing, the proposed cost, and the questionable benefits the project offers. I would like to thank the countless citizens in Hastings, Lennox, Addington, Tyendinaga, and all across Canada for their continued efforts in raising awareness of the negative consequences of this project. Thank you, Mr. Speaker.
L'honorable député.
The honourable member of Kapuskasing, Timmins, Mushkegowuk.
Mr. Speaker, I would like to highlight our continued efforts in Northern Ontario to circulate the petition calling for Highway 11 to be designated as a project of national interest. Je vous demande tous.
I call on all of you to sign this petition as soon as you receive it in your town or your city. It is by working together that we can ensure the security and reliability of the Trans-Canadian Highway 11.
We started. We'll keep collecting signatures from communities across Northern Ontario. To make one thing clear, safety must come first. Thank you, Mr. Speaker.
Presenting petitions, the honourable member for Courtenay, Alberni.
Well, thank you, Mr. Speaker. Mr. Speaker, it's an honour to table a petition drafted by Graham Riches from Parksville in my riding. He calls on the government to fulfill international commitments to treat food as a human right. And he draws the attention of the House of Commons to the right to adequate food is a fundamental human right recognized in the Universal Declaration of Human Rights and in the International Covenant of Economic, Social, and Cultural Rights ratified by Canada in 1976. And under the ICESCR, Canada has a legal obligation to ensure physical and economic access to sufficient, safe, nutritious, and culturally appropriate food for all. The petitioners highlight that the United Nations has affirmed that food security is primarily the result of inadequate income and social protection, not food shortages. Yet over 10 million people in Canada experience some form of household food insecurity, and reliance on food banks continues to rise, and that Canada has not entrenched the right to food in domestic law, nor established clear legal duties, monitoring, or remedies to fulfill this obligation. They call on the Government of Canada to, 1, recognize the right to adequate food as a justifiable human right in Canadian law, consistent with the ICESCR. 2, invite the United Nations Special Rapporteur on the right to food to conduct an official visit to Canada and report to Parliament. And thirdly, develop in consultation with Indigenous peoples, provinces, territories, civil society, and people with lived experience a federal right to food framework act that establishes government duties, measurable targets, monitoring remedies, and lastly, align federal poverty reduction, income security, food and health policies with Canada's international human rights obligations, including the ICESCR and the United Nations Declaration on the Rights of Indigenous Peoples. Thank you.
Questions on the... excusez, l'honorable député.
The honourable member for Rosemont Petit Patrie. Thank you, Mr. Speaker. I have the honour of tabling a petition signed by thousands and thousands of citizens, an important position given the assaults in the Caribbean region. The request is to condemn the American actions that are against international law, to not take part in these types of activities, and to make sure that the Caribbean region is considered a zone of peace, no external military activity, to reject any activity against Cuba, Colombia, or Mexico of this sort, and to stand against economic measures and any other measures against Cuba, and to vigorously require their request to strengthen trade and economic ties with Cuba, and to promote unequivocally the right to free self-determination for the countries in Latin America and the Caribbean. Thank you, Mr. Speaker.
Questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, I would ask that all questions be allowed to stand at this time, please.
Agreed. Orders of the day.
Government orders, business of supply, opposition motion regarding protection of private property rights in Canada, standing in the name of Mr. Schmale.
Mr. Schmale, seconded by Mr. Van Popta, moves that, given that 1, the Cowichan Tribes versus Canada decision created massive uncertainty around fee simple property, the legal basis on which Canadians and businesses alike own their homes and land. 2, this decision is already having significant impact on home values and the financing of projects. 3, the subsequent Musqueam Rights Recognition Agreement has deepened uncertainty and failed to say anything definitive about fee simple property, deepening uncertainty and creating a dangerous precedent with potentially serious consequences. 4, the government implemented the Directive on Civil Litigation involving Indigenous peoples. That includes litigation guideline number 14, which discourages government... Dispense? Okay, may I dispense? Yes, okay, good. The Honourable Member for Haliburton Kawartha Lakes.
Thank you, Speaker. I rise today to address a matter that strikes at the very foundation of security, stability, and confidence in this country: the protection of private property rights in Canada, following the decision in Cowichan Tribes versus Canada. For generations, Canadians have believed that when they purchase a home, pay their mortgage, raise their children, build a business, or farm a piece of land, that property belongs to them. That belief is not merely emotional, it is foundational to our economy, our financial system, and the trust Canadians place in the rule of law. Today, unfortunately, that certainty has been shaken. Canadians already face enough pressure from rising costs, inflation, unaffordable housing, and economic uncertainty without having to wonder whether their home is truly theirs. Yet that is precisely the uncertainty that is now spreading across British Columbia and beyond. The Cowichan ruling has raised profound questions about whether fee simple property ownership, the legal basis upon which millions of Canadians own their homes and businesses, remains secure in the way Canadians have always understood it. And instead of providing clarity, this Liberal government has deepened that confusion. Instead of defending homeowners, they withdrew legal arguments that protected fee simple ownership. Instead of reassuring Canadians, they negotiated agreements behind closed doors. Instead of transparency, Canadians received uncertainty. Speaker, Conservatives believe reconciliation and private property rights can and must coexist. These are not mutually exclusive proper principles. And we respect Indigenous rights. We respect the Constitution, and we recognize the importance of meaningful reconciliation and the need to address historic injustices. Indigenous peoples, I think we all can agree, deserve respect, recognition, and fairness. Their histories, their cultures, and constitutional rights are an essential part of our country. Treaty obligations matter, Section 35 rights matter. But reconciliation, unfortunately, Speaker, cannot come at the cost of destabilizing the homes, farms, businesses, and life savings of ordinary Canadians. It cannot proceed through secrecy and without transparency. And it cannot proceed while governments refuse to defend the certainty upon which Canada's entire land title system depends. And that is why Conservatives, Speaker, have called on the government to immediately change course. As the Leader of the Official Opposition stated in April, the government must provide certainty, defend private property in court, and make clear that Canadians' homes and land titles will be protected. And just before I get a little further on, I'd like to mention that I am splitting my time with the member from Langley Township, Fraser Heights, a remarkable member of Parliament, and I'm looking forward to hear his words. So as I was saying, the government must explicitly defend private property rights in the Cowichan decision. And the federal government must, going forward, argue before any court when discussing a new agreement or treaty that fee simple property land ownership supersedes all other titles. the Liberals should not have directed, Speaker, federal lawyers away from advancing the extinguishment argument that had previously been part of the Crown's legal position. And they must ensure this defense is advanced in all future legal cases involving Aboriginal title. And it must stop pretending that this uncertainty does not exist. Speaker, this is not theoretical. The consequences are already real. According to reports, appraisers in British Columbia warned that uncertainty surrounding property rights could reduce property values dramatically in affected areas. Financing for major development projects has already reportedly been denied because lenders no longer have confidence in the certainty of title. The federal Liberals are doing nothing to support those affected by this decision. They actually waited for the province to intervene. They are not backstopping those landowners, businesses, or families caught up in this legal quagmire. This means that fewer homes are being built in a housing shortage, fewer jobs are being created while the economy struggles, less investment, and greater instability in an already fragile housing market. And families in Richmond and beyond, all over British Columbia, are seeing their property values drop far deeper than many markets are already showing. Farmers are asking whether their land is still protected. Business owners are asking whether they can still use their property as collateral to obtain financing. Municipalities are questioning the reliability of zoning and planning authority. And this is not merely a regional concern, Speaker. As I mentioned just a few moments ago, it is a national issue. And that is why on November 20th of last year, I formally requested an emergency debate in Parliament under Standing Order 52 following the Cowichan decision. In that request, Conservatives warned that the ruling risked undermining the indefeasibility protections that underpin Canada's entire land title system. We warned that uncertainty regarding fee simple ownership could affect mortgages, insurance, development, municipal governance, and economic confidence across this current country. And we warned that Canadians felt blindsided because governments had failed to consult or inform the very people whose homes and businesses could be affected. As my letter stated at the time, Speaker, ordinary Canadians bought their homes in good faith. They trusted their government to be transparent and honest with them. And instead, they discovered, through news reports actually, that the legal certainty of their property rights could now be questioned. Conservatives called for that emergency debate so Parliament could address those fears openly and transparently. Unfortunately, Speaker, the Liberals refused. And Canadians are now left to wonder whether that refusal had less to do with reassurance and more to do with the fact that government was simultaneously negotiating other major rights recognition agreements behind closed doors. The secrecy surrounding Cowichan did not end in the courtroom. It actually continued, Speaker, with the Musqueam Rights Recognition Agreement. That agreement, signed in February, recognized Musqueam Aboriginal rights and title across asserted territory spanning much of Metro Vancouver, including Vancouver itself, Richmond, Burnaby, West Vancouver, and Delta. Yet, despite the enormous implications of such recognition in one of Canada's most densely populated urban regions, the agreement failed to explicitly protect fee simple property ownership. That silence matters, Speaker. The government and Musqueam leadership later stated publicly that private property would not be affected, but the agreement itself does not clearly indicate that same comment. And when dealing with constitutional rights, property ownership, and land governance affecting millions of Canadians, that confusion is not enough. That confusion has deepened that uncertainty. It has created fear among homeowners and has raised serious concerns among neighboring First Nations with overlapping territorial claims. The Squamish Nation publicly stated that it had not been adequately consulted and warned the agreement could affect the lands that they also claim. Again, secrecy. Again, insufficient consultation and more uncertainty. British Columbian Speaker, we're stunned to hear that Premier David Eby declared that private property will never be part of provincial negotiations. Think about what that means for homeowners listening at home. If private property is not central to negotiations involving title and jurisdiction in urban regions, then who exactly is standing up for the millions of Canadians whose life savings are tied to their homes? Who is defending the integrity of Canada's mortgage system? Who is defending that certainty required for investments and economic growth? Conservatives are. And we are calling on this Liberal government to act immediately. We are demanding that the government put private property first in the Cowichan appeal by arguing clearly and unequivocally that fee simple property ownership has priority over pending claims. We're also demanding that no future agreement be signed without explicit protections for existing homeowners and property owners. No more confusion, no more silence, no more secretive agreements, no need to leave Canadians wondering if their home is secure. Speaker, Liberals keep pretending that Canadians should just simply trust them, but trust requires transparency. Transparency is what builds that trust. And trust requires governments willing to defend the very people they represent. And unfortunately, the government continues to create uncertainty, and it's growing across this country, and it doesn't need to be this way. I look forward to the questions ahead, Mr. Speaker.
Questions and comments. Question et commentaire. The honourable member for Calgary.
Well, thank you, Mr. Speaker, and I thought that he made a very good speech with many key points covered. And if he wants, I think one of the most important federal ties to this issue is their failure to make the argument in court when they could the first time around, making the appeal of the decision that they say they oppose so much more difficult. And so if the member could maybe comment on that.
The honourable member for Haliburton, Kawartha Lakes.
Thank you, Speaker, and very important question indeed. That's right. The government in 2018 directed their lawyers not to argue in court for fee simple property rights in the Cowichan tribe's decision. And because they were, for some reason, in that lane to not argue for fee simple property rights for the homeowners themselves, now that the case is at appeal, the government can't use that argument. They cannot use the argument that they stand up for fee simple property rights. The only group that did in the original case, Canada's longest trial, I might add, over 500 days, is the City of Richmond. They are the only ones standing up at this point for fee simple property owners.
Questions and comments. Question et commentaire. The honourable Minister of Crown Indigenous Relations.
Thank you, Mr. Speaker. Can the member opposite speak to principle number 14 that they disagree with? I'm just wondering what his interpretation of principle number 14 is. Thank you, Mr. Speaker.
The honourable member for Haliburton, Kawartha Lakes.
Absolutely, it's quite simple. The government in 2018 directed their lawyers not to stand up for fee simple property. The judge also, Justice Young, also cited that in her very lengthy decision that the government was not there. The federal government was not there to stand up for fee simple property owners. And now the decision has been made in Justice Young's decision, pointing out that 2 sections of British Columbia's land title system does not apply to a swath of land within the City of Richmond. It was the federal government that failed those landowners, those business owners, those people who are trying to sell their homes and watching their property values sink. That is unfortunate, and people deserve better.
Questions and comments. Question et commentaire. The honourable member for Cambridge.
Thank you, Mr. Speaker. I appreciate my colleagues' remarks on this issue and the broader concern around private property rights. Could my colleagues speak further to how government delay and unclear action on property rights risks setting a precedent nationwide, and what that does to public trust when Canadians want certainty that their homes truly belong to them?
Member for Haliburton, Kawartha Lakes.
Thank you very much, Speaker, and I appreciate the question from the member from Cambridge. And that goes to the second part of my speech, when you have the Cowichan decision with so much uncertainty around a large swath of land within the City of Richmond. Then you have the Musqueam Agreement that is basically a menu for future talks to land on a treaty or self-government agreement, whatever that may land. But in that agreement, the government, knowing all this uncertainty, did not address or at least put in protections that private property within the claim area was off limits, was not going to be on the menu. And this government, unfortunately, went ahead anyway, knowing that this uncertainty is spreading across the country. And now we have cases in in New Brunswick and elsewhere that are growing because of this uncertainty. You need to have that trust in the system, and property owners know that if they buy a piece of property in good faith, pay their mortgage, they are entitled to that property.
Questions and comments? Question et commentaire dans la députée.
The Honourable Member for La Pointe-de-Lille. Thank you. In Quebec, we don't have this problem due to our civil law tradition, but why does my colleague think that everything is happening behind closed doors? Things should be out in the open so we could debate them. Why does he think that the government is so reluctant?
Lakes, about 45 seconds.
Okay, great question. Thank you to the member from the block. I think what we saw in the Cowichan case is nobody informed the property owners that their property could be affected if a decision by the courts was released that we see now. Nobody let them know. The only reason they found out, the property owners in Richmond, was from the media or the city itself. The federal government was silent. And now in Musqueam agreement that we see, there were no consultations within neighboring nations. Nobody else was consulted on this agreement, but yet the government is negotiating all this stuff away behind closed doors, and Canadians deserve better.
Resuming debate. Reprise du débat. The Honourable Member for Langley Township, Fraser Heights.
Thank you, Mr. Speaker. I'm speaking on the Conservative motion that is on the agenda today, calling on the Liberal government to put private property first in the Cowichan case, arguing that private property, has priority over all other forms of title. And we're saying this because in the Cowichan Tribes versus Canada decision, it created a massive uncertainty around fee simple property, the legal basis on which Canadians and businesses alike own their homes and their lands. And I could add their warehouses and their factories and their hotels and their high-rise apartment buildings. I want to quote from the BC Supreme Court decision that has shaken the confidence of the real estate market and homeowners and landowners. This is what the judge says at paragraph 2093. I agree, she said, that Aboriginal title is a prior and senior right to land. It is not an estate granted by the Crown, but rooted in prior occupation. It is constitutionally protected. The question of what remains of Aboriginal title after the granting of fee simple title to the same lands should be reversed. The proper question is what remains of fee simple title after Aboriginal title is recognized on the same lands. And that, Mr. Speaker, is what is unsettling so many people interested in real estate. What does a prior and senior right actually mean? Now, here's another quote from paragraph 3551, close to the end of this 800-page decision, where the judge says, a precedent that will follow from this case is that provincial Crown grants of fee simple interest do not extinguish nor permanently displace Aboriginal title, in sections 23 and 25 of the British Columbia Land Title Act do not apply to Aboriginal title. Now, Mr. Speaker, before entering Parliament, as a member of Parliament here, back in 2019, I spent many years practicing corporate and real estate and land development law in the Metro Vancouver area. Now, those decades in the law taught me this with absolute clarity. Canada's economic stability rests on the bedrock of secure, indefeasible, fee simple title. This principle, inherited from centuries of British common law development, is not an abstract legal doctrine. It is a foundation of our banking system, commercial investment, housing markets, and, importantly, the ability of ordinary Canadians to build and preserve wealth. Undermine that foundation, and you undermine our economic stability and civic resilience as a Canadian society. The whole real estate industry banks on indefeasibility. The principle that says that when a person is registered as the legal owner of the land, their ownership cannot be challenged or defeated. The title is what the title says it is. Nobody had ever questioned this simple principle of indefeasibility until the Cowichan decision last year. Now, it bears repeating, just one phrase. Section 23 and 25 of the Land Title Act do not apply to Aboriginal title. Now, these are the sections, not to get technical, that underpin the principle of title indefeasibility. And today, that principle is less secure than we always thought that it was. This is the first in Canadian jurisprudence. Now, there have been other cases in British Columbia where the courts ruled that a First Nation had met all the criteria for proving Aboriginal title. The first one being a 1997 Supreme Court of Canada case called Delgamuukw, which set out the standard for proving Aboriginal title in the court of law. Now, 17 years later, another important case, the Chilcotin Nation case, declared Aboriginal title over a large but remote area of British Columbia, about 2,000 square kilometers. But all of that land in question was Crown land. The Chilcotin Nation plaintiffs in that case, their litigation strategy was deliberately crafted to avoid conflict with private property owners. Now, fast forward another decade to the case that we're talking about today, which declared Aboriginal title over a relatively small area, only 800 acres. Compare that to the 2,000 square kilometers in the Chilcotin case. But this land is right in the heart of Metro Vancouver. Now, any realtor will tell you that the three most important things about real estate is location, location, and location. And this location makes this real estate very valuable. Right in the heart of the industrial part and residential part of Metro Vancouver, there are about 150 private landowners. There's a beautiful golf course and also a significant commercial landowner whose project has now been put on hold. None of them had the opportunity to argue their case in court. The fact that the Cowichan plaintiffs did not restrict their claim to publicly owned lands, but included privately owned lands, makes this case unique. And it is in that context that we accuse the Liberals of dropping the ball. A different and more far-reaching strategy on the part of the plaintiffs, compared to the Chilcotin, where they restricted it to public lands, required a different and more aggressive response from the federal Attorney General lawyers. But under the direction of the Attorney General back in 2018, the Justice Department lawyers pulled their punches. And the judge noted that at paragraph 2096, where she said, quote, Canada initially argued extinguishment, but abandoned its reliance on this defense in its amended response to the civil claim filed November 22nd, 2018. Obviously in direct response to new directives coming from the Attorney General. They dropped the ball. They dropped their first and best line of defense, which says that the clear and simple act of the Crown granting fee simple title to individuals throughout BC's history had the effect of extinguishing Aboriginal title to the extent that future plaintiffs might argue for Aboriginal title. We're saying that it's obvious that the government lawyers should have maintained this line of defense, considering the aggressive action by the Cowichan plaintiffs, and aggressive action, offense, demands, an aggressive defense. Now, some argue that weakening private property rights is a path towards reconciliation. But Canadian courts have already warned of the opposite. The New Brunswick case of J.D. Irving versus Wolastoqey Nation, December 2025, from the New Brunswick Court of Appeal, put it this way, quote, a declaration of Aboriginal title over privately owned lands, which by its very nature gives the Aboriginal beneficiary exclusive possession, occupation, and use, would sound the death knell of reconciliation with the interests of non-Aboriginal Canadians. That's not rhetoric, Mr. Speaker. It is a sober legal assessment of the consequences of eroding certainty in land ownership. The British Columbia Supreme Court in the Cowichan moved in the opposite direction. The court held that Aboriginal title can extend to privately owned lands and that Aboriginal title and fee simple ownership can somehow coexist on the same land at the same time. In my respectful view, this is simply not possible. Both forms of title claim exclusive rights to occupy, to develop, to benefit economically from the land. Two competing exclusive titles cannot occupy the same legal space without destroying the certainty that underpins our entire property system. The result is not reconciliation, it is confusion. It is not economic opportunity, it is economic paralysis. And it is not a path forward, it is a step backward into uncertainty at a moment when Canada desperately needs stability, investment, and confidence. If the Cowichan case stands, as it is, the consequence will be profound. It risks chilling development, destabilizing markets, and deepening divisions rather than healing them. Canada cannot afford a property rights regime that leaves homeowners, lenders, and investors unsure if they can take their fee simple title to the bank. Reconciliation requires clarity, honesty, transparency, and respect, not the erosion of the very legal foundations that allow our society to function. And that is the principle that the Liberal government overlooked when they instructed their lawyers not to use all the tools in their toolbox to defend property rights in Canada for Canadians. They dropped the ball, and Canadians are paying the price. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. The member opposite did a number of histories of Aboriginal title. However, he missed the Haida Aboriginal title, which includes private property and Crown land. I'm just wondering why he omitted to discuss that. It's been in legislation for the past 2 years, and just wondering if it just doesn't support the argument that the Conservatives are trying to make. Thank you, Mr. Speaker.
The member for Langley Township, Fraser Heights.
Well, Mr. Speaker, if I had a half hour or an hour, I would have talked about all the interesting cases, but I only had 10 minutes. The Haida case is obviously a very, very important case. Talks about and expands on the principle of duty to consult. Nobody's arguing with that. There is a duty to consult. We agree with that. We agree that reconciliation is important, but to undermine the private property regime that Canada's economy is built on is not the way to forward on reconciliation.
Good answer.
Question commentaire.
The Honourable Member for LaPointe-de-Lille. It is true that it is important to clarify things, but if that's true, according to the Conservatives, why can this debate not take place in a committee instead of in front of the House?
Apparently, we tried to argue it in committee and it got shut down. We have put forward a motion. I don't know if it's in here, but we have put forward a proposal that this House form a committee that looks at this issue. But in the meantime, we need to argue it here. This is very important to Canadians. I can tell you, it is important to people in my riding, people in Metro Vancouver, because they are deeply concerned about the uncertainty that is being brought by this decision and by the lack of action by the federal government. Thank you.
Comments. Now, member for Brantford Brant, Six Nations.
Thank you, Mr. Speaker, and I thank my colleague for that excellent speech. Now, we've heard repeatedly from this Prime Minister and the Minister for Crown Indigenous Relations that the government's response to the Cowichan decision was to immediately appeal. Is that fact? And if it's not fact, what does it say about the importance this government places on this issue?
Good question.
Member for Langley Township, Fraser Heights.
Yes, we've heard that on a number of occasions, that they appealed the decision right as soon as they could. That's just not true. They waited until really the last minute to appeal it. But more importantly, why didn't they, they're saying, oh, we stand for private property rights. Well, they didn't use all the tools in their toolbox to do that. Even though private property owners had not been named as defendants, the Attorney General should have been there, could have been there to defend private property owners. They didn't.
Questions and comments? Question commentaire. David.
Questions and comments. The Honourable Member for Sarnia, Lambton, Bequeshwanong.
The new government and the Prime Minister has been clear that we will protect private property rights for Canadians. Now, I have great respect for the member opposite and his extensive legal experience. What does he believe is the best legal path forward to make sure that the private property rights are protected?
The Honourable Member for Langley Township, Fraser Heights.
Well, interesting coming from a member who didn't consult with the First Nation communities in her riding when she asked to drop the Indigenous name from her riding.
That's a fair point.
And I would say this too, that yes, the Liberals today are saying that they will defend private property rights. Well, they failed to do it before, and they've worked themselves into a corner, not being able to advance some of the arguments at the Court of Appeal that they should have raised at the trial level.
Questions and comments? The Honourable Member for Saskatoon South, about 40 seconds.
Thank you very much, Mr. Speaker. To my honourable colleague who has extensive career in corporate along with real estate law, it was an interesting speech because we talk about homeowners, but this member talked about warehouses, talked about golf courses, talked about investments. Are they as worried as homeowners in the BC region with this decision coming up?
I'm a member for Langley Township, Fraser Heights.
That's a great question. Thank you for raising that again. It was a short speech. I didn't have time to work everything into it, but I've spoken to a number of the landowners, including a commercial landowner in the region, who has a project underway. He had financing in place. He had tenants for the new warehouse complex that he was going to build. All of it is on hold. And you know what? This company is now making an application to court, doing the job that the federal government attorney general should have done in the trial 5, 6, 7 years ago. He is now making the application to argue the rights of private property owners.
Resuming debate. Reprise débat. The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. I want to begin by speaking directly to Canadians who may be watching this debate today, feeling anxious or uncertain. As the Prime Minister has made clear, private property rights are fundamental, and our government will always protect them. Federal agreements, including agreements about Aboriginal title, have always protected and will always protect private property. Before I begin, I want to remind members of this House that the Cowichan case is subject to active litigation and appeal. As it stands right now, the trial order has not yet been entered and will not be entered until Montrose's application to reopen the trial, which I will discuss later, is resolved. So given the impact that our words here today could have on this active litigation, it's important that all members of this House, including myself, are judicious and responsible with their words. So let's get to the motion. Our government agrees with some of the principles in the motion and already do take many of them into negotiations. However, we will not allow the Conservatives a platform to continue to spread disinformation with a special committee. We will not allow this Parliament to be used to relitigate an active court case with partisan rhetoric, which could potentially jeopardize the ongoing litigation. Respect for the judicial process is essential. Canadians do not need the Conservatives' political chaos and poorly informed commentary layered on top of the complex legal questions at play in this case. Further to that, this motion is redundant, as it calls on the government to do things which we're already doing. For example, in the Cowichan case, the government has defended the validity of Grant's fee simple title by the Crown, and we will continue to do so on appeal. Again, as the Prime Minister said last week, and I quote, "Private property rights are fundamental, and we will always defend them." Secondly, it's already Government of Canada policy to only make rights and title agreements that protect the private property of Canadians. I can assure this House and all Canadians that we will not, nor would we ever entertain or even consider an agreement where Canadians lose their private property. In fact, Mr. Speaker, we've been signing modern agreements with First Nations since the 1970s. None of those modern treaties, negotiated agreements, or federal approaches has led to Canadians losing privately owned land. It's important to note that any agreement on Aboriginal title at the federal level has protected and will protect private property. Avant d'aller plus loin, je vais...
Before going any further, I would like to briefly speak about my point on view on this debate. I come from a region where modern rights are dealt with by historical treaties. I own private property in a modern treaty area. I've lived, worked, and governed in contexts where Indigenous and non-Indigenous Canadians have learned, sometimes imperfectly, but always constructively, to coexist on the same land. This experience has taught me one fundamental lesson. The key to success is not stoking fear. It's not misinformation, and it's certainly not political opportunism. The key is sitting down around a table, having grown-up discussions, and doing the hard work of reconciliation responsibly. That is what this government is doing, and that is exactly what this motion seeks to undermine.
Speaker, this motion wraps itself in the language of private property while fundamentally misrepresenting the government's position, the facts on the ground, and recent federal agreements with Indigenous partners. It also confuses the results of a court decision that our government fundamentally disagrees with and a negotiated agreement which does not deal with Canadians' private property interests. It suggests that government agreements are giving away private land. It suggests that because of the Musqueam Agreement, Canadians could lose their homes. None of that is true. What is true is that this motion is an opportunistic political play from the Conservatives to create fear, stress, and division. If the Conservatives truly cared about addressing Canadians' concerns, they should have put forward a motion that is grounded in facts and reflects the situation as it is, not one that only serves their political interests. Now, Mr. Speaker, let us turn first to the Cowichan decision. This case has a long and complex history. It is, in fact, the longest civil trial in Canadian history, at over 500 days. At its core, it raises legal questions about Aboriginal title and how it interacts with Crown obligations and existing land ownership systems. Throughout the case, Canada has consistently defended the validity of Crown grants of fee simple title, and we continue to do so today. That position has not changed. We also recognize that private ownership is a foundational part of Canada's legal system. It gives people certainty and confidence in their homes and businesses. That matters to Canadians, and it matters to our economy. Canada has formally appealed the decision because we believe further legal clarity is required, particularly with respect to private property interests, and we will advance all legally viable arguments to protect that clarity. Importantly, the court ruled that British Columbia, not the federal government, has the duty to negotiate in good faith regarding privately held lands, because jurisdiction over private property and land registries rests with the provinces. Section 92 of the Constitution Act establishes provincial authority over property rights, placing legislative control over private ownership, property ownership and use within provincial jurisdiction. The Conservatives continue to ignore the fact that this is constitutional reality, not political choice. To that end, British Columbia has appealed. British Columbia is acting within its jurisdiction, and British Columbia is working on measures to support potentially impacted property owners. And Mr. Speaker, when it comes to Aboriginal title, more generally, it's important to note that the law is far from settled in this regard. For example, the New Brunswick Court of Appeal reached a very different conclusion in J.D. Irving Limited et al. Versus Wolstaki Nation, as compared to the BC Supreme Court's decision in Cowichan. The New Brunswick Court of Appeal states that it is open for a court to make a finding of Aboriginal title over private property, which could lead to a compensation award against the Crown, but that a declaration of Aboriginal title cannot be made over private property. Canada is waiting for the Supreme Court of Canada to confirm whether it will hear an appeal of the Wolstaki decision, and we're monitoring this case closely. So we now have two courts in Canada taking opposite approaches. That divergence is exactly why clarity from the court is needed. However, Mr. Speaker, we recognize that the Cowichan decision has caused uncertainty and anxiety. Canadians deserve to feel secure in their homes and investments. That's why, as far back as 2017, Canada argued that private landowners should be notified of the litigation. Further, since the ruling last summer, we, Canada, consented to the Montrose application, and we're now awaiting a ruling. For those who are unfamiliar, Montrose is a company that operates in Richmond and claim they are the largest landowner in the declared Cowichan title area. Montrose has applied to the British Columbia Supreme Court to reopen the trial and be added as a party. If the trial is reopened in a limited way, Montrose, an impacted private property owner, will have the opportunity to present evidence and their perspective on the impacts of this decision. Then, the judge will rule on whether or not there should be a limited reopening of the trial. So this may impact the decision made by the judge in August 2025. Mr. Speaker, we consented to this application because we believe that when people may be directly affected by a legal ruling, they deserve to be heard. Canadians know what they can expect from our government. We have appealed the Cowichan decision, and we will advance all legally viable arguments to preserve the certainty of private property interests. Mr. Speaker, as I've said at the beginning of my speech, though, the Conservatives believe that they should use Parliament to relitigate an active court case. Let me be clear, having these discussions here on the floor of the House of Commons or in a special parliamentary committee, instead of in a courtroom where they belong, has the potential to negatively impact Canada's legal position and may actually undermine arguments on appeal that would protect private property. We must respect the judicial process and continue to seek resolution of this matter through the courts. The Conservatives have suggested that the directive on civil litigation involving Indigenous peoples restricted Canada's ability to advance legally viable defenses in the Cowichan litigation, specifically referring to litigation guideline number 14. Litigation guideline number 14 of the directive does not preclude Canada from relying on any specific defenses, but requires a principled basis and evidence to support the defense. Canada is currently reviewing potential legal arguments for the Cowichan appeal, and all potential defenses remain on the table. Again, our government will always raise valid arguments that we believe will be successful in court. That is what the law demands and what Canadians deserve. Regardless of the directive, the government would never make arguments that don't have a principled basis and evidence to support the defense. Canada is currently reviewing all legally viable arguments for the Cowichan appeal, and all potential defenses remain on the table. But, Mr. Speaker, even if the Conservatives aren't listening, I want to reassure Canadians at home who are watching that Canada will advance all legally viable arguments on appeal to protect private property. So, Musqueam. Mr. Speaker, I now want to turn to the Incremental Rights Recognition Agreement with the Musqueam First Nation, another area where misinformation has flourished. This agreement did not appear overnight. In 2017, Cowichan and Canada signed a Memorandum of Understanding. In February 2026, that work evolved into a framework agreement. This is not a title agreement, and it is not a land claim. And let me be absolutely clear on a point that has caused concern. This agreement does not affect private property. In fact, it cannot affect private property because it's a bilateral agreement between Musqueam and the federal government. Why does that matter? Because, again, private property falls under provincial jurisdiction. As I've said, Section 92 of the Constitution Act establishes provincial authority over property rights, placing legislative control over property ownership and use within provincial jurisdiction. The federal government does not have the authority to negotiate Canadians' privately held lands, and this agreement does not in any way attempt to do that. It's important to note that all discussions of Aboriginal title at the federal level protect private property. No modern treaty, negotiated agreement, or federal approach has ever led to Canadians losing their privately owned land. Further, it's important to note that the Musqueam themselves have been clear. In fact, just a few weeks ago, Musqueam's chief negotiator said, and I quote, "Private property was never on the table. It was a non-starter from the very beginning," end quote. As the agreement itself states, this work is about building relationships, establishing principles, and setting out processes for future discussion, not transferring land. And I really want to highlight one bullet from the agreement for us to remember throughout the debate today. And I quote, "For a long time, we, Musqueam and Canada, misunderstood each other. We are all one, and we're here to stay. It was impossible for this misunderstanding to go on. We wanted to reach a mutual understanding, and that's why we gathered together to make an informed decision. In the spirit of reconciliation and consistent with the principle of Namakat, which means we are all one, Musqueam will continue to work collaboratively with Canada to further our mutual interests, to transform conflict and injustice, to create partnerships in the spirit of unity, with the aim of developing processes for shared decision-making, revenue and benefit sharing, and dispute resolution," end quote. Mr. Speaker, this agreement is the result of more than 10 years of negotiation. Negotiation instead of litigation. It provides clarity, stability, and better outcomes for everyone involved. Again, despite what the Conservatives would have Canadians believe, it does not interfere with fee simple property ownership. The maps circulating online showing land being given away are maps of Musqueam's claimed historical territory, not title. Conservatives confusing the two is either careless or deliberate. The government has not agreed to anything new with respect to these areas, and we will not, cannot, and will never negotiate away Canadians' private property. There are no clauses transferring private homes, there is no sudden erosion of municipal or provincial authority, and there is no legal basis for the climate of panic the Conservatives are attempting to create. I'll remind the members on the other side of the aisle that responsible leadership means actually reading agreements before condemning them. And let me offer the House a concrete example of a title agreement. the Haida Nation Amendment Act, which became a law in BC on May 16, 2024. The law confirms the Rising Tide Haida Title Lands Agreement and enshrines the recognition of Haida Aboriginal title in the laws of BC. The agreements and legislation provide important protections, such as 1. Private property, residential, commercial, or industrial, is not affected by the recognition of Haida Aboriginal title. 2. Privately owned land, fee simple property, remains under provincial jurisdiction, and the recognition of Haida Aboriginal title will not change any rights associated with it. That means business licenses, building permits, and zoning continues as is through the reconciling process. Key infrastructure like ferry terminal and highways continue to be operated and maintained by the province. Provincial and municipal services provided by Haida Gwaii, including health, education, transportation, fire and emergency services, also continue as they are. The agreement and provincial legislation came into effect July 5, 2024. It's been almost 2 years and the sky hasn't fallen. Life has continued on for folks. Et c'est à cela que ressemble la coexistence.
And that is what negotiated coexistence looks like in a constitutional democracy. When it comes to Aboriginal and treaty rights, we will continue to consult on pipelines, mines, and major projects of national interest. But, Mr. Speaker, none of that is new. Even before title is proven, the Crown still had a duty to consult. Title clarifies the rights of Indigenous partners. It does not invent obligations out of thin air. In 2014, when Aboriginal title was affirmed by the Supreme Court through the Tissaquotan decision, some critics predicted chaos. They warned of economic collapse. They claimed that Canadians would lose their land. None of that happened. It's been 12 years. What we gained was clarity over what and where the Sokotan Aboriginal title land is. And that clarity has created certainty for investors, for communities, and for governments. And that has allowed them to build.
Mr. Speaker, one of the greatest harms of this motion is not legal, it's social. It invites Canadians to fear reconciliation. That's not leadership. Many Canadians were not taught about treaties or about unceded land. But lack of education is not an excuse for the Conservatives spreading misinformation now. Leadership means explaining complexity, not exploiting it for fundraising opportunities. And let's be serious. We can protect private property. We can advance Aboriginal title and rights. We can do both without reopening the Constitution, as this motion proposes. Because frankly, Mr. Speaker, we do not have time for a constitutional wrangling exercise. Canadians want homes built, projects approved, the economy growing. And we can do that right now within our existing constitutional framework. Mr. Speaker, hope is not a plan, and nostalgia is not a strategy. If the Conservatives ever hope to lead, they'll need to learn how to work with all Canadians, including Indigenous partners. That means quit the fear-mongering, quit the misinformation, start learning, and start relationship building. And they need to recognize that reconciliation and economic growth are not opposites. They're partners when done properly. I'll close where I began. To Canadians watching today, you still own your home, you can still renovate it, and our government is fully committed to protecting your property rights. In Indigenous treaty or agreement discussions, private property is not on the table. It's not today, and it will not be tomorrow. What we are doing is building a stronger, more honest, more stable foundation for coexistence and prosperity. What is on the table is whether this House chooses clarity over chaos, unity over division, and serious governance over fear-based politics. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Haliburton, Kawartha Lakes.
Thank you very much, Mr. Speaker. I appreciate the speech from the minister, but I do have some deep concerns with what she was saying. The minister implies that the opposition is fear-mongering. Well, I would also invite her to speak to the property owners and business owners affected by this, watching their properties drop and the continued questions about whether they're able to refinance their house or business. The minister also spoke about misinformation, so I'm wondering in my speech, which part is misinformation? In 2018, Did the government remove arguments for fee simple property within the Cowichan case? Or was it that the province of British Columbia had to step in to backstop businesses and homeowners to be able to secure financing to continue their operations? Or was it with the proposed developments that were cancelled because of this? Or was it where they signed an agreement with Musqueam that didn't take fee simple property? So I'd like to ask the minister, which part is misinformation?
Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. So the last point on the Musqueam Agreement, it is incremental rights and recognition agreement, which means if folks are interested, they can go to the website and there's a description about what an MOU is, what a framework agreement is, and we're currently at the framework agreement. So back in 2017, we signed the MOU with Musqueam. It took 9 years to come to the framework agreement, and it outlines the next steps for discussion. The other two agreements that were signed were about the marine stewardship and the fisheries. And in the motion that the Conservatives are proposing is to put private property is not included in every agreement, which to the Conservatives I ask, why would we include that in every agreement, the education agreements, the health agreements, the self-government agreements? When an agreement doesn't touch on private property, we don't include it because it doesn't touch on private property. Thank you, Mr. Speaker.
Question et commentaire, l'honorable.
The Honourable Member for Côte-Nord, Kawachikamach-Nitassinan. Thank you very much, Mr. Speaker. I thank the Minister for her speech. I noted that she said that one of the responsibilities we have is to explain complex matters and, in fact, to dispel any kind of doubt there is for Quebecers and Canadians in this area. We have a motion, and I'll be discussing it in a moment, the proposal from the Bloc Québécois on the motion, but would she be in agreement with there being, of course this could be committee business. This has never been denied in a committee. There was a motion that was tabled. I heard that it had been denied, and that's never happened, so it is possible to do that. And this morning there was a focus on the business, and the Conservatives did not raise the motion. So I just wanted to correct the information. I'd like to know if the Minister agrees that there could be a means, perhaps in committee, to discuss the matter for the benefit of all. Thank you, Mr. Speaker. The Honourable Minister for Indigenous Crown Relations. Thank you very much, Mr. Speaker, and I appreciate the question from my colleague. Yes, I think there is an opportunity to see how we can improve education on the treaties. There's a lot of misinformation and denialism, and we would appreciate it if the committee were to take this opportunity to look into how we could improve awareness raising about treaties, residential schools. I think it would be a good exercise. And also how we could have discussions about Aboriginal title. And there are many examples of this throughout Canada. How can we better explain this and educate Canadians on this? Thank you.
Question et commentaire, the Honourable Parliamentary Secretary, the Minister, or the Government House Leader.
Thank you, Mr. Speaker, and I very much appreciate and value what it is that the Minister has clearly put on the record to provide the assurance and making sure that there's some reality with the debate that's going to be we're going to be talking about today. I share the concern in regards to misinformation because of the damage that it causes, Mr. Speaker. You know, I think in issues such as the whole reconciliation and how important it is that we continue to move forward on reconciliation. I think it's important that we continue to work nation to nation as we look at ways in which we can see the potential of Canada realized. My concern is that intentional misleading information causes damage to all of us. And if she could just provide her thoughts in regards to the negative side of misinformation.
The Honourable Minister.
Yes, thank you, Mr. Speaker, and I appreciate my colleagues' questions, and I do think to kind of tie to the both, the opportunity for improved communications, but the uncertainty and fear that can happen in the investment world when the education's lacking. And so when there's talk about the federal government is giving away all this land, which is inaccurate, that's misinformation, that leads to that uncertainty that the member's speaking of. Canada was just at the United Nations Indigenous Peoples Forum, and we're a leader that many countries look to in regards to reconciliation. And so I think we can continue to shine. Our journey with reconciliation isn't over. It's a long journey, and we need to continue to evolve. And so making sure that we continue to advance modern treaties, Aboriginal title that protects private properties is an important work that we need to continue.
Question comes now, member for Langley Township, Fraser Heights.
Thank you, Mr. Speaker. Thank you to the members opposite for her speech. They keep talking about misinformation, as though the Conservatives, when we raise issues, when we raise weaknesses in the Liberal Party, that we're spreading misinformation. All we're doing is shedding light on their incompetencies. And we have a real-life example, the Montrose case application which the minister had already mentioned. I talked to them, and they had a project that was ready to go. It has fallen apart. This is not misinformation. This is reality on the ground, and it's not the Conservatives that are feeding this. It is the facts on the ground that are making life difficult for investors. Can she comment on that?
The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. The courts and litigation does create uncertainty, and so this case began in 2014. The ruling ended in 2025. All the parties appealed the decision. Montrose has asked for the trial to be reopened, and so we're awaiting the decision from the judge. And so litigation can create uncertainty while we're working through these steps, which is why we prefer to work through negotiations. And so agreements like Haida, where the federal government, the province, and the Haida Nation were able to come together and actually work through how private property and Aboriginal title can work together, is the prime example. And so it's ensuring that Canadians understand the current stage of the legal process, because it is being appealed. There is the opportunity that the trial may be reopened in a limited way. And so I think it's important that we continue to tell Canadians the current facts, as well as continue to work through negotiations.
Questions, comments. Now, member for Medicine Hat, Cardston Warner.
Thank you very much, Mr. Speaker, and thank you to the minister for her comments. You know, I've sat here and I've heard this now for weeks since the decision was made about how Conservatives are spreading this misinformation, and yet we know that government lawyers don't act on their own. They get direction. That direction came directly from Cabinet to the government lawyers on Principle 14 in this particular decision. So could the minister please clarify for Canadians the misinformation that the Liberal Party is now propagating that suggests that the misinformation is actually the failure to actually admit that the direction given to their own lawyers failed Canadians in this particular case?
The Honourable Minister for Crown Indigenous Relations.
Hear, hear.
Thank you, Mr. Speaker. I did want to mention litigation guideline number 14, which the Conservatives have referenced a number of times. I encourage them to read beyond the first sentence and to actually read the whole principle. If they do get to the second sentence, they'll see that all defenses are available. However, defenses must not be pleaded simply in the hope that through discoveries or investigations some basis for the defense may be found. We can only use defenses where there is a principled basis and evidence to support the decision. So, Mr. Speaker, we are in active litigation. We're continuing to review all viable legal arguments. However, when the speakers mention guideline number 14, I really encourage them to read beyond sentence number 1, get through the whole principle, and I also encourage the Conservatives to read the whole directive because I think it will enlighten them. But again, we are looking at all viable options in the appeal. Thank you, Mr. Speaker.
Hear, hear. Resuming debate, reprise débat. L'honorable député de...
The Honourable Member for Côte-Nord, Kaohachikamac, Nitassinan. Thank you very much, Mr. Speaker. I'm pleased to rise today on behalf of the Bloc Québécois on this Opposition Day. First off, Mr. Speaker, I'd like to start by mentioning this idea that I will be starting with. In a responsible sense and with a nuanced approach, I want to say this because I think it's for the benefit of Quebecers and Canadians to be well informed, because I feel that this opposition day, and again, I welcome the tabling of this motion on the part of the Conservatives to be able to discuss a subject which certainly could and can affect the lives of Quebecers and Canadians. And for this reason alone, the Bloc Québécois is in favor of the principle of the motion. And I say the principle behind it, which does not mean we agree with the wording of the motion as a whole. And in the context of my speech, I will be raising a number of issues. And despite the fact that I have 20 minutes, Mr. Speaker, I doubt I'll have an opportunity to complete my entire speech, which is in a way saying that this subject matter is broad, far-reaching, and should be the subject of further discussions. So from the start, if we say that we are in favor of the principle behind this motion, the reason why we do is because there is some legal uncertainty here. We agree with that. I've heard it in Quebec, and we've seen it in the rest of Canada, and it does require a government response. So that's undeniable. The reach of this decision, it is really an innovation in the sense that it is new, but it creates obligations that are quite real, quite tangible for governments, whether that be provincial governments, the federal government, in the process of recognition with Indigenous communities. And of course, we've been hearing this from the start of the day. This raises fundamental questions about property rights in Canada. Land, property, that of course affects everyone. So the Cowichan decision did bring about some uncertainty as to property rights, private property rights, and there needs to be a response. There have been some concerns, and as I was saying earlier to the minister, there is some work that needs to be done in terms of raising awareness, but of course, that's one aspect that needs to be addressed. Now, in the wording of the motion, it's not mentioned, but the right to property is unequal throughout the country. And I'll give you an example. In Quebec, for instance, we have a civil law tradition. So there is absolute and real rights to property, and in Canada, the definition is pursuant to fee simple property. A number of decisions have been rendered, and specifically Cowichan. This is essentially feudal English law that has led to the development of this Canadian legislation. Despite the fact that it's an attack on private property rights, it would warrant a concern on the part of everyone. And based on the motion, we have to take into consideration the legal specificities of each province and of Quebec. Just as a reminder, with respect to civil law, Quebec because of its civil law system and the Civil Code of Quebec, we view things different. But this particular decision is pursuant to the 1982, Section 35, Constitution Act 82, that recognizes and confirms Indigenous or Aboriginal title for Quebec. I'm not sure if it's useful to mention, but I will mention it again. Quebec did not sign on to the 1982 Constitution Act. So when we talk about the context and the specificity, legally speaking, that has to be considered. I wanted to say it. I wanted to remind my colleagues of this for future discussions, broader discussions. This is a factor. All of this means that there could be some issues here, and I certainly can't speak on behalf of BC, but I'm noticing the situation in Richmond and other parts of BC. The court voluntarily failed to discuss the the coexistence of ancestral or Aboriginal title and fee simple. So the issues of governance, taxation, validity of permits, all of this receive no answer. And to simplify, this is an issue that is complex. There are two forms of rights, the Aboriginal rights and the fee simple property rights that say, essentially, we are the owners of this land, of this property, if we're referring to, let's say, an individual's property. So it's as though, even though there are distinctions between the two, and without getting into the details of all of that, there is a property right. They both have this property right. So there's a coexistence of rights, but it's difficult to ensure absolute rights without there being a discussion on these details. And this is what people are concerned about. Could there be a hierarchy? There is none, but of course, there would be negotiations. And there are concerns because people do not know the ins and outs of all these matters. There would need to be a clear mechanism in place to dispel the issue of the validity of property rights. That's the most urgent question here. I think all colleagues have raised it. I wanted a little further down in my speech to raise the issue, but I'll do it now, the issue of the concerns in the public, people in BC. I've read a number of articles on this subject, and we're even noticing that the government itself, even the municipality of Richmond, will be providing information to the public, will be taking questions also. So there is a desire for other orders of government to take charge of this issue. And there are concerns and questions from people, individuals, and there's an effort to reassure people. So already the municipalities and the government of BC need to inform the public, and that shows to what extent there are some concerns and some questions regarding the Cowichan ruling. And these are questions that need to be answered. There is a process of negotiations underway. There needs to be a solution, and there doesn't seem to be one here. As a reminder to everyone, with respect to the history of the Cowichan decision, Cowichan v. Canada, and that is, shall we say, innovative, because it essentially creates a precedent which changes things for land claims that are underway and future land claims. For instance, the Aboriginal doctrine recognizes that Indigenous rights have not been extinguished. This is something we need to remember, not extinguished by the arrival of the Europeans. And there is a mechanism, there is jurisprudence, case law that explains or directs the decision pursuant to which there is title that is being inferred. So the sufficient occupation, continuous occupation, and exclusive occupation of the territory. That's what confirms Aboriginal title, and the Supreme Court confirms the exclusive right for Cowichan. The decision is lengthy, 836 or so pages. Less than a year ago, the Supreme Court found that, the Supreme Court of BC found that there was the demonstration of Aboriginal title, and that is beyond the current provincial system. So this indicates coexistence of two types of property rights at the same time. The Cowichan Nation intended to receive a statement, and there's also the issue of the right to fish. These are Indigenous rights. Some groups and governments stood against that. Canada, BC, the City of Richmond, and the Port Authority in Vancouver-Fraser, and two First Nations, the Sawatan and the Musqueam, were opposed to the request from the Cowichan.
The trial took 513 days and finally led to a decision which is largely based on the promise of the British governor back in 1853 And once again, Mr. Speaker, I would remind listeners that the court did not rule on how fee simple property and Aboriginal title can coexist. And because of this, some instability was introduced into the legal framework. It destabilized the Canadian private property regime, leading to certain concerns because, of course, people are afraid of the unknown, and that's what we're seeing here. To add on to the notion of fee simple property, because the Conservative motion doesn't talk about civil law, so I'm going to do a quick aside. I'm likely the only person who speaking today who will be able to talk about the distinctive character of Quebec. There are two types of law in Canada, common law and civil law. In Quebec, civil law governs property rights. In the rest of Canada, it is common law. But these two legal frameworks have vastly different ways that they define and protect property rights. Fee simple property does not exist in Quebec. Instead, we have something referred to as absolute property rights. These rights define property as the ability to freely use and exercise a piece of land. But there are other characteristics of property ownership in Quebec. Property ownership is absolute, exclusive, and eternal. Quebec is a registry setting out who owns what, and property rights must be respected by third parties. Things work slightly differently in English Canada. Fee simple property is a notion inherited directly from English common law. It is more exhaustive and goes a little bit farther than what we have in the civil law tradition. The theoretical underpinnings of fee simple property are different from the legal framework we have in Quebec. In English Canada, the fee simple property derives from the state. In theory, the Crown property is owned by the Crown at a certain level. Fee simple property rights can be cancelled or transferred in extenuating circumstances. The Crown holds Indigenous land in trust for Indigenous communities, as set out under the Indian Act. So, Mr. Speaker, if I still have a little bit of time, I would like to go a little bit farther because I've totally lost track of time. I hope I will have a moment to talk about project funding and residential properties. My colleagues are worried about this, especially in the official opposition. I should admit that the ruling, or really the interpretation of the ruling, in the Cowichan tribes case by the business sector and by the financial sector have already had a significant economic and political impact. This can be seen in the flurry of media coverage we've witnessed in French and English all throughout Canada. We need to remember that despite all of this, there has been no actual evidence-based analysis showing a general measurable effect on property values. Now, I'm not saying this effect does not exist. I'm just saying that we lack the data to prove it. This is an issue of importance to all Quebecers and Canadians. Everyone really ought to understand the impact of this decision. We shouldn't just be going based off instincts and anecdotes. My colleagues have brought up some anecdotal evidence, but what we really need is data, because such data would feed our debates and our considerations as parliamentarians. Legal experts have pointed to the fact that people's perceptions of what is going on have a considerable sway. People have strong perceptions about the Cowichan case. And the fact that market actors are responding has had an effect on property values and property rights in the area in question. There's a certain amount of legal instability, legal uncertainty, and this could lead to there's a distant possibility of future restrictions on the use of land, different ways to manage the land. This decision could also affect governance. Some people have noted that even though there has been no observable decline in property values, there might be an impact on how easy or how difficult it is for people to sell their land in the area concerned. There's been a decline in confidence. This could be described as a legal shock, a legal upset. And this can have an effect on assessments of land value. Some colleagues have also mentioned that people are having more difficulty getting loans due to this decision. I read this in a number of articles as well, so the federal government needs to step in and take steps to remedy that situation. I'm getting ahead of myself, so I'll circle back to what I was saying earlier. The mere fact of this uncertainty and the need for additional information will increase the cost of due diligence in the real estate market, and this could lead to a chilling effect in real estate. It might make it more difficult to obtain funding, obtain financing, obtain loans. So there will be a direct impact. I've been talking about Cowichan so far, but the Musqueam rights agreements is also brought up in this motion, and I could also touch on the Wolastoqey decision in New Brunswick, which has a certain resemblance with the situation we are seeing in British Columbia. All of these cases lead to resemble one another. They are not the exact same as one another. There's nuances there, but they have certain similarities, and they share this notion of uncertainty. We don't know exactly where things are heading, and there is certain uncertainty. I know that I'm almost used up my speaking time, and so I will not have time to go into all elements of the Conservative motion in detail. I would say we agree with it in principle. We would suggest amending it in certain places. I would say in good faith that this is a subject that could be brought up in committee, for example, at the Indigenous and Northern Affairs Committee. I would disagree with the need for a whole special committee to study the issue, but in general, I agree with the motion in principle. Questions and comments? The Honourable Minister of Crown Indigenous Relations. Thank you, Mr. Speaker. I would like to thank my colleague for her speech. I have a question regarding Section 92 of the decision. It's true that private property is an area under provincial jurisdiction. British Columbia is currently backstopping properties, so my question for the member is as follows. Could she explain the importance of the federal and provincial governments respecting each other's areas of jurisdiction? The Honourable Member for Côte-Nord, Kawachikamach-Natassinen. Thank you, Mr. Speaker. I would like to thank my colleague, the Honourable Minister, for her question. I didn't expect to be talking about areas of jurisdiction, even though it is a favourite topic here in the Bloc Québécois. It is, of course, important for governments to respect each other's areas of jurisdiction. I spoke a little bit about Quebec and our unique civil law tradition. Quebec is also in a distinct position because we still have not signed the Constitution, creating a bit of a legal void here in Quebec. I expect everyone to fulfill their duties in a spirit of dialogue and total transparency. Thank you.
Paul Burton, Kawartha Lakes.
Thank you very much, Mr. Speaker, and I appreciate the speech from my Bloc counterpart. And while I do usually get along and agree with a lot of what she has to say, especially in the Indigenous Northern Affairs Committee, I do disagree with some of what she said in her speech, particularly around perception. And I read to you, Speaker, this headline from Global News dated December 11th, 2025. Cowichan case blamed for sinking British Columbia property deals, including luxury hotel purchase. And that was a few $1 million. My member next to me here has another one, a $15 million hotel project and development canceled as well. I have personally met with people within the city of Richmond affected by this decision that would like to move for a variety of reasons, job opportunities, etc., that have seen their property values go down a lot further than the market is declined in other parts of the province. So there is some real impacts because the government did not do their job. But the question I'd ask to the member opposite, regarding committee, if she knows, if she recalls, there is a notice of motion on committee that we have been told that there was no chance of it being debated because the Liberals disagree with it.
The Honourable Member for Côte-Nord, Kawachikamach-Natassinen. Thank you, Mr. Speaker. So my colleague brought up two separate questions. The first had to do with the real impacts of the decision. And I'm not sure whether my colleague overlooked the part of my speech where I noted that there were real impacts. I am aware of these impacts. I've read about them. The only thing is there has not been a rigorous study yielding concrete evidence about the situation. I would like there to be one because this is an issue of importance to everyone, and I think such a data would feed our discussions. The second thing, as for the second point, is that my colleague might not have been, actually, I shouldn't say that. He might have been there but not paying attention. When I noted that this topic did not come to a vote in committee, the committee has not taken up this topic. I did mention this, and I do agree with the principle of the Conservatives' motion. I'd be happy to have a discussion about this. The government might not be willing to talk, but I'm sure my colleague will be. The Honourable Member for La Pointe-de-Lille. Thank you, Mr. Speaker, and I would first like to commend my colleague for her excellent speech. She was able to share her in-depth knowledge of the issue. There's a question about why this was not brought up in committee. We know that the government we are told that the government shot it down. Could my colleague speak a little bit more about how we would like to amend the Conservative motion, especially the part having to do with the proposed committee? The Honourable Member for Côte-Nord, Kawachikamach-Natassinen. Thank you, Mr. Speaker, and I would like to thank my colleague for La Pointe-de-Lille for his question. We always try to be responsible and rigorous. There have been calls for a committee study. But that study cannot be done quickly. This issue will take time to understand. Consultations will need to be held. Reflections will need to be done. I brought up the Conservative proposal of a special committee. I think it's worth asking what a special committee would be able to do that the Indigenous and Northern Affairs Committee is not currently capable of doing. That said, I'd be willing to discuss. These are just some reflections I have, because at the end of the day, we want the debate to be productive and we do not want it to be subsumed by partisanship. Questions and comments? The Honourable Minister of Crown Indigenous Relations. Thank you, Mr. Speaker. We are currently in the middle of a court appeal. Here's my question for my colleague. Do you think that the risk of Parliament influencing a court decision could blur the line between political debates on one hand and an independent judiciary on the other? The Honourable Member for Cote Nord, Kawawa-Chikamache, Nitassinan. That is a great question. We absolutely do not want to blur the line between the legislature and the judiciary. That said, I think the public has a number of questions they would like answers to. That's why I spoke about the need for more information. People have legitimate concerns, and certainly the federal government shouldn't meddle in a legal debate, but these are issues that impact all Quebecers and all Canadians, including First Nations. I think we should be able to have healthy debates here in the House about issues of national importance. The Honourable Member.
I thank my colleague from Quebec for her enlightening speech and explaining the difference between fee simple coming from British feudal law and absolute title coming from continental civil law. So it's very enlightening, but the same question still applies. Does this member think that absolute title, as the translation team called it, and Aboriginal title can coexist on the same piece of land at the same time, or is that an unreconcilable conflict?
The Honourable Member for Cote Nord, Kawawa-Chikamache, Nitassinan. Thank you, Mr. Speaker. Here, I would not want to get ahead of the courts. As I said a few times, that is the question under debate. How can these two types of ownership coexist? If I read between the lines of the New Brunswick court decision, I get the sense that these two types of ownership cannot coexist. However, in the Cowichan case, the courts have said that they can coexist. The only thing is, we don't know how they can coexist, so there's some concerns. There will need to be negotiations, maybe on a case-by-case basis, and all of this brings up a certain amount of uncertainty. I would not want to speak on behalf of the judiciary, but I think it is worth asking these questions, asking how these two types of ownership can coexist, and what sorts of solutions we would be able to come up with. There's all sorts of discussions to be had, and that's why the motion is so relevant. The Honourable Minister. Thank you, Mr. Speaker. Could the member speak about the importance of clarity and legal predictability in this affair? And could she speak to whether this motion provides such clarity? The Honourable Member for Cote Nord, Kawawa-Chikamache, Nitassinan. Thank you, Mr. Speaker. Not to repeat myself a third time, but here in the Bloc Québécois, we believe in rigorous debate. I have noted that I support the motion in principle, but not in its exact wording.
Please débat, the Honourable Member for Kamloops, Shuswap, Central Rockies.
Thank you, Mr. Speaker, and I will be splitting my time with the member from Cowichan, Malahat, Langford. Mr. Speaker, it is always an honor to rise as the elected representative of Kamloops, Shuswap, Central Rockies, and as I have previously stated in this place, all of us have a solemn responsibility to provide representation and voice to those citizens that depend on us to do their bidding here in Parliament. Canadians need us to be vigilant for challenges and dangers that emerge and take actions to prevent, mitigate, and overcome the challenges and dangers, including unintended consequences caused by actions or inaction of levels of government. In these times of global uncertainty, Canadians need our vigilance and action perhaps more than any other time. Today, I rise to speak to today's Conservative Opposition Day motion, and this motion opens with how the Cowichan Tribes versus Canada decision has created massive uncertainty around fee simple property, not just in Richmond, BC, where the land relevant to the case is located, but across my home province of British Columbia and other parts of Canada. All this because the legal basis on which Canadians and businesses alike own their homes and land, the basis on which economies are built, the basis that has provided the general stability for growth, investment, surety, and prosperity has been undermined. Certainty of fee simple property has been undermined, and with it, the stability and security of every property owner in BC and beyond. Mr. Speaker, I believe all of us in this House are proud to call Canada home, while we also recognize historical imperfections, chapters of our shared history in which forebears, including the federal government, failed. It is important to recognize and learn from historical failures. It helps our nation strengthen. And so too does recognizing our historical successes, reflected by the facts that our ancestors and predecessors built a country that others around the globe have admired because they have seen the opportunities that flowed from our stability and certainty. However, the sharp decline in certainty in the wake of the Cowichan decision has caused instability, directly harming opportunities for Canadians, while also putting a chill on those who would otherwise invest in Canada. If others look at Canada to see internal turmoil and conflict rather than stability, they will go elsewhere to pursue opportunities. Instability and insecurity reflect on Parliament, and all parliamentarians should reflect on how we can increase stability and security for citizens both today and far into the future. Mr. Speaker, the Cowichan decision is already having significant impact on the outlooks of citizens. Home values and the projected financing, not just in the immediate area around Richmond, but across BC, have been impacted. When I am at home and meeting with people at events and on the streets across Kamloops, Shuswap, Central Rockies riding, people are coming up to me and asking if their future and if their title to their property that they have worked a lifetime to pay for is at risk. Instability caused by the Cowichan decision was compounded when the Liberals negotiated the Musqueam Rights Recognition Agreement in secret without ensuring it contained protections for property rights, without ensuring proper transparency or consultation with other potentially affected First Nations. The Musqueam Agreement covers up to 533,000 hectares, including Metro Vancouver and the Richmond lands that are at the center of the Cowichan ruling. Canadians are questioning, questions that the Liberal government will not answer. When the Prime Minister stated that all federal agreements with First Nations, with Indigenous peoples, and with rights holders protect private property rights and protect Indigenous rights, did he know that this is not the case? The Musqueam Rights Recognition Agreement only contains the word private once, and not in reference to private property. The Musqueam Stewardship and Marine Agreement does not contain the words private or property. The Musqueam Fisheries Agreement does not mention the word private or property. The agreement that provides the Musqueam with revenues from the Vancouver Airport does not contain the word private or property. None of these agreements signed by the Liberal governments protect private property rights as the Prime Minister tried to claim they do. So either the Prime Minister has no idea what's in these agreements, or he has been misleading Canadians. If we are to have true reconciliation in Canada, I believe we also must have truth. Mr. Speaker, when we have a Prime Minister that either does not know or does not care what agreements his government is signing, or is willing to mislead Canadians on what is in those secretly negotiated agreements, it is no wonder the Canadians have questions of us that they have elected to be their representatives and voice. Mr. Speaker, Canadians already face enough pressure from high costs and economic uncertainty without having to wonder whether their homes are truly theirs. This Liberal government must provide that certainty and stability by openly reaffirming private property in court. And they must make it clear in writing that Canadians' homes and land titles will be protected. Thus far, they have failed to do this. And as Conservatives, we have urged the federal government to reinstate the arguments before the Court of Appeal that fee simple land ownership supersedes all other titles, and call on the government to take the following steps to protect property rights. Step 1 would be to put private property first in the Cowichan case by arguing that this has priority over all other titles and reversing the current position directing federal lawyers not to argue for property rights and the withdrawal of the extinguishment argument from the earlier 2018 decision. Step 2 would make no agreement without explicit property protection, so that existing fee simple owners are protected in all future agreements with First Nations, reversing the government's failure to explicitly protect people's homes in the agreements the Carney Liberal government, the agreements the Liberal government signed that failed to explicitly protect fee simple property ownership, causing confusion, fear, and risk, instability, and uncertainty. At a time in global history when we're all seeing so much instability and uncertainty, this is a time when Canada could be a shining example in which all Canadians, regardless of ancestry, could have a sense of certainty and stability that others used to see in us. But we cannot restore certainty and stability through secretly negotiated agreements. I've always believed that bringing everyone to the same table allows us to fully understand each other's perspective. Failing to do so only brings speculation, skepticism, and distrust. If we are to build trust and respect, we need this government to respect all Canadians and restore confidence for homeowners across British Columbia and Canada by convening a parliamentary committee to study all legal, constitutional, and political steps that can protect private property rights in Canada in light of the Cowichan decision and the Musqueam Agreement. In this way, the government can begin restoring trust, the trust that is required to move forward with the transparency, balance, stability, and certainty that Canada once had. Thank you, Mr. Speaker.
Questions and comments. Gets the commentary. The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. One part of the motion, Part C, calls on the government to make no agreement without explicit property protections so that fee simple property owners are enshrined in all future agreements with First Nations.
That's right.
However, agreements relate to education, health, policing, and so my question to the member is, we don't reference private properties there. Is the Conservatives proposing that we include that the health transfer for the government of British Columbia, any type of provincial also? Why Why is it limited to First Nations, Mr. Speaker?
And before we go to the response or point of order, the Chief Opposition Whip.
Yeah, thank you, Mr. Speaker. I'd like to give notice that under Standing Order 43-2A that all remaining Conservative caucus speaking slots will be divided into two.
So noted. The honourable member for Kamloops Shuswap, Central Rockies.
Thank you, Mr. Speaker, and I thank the minister for her question. But I want to again quote what the Prime Minister stated earlier this week in this House. He stated that all federal agreements with First Nations, with Indigenous peoples, and with rights holders protect private property rights and protect Indigenous peoples' rights. When I checked those agreements this morning, as I stated, the Musqueam Agreement does not mention the word private property. None of those agreements mention private property. So was the Prime Minister misleading the House, or was he ill-informed?
Questions and comments. Question et commentaire. L'honorable député.
The honourable member for La Pointe de l'Île. Earlier, I asked a question about why not have this debate at the Indigenous Affairs Committee. I was told that that request was refused. My colleague who participates on the committee said that that's not true to her knowledge, that the motion for the study had simply been tabled. There was a committee meeting this morning and the debate wasn't relaunched, so I'd like to know if the Conservatives, if the government were to agree that it be studied at committee, would the Conservatives be prepared to have this studied in committee instead of at a special committee?
The honourable member for Kamloops Shuswap, Central Rockies.
Well, thank you, Mr. Speaker, and I thank the member from the bloc for asking the question about whether this could be studied at the Indigenous Affairs Committee. With the regime that the current power-brokered Liberal government has now installed at committees with their majority there, shuttering committees when any question as to their integrity, the government's integrity, gets shut down, turned in camera, and voted against by majority Liberal membership on these committees, I don't trust this Liberal government to allow any of this discussion to take place at committee.
Hear, hear.
Questions and comments. The honourable member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker, and I thank my colleague for his excellent intervention. You mentioned the term secret agreement. Could you tell me the risks and explore some of the risks of secret agreements done behind closed doors and the effect on transparency, as opposed to court-established or a treaty process that's established through the courts that is open and transparent? Thank you.
And just remind the honourable member to address comments through the chair. The honourable member.
Thank you, and I thank the member from Cowichan, Malahat Langford for the question. I think he was referring to the risks of secret agreements. Could I expand on those risks? Well, because those agreements are secret, we haven't seen them. We don't know what the risks are in these secret agreements. I've been party to this or privy to this through my work on over 10 years on the Fisheries Committee, where agreements are signed with organizations around the country, secret agreements that, due to the rules that were put in place by the Liberal government in the previous changes to the Fisheries Act, the information in those agreements cannot be made public. It's hidden behind closed doors, so the risks are absolutely unknown.
Resuming debate. Reprise du débat. The honourable member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker. I rise today on behalf of the great people of Vancouver Island, and especially all the seniors and families, workers, businesses, and perhaps most importantly, the youth of Cowichan, Malahat, Langford. Our communities stretch from Langford to Crofton, Thetis Island to Lake Cowichan to Port Renfrew, and across the beautiful Cowichan Valley, home to numerous First Nations, including Cowichan Tribes, the largest First Nation in British Columbia. We are a people who love where we live. We are people who take pride in our homes, our neighborhoods, and our future. We are rooted in the lands, the rivers, the forests, the mountains, and of course, the ocean. They're all integral parts of our soul. And today, Mr. Speaker, we are all worried. The Cowichan land decision has created uncertainty and division that no community, Indigenous or non-Indigenous, should ever have to face, be it on the island or across British Columbia. Home values are falling, falling, banks are refusing mortgages, sales have stalled, businesses are looking elsewhere or moving away, and anger and division is building. People are lashing out at one another. This is heartbreaking and it is unacceptable. And the Liberal government has offered nothing. No clarity, no plan, and no leadership. Mr. Speaker, the language in the Cowichan ruling describes Aboriginal title as a prior and senior right to land, effectively creating a groundbreaking precedence, putting Aboriginal title above fee simple title. In other words, all privately held and Crown land at risk. This has now created real fear whether private property rights will still hold weight across British Columbia and indeed across Canada. These are not abstract legal questions, however. They are conversations happening every night in Duncan and Langford and Shawnigan, Mill Bay, and within the Cowichan tribes. Parents are asking whether their home, their single greatest asset, is still secure. Seniors are wondering whether they can afford to retire, and young families questioning whether they can stay on Vancouver Island at all. Our youth are wondering what Canada will look like in the future. And our First Nations are seeing reconciliation sentiment taking a major step backwards. And through all of this, the Prime Minister has remained silent. Instead of leadership, we have his Litigation Directive number 14 that forbids federal government lawyers from defending private property rights. A directive that tied their hands in British Columbia Appeals Court and will now automatically tie their hands again, this time in Supreme Court of Canada going forward. This is not reconciliation. This is abandonment of all Canadians. And it is deepening division, anger, and stress among neighbors, friends, and families, exactly the opposite of what reconciliation should bring. Mr. Speaker, British Columbia deserves better, Vancouver Island deserves better, and Cowichan tribes deserve better. Reconciliation cannot be built on secretly negotiated agreements or confusion. It cannot come at the expense of homeowners or the very stability of our economy or the core of our country. For decades, we've had Made in Canada approach that balanced Indigenous rights with the needs of society as a whole through an established treaty process. Section 35 of our Constitution recognized and affirmed these rights. It created a framework that brought stability and prosperity. It's not perfect, but it worked. And now this Liberal government has walked away from that. They have leaned on a United Nations declaration, an unelected body, that is not Canadian, not part of our legal system, not binding, and was never intended to override private property rights. Yet the Liberals are using UNDRIP as if it does. And when they signed the Rights Recognition Agreement with the Musqueam, not a treaty through the court system, but a closed-door, secretly negotiated agreement that failed to explicitly protect fee simple or private property owners, neglected to even mention it, and an agreement that awarded the Musqueam Aboriginal land title over the majority of Greater Vancouver, including lands previously awarded to Cowichan tribes in Richmond, BC. They created a conflict between two separate Aboriginal titles. In fact, almost all of British Columbia is potentially under overlapping Aboriginal land claims, with the Cowichan decision setting the precedent that Aboriginal title is superior to private property and Crown title. British Columbia is in a mess. And that precedence has now rippled across Vancouver Island, creating confusion and fear from Langford to Ladysmith and across British Columbia. This is not reconciliation. This is recklessness. So today I'm calling on the Prime Minister to act clearly, publicly, and immediately. Our Conservative plan has 4 straightforward pillars. First, put private property rights first in the Cowichan case. Restore the extinguishment agreement the Liberals abandoned in 2018. No one should ever have to wonder whether their home is truly their home. Second, make a no agreement, none, without explicit protection for all existing fee simple owners. The Sequent-Musqueam agreement failed to do this. The Prime Minister must correct this mistake and guarantee that all future agreements protect people's homes. And third, publish a plan within 30 days to protect Canadians affected by the Cowichan decision in the Musqueam agreement. Not a press conference, not a promise, not an MOU, a real plan with timelines and commitments delivered personally by the Prime Minister. Finally, convene a special parliamentary committee to examine every legal, constitutional, and political tool available to protect private property rights across Canada. Mr. Speaker, this crisis is not limited to the Cowichan Valley. It has spread across Vancouver Island, across Richmond and British Columbia, and it will soon spread across Canada. If we do nothing, we will leave future generations with a fractured legal landscape and a broken economy. But there is a better path, one that respects Indigenous rights and private homeowners. And we see that path in our Conservative platform. It is practical economic reconciliation. It will put First Nations back in control of their own revenues. It reduces bureaucracy and government controls. It strengthens local economies, including on Vancouver Island. And it brings First Nations into the Federation as full partners, not wards of the state. First Nation chiefs from across the country and across British Columbia have said the same thing. They want less Ottawa. They want more autonomy. And they want to build prosperity for their people. And Conservatives agree. Mr. Speaker, reconciliation must be built on partnership, not secrecy. On clarity, not confusion. On respect, not fear. And on truth, not misinformation. The Truth and Reconciliation Commission called for both truth and reconciliation. The Prime Minister has failed to deliver either. The great people across Cowichan, Malahat, Langford deserve a government that protects their homes and their future. Cowichan tribes deserves a government that respects their jurisdiction and supports their economic independence. And Canada deserves a government that understands that reconciliation and private property rights are not competing ideas. They are both essential to a stable and united Canada. The Prime Minister has a choice. He can continue down a path of silence and uncertainty, or he can act clearly, transparently, and responsibility to restore confidence in our legal system and protect rights of every Canadian. My community is watching, Cowichan Tribes is watching, Vancouver Island is watching, and we are waiting. It is time for the Prime Minister to show leadership. Thank you, Mr. Speaker.
Hear, hear. Siang commentary. The Honourable Parliamentary Secretary, the Minister of Emergency Management.
Thank you, Mr. Speaker. Mr. Speaker, the Prime Minister did speak very clearly in this House, making very clear that this government was going to defend private property rights. The government immediately appealed the decision. I guess my question to the honourable member, whose speech I just listened to and felt that there was multiple times where it sunk into disinformation, was how does the honourable member believe that a parliamentary committee will develop arguments for the court that are better than the expert constitutional lawyers who are currently arguing on behalf of the Government of Canada and being instructed to use every type of argument to defend property rights?
Member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker. Speaking of disinformation, the member opposite claims that the Prime Minister has defended this, but he fails continually to disclose that he's already tied the hands of the government lawyers with the extinguishment article. And he speaks of filed immediately. In fact, the Supreme Court filing was done on the last day at the very last minute. So that is more misinformation. Conservatives are calling for real truth and real reconciliation and real honesty. Thank you, Mr. Speaker.
Questions and comments. Question commentary. The Honourable Member for Prince George, Peace River, Northern Rockies.
Thank you, Mr. Speaker, and thanks to my colleague from Vancouver Island for his speech today. Just an article from Business in Vancouver. Councillor says $100 million project denied loan over Cowichan case. Bank says not a factor. And then also goes on to say, Richmond, BC councillor says a company based in The city has been refused financing for what she says is a $100 million project because of uncertainty over their site due to Cowichan Tribe's Aboriginal title ruling. And we're seeing, conflicting things. We're hearing the government say, look, it's no big deal here. Other people are saying it's no big deal here. But that's what's happening, the reality on the ground. And I guess despite the empty words from this Prime Minister and this Minister, the member from Vancouver Island, what are the genuine fears that you're hearing from your own members in your own community on the ground?
And again, through the chair, the honourable member for Cowichan Malahat Langford.
Thank you, Mr. Chair, and I thank my colleague for his question, and I really agree with his statement about empty promises and empty words. People are worried about the values of their property. They're worried about getting mortgages, and in fact, it's so bad that the provincial NDP government is now having to back mortgages in affected areas. And they can only do that for a small area. That's something they're going to have to do for the entire province. People are worried. Property assessments are now coming with waivers saying the property value only stands so long as it isn't superseded by Aboriginal title. So people in my riding of Cowichan Malahat Langford are facing real concerns, and they're facing increased racism, they're increasing anger. And this is all coming at tough economic times on top of that as well. So there are very valid reasons for concern, and we are seeing it across Vancouver Island and British Columbia. Thank you, Mr. Speaker.
Yes, Your Honour. Commentary. Questions and comments of the Honourable Parliamentary Secretary, the Minister of AI.
Thank you, Mr. Speaker. I note in the member opposite's comments that he expressed that somehow these Musqueam agreements were secret. If he would like, I'm more than happy to share with him the links online where they are available to the public. He also spoke about the need for true reconciliation, which he alleges his party believes in. Does that strategy of true reconciliation also including condemning the comments of the member from North Island, Powell River, who said that Indigenous people asked for residential schools and that there was no Indigenous genocide?
Yeah, member for Cowichan Malahat Langford.
Thank you, Mr. Speaker. I appreciate the question. My comments said secretly negotiated. The Musqueam Agreement was negotiated behind closed doors. Even the Premier of British Columbia claimed he did not know about it until the actual signing. That is secrecy, that is transparency, and that is how this government is failing our country. As far as the comments, I have not heard those comments, and I'm not in a position to comment on them. Thank you.
Resuming debate. Reprise débat, the Honourable Parliamentary Secretary, the Minister of Artificial Intelligence and Digital Government.
Thank you, Mr. Speaker, and I'll be sharing my time with the member from South Surrey, White Rock. Mr. Speaker, I rise this afternoon to speak about a court decision that has caused real worry in my province and to speak directly to the Canadians, particularly British Columbians, who have been watching this debate and wondering what it means for them and for their homes. Let's begin with the facts, because the facts have been in short supply in this debate by members opposite. The fact is that this government has fundamentally disagreed with and fundamentally disagrees with, continues to, the British Columbia Supreme Court's decision in Cowichan. The fact is we appealed that decision on September 8th of last year. The fact is that the Prime Minister of Canada has stood in this House and stated clearly to all that would listen that private property rights are fundamental, that this government will protect them, and that federal agreements, including agreements about Aboriginal title, have always protected and will always protect private property. These are the facts. They are on the record. They are not in dispute except by those who find facts inconvenient to the story that they would prefer to tell. A story which leads to mistrust, anti-Indigenous racism, perhaps most importantly, to instability in British Columbia's economy. Mr. Speaker, I want to speak directly to the homeowner in Richmond who read a headline and felt their stomach drop. I want to speak to the family in my riding of Vancouver Granville who has spent 20 years paying down a mortgage and is now wondering whether the ground beneath their home is as solid as they believed it to be. I want to speak to the small business owner who has been asking their bank for financing and getting questions that they have never been asked before. These concerns are legitimate. A home is the largest investment most Canadians will ever make. When a court raises questions about the relationship between Aboriginal title and fee simple ownership, people are right to ask for clarity. They deserve a serious answer, not a slogan or a soundbite. So allow me, if you would, Mr. Chair, to give them one. 3 principles guide this government's response to the Cowichan decision. First, we believe in the security of private property. Canadians who hold title to their homes and their land must be able to rely on that title. This should not be a partisan position. It is the foundation on which families plan their future, on which businesses make investments, and on which our economy functions. Second, we believe in the principles of reconciliation. Reconciliation is not a slogan. It is not an obstacle to be managed. It is a constitutional and moral obligation that this country has been working through for generations, and that we continue that work patiently, lawfully, and in good faith. Third, we believe in building shared prosperity. Prosperity for homeowners, for workers, for businesses. Prosperity for Indigenous communities who have for too long been excluded from the economic life of this country. These are not competing goods, Mr. Speaker. They are connected goods. And I want to be honest with this House and with the Canadians watching. The legal questions raised in the Cowichan decision are genuinely complex, and the clarity that Canadians deserve is going to come from where it should come from in our system, from the courts, on appeal, with all viable arguments tested and all parties heard. That process is underway. It will take time, and none of us should stand in this place and pretend otherwise, because Canadians deserve, as I said before, a serious answer, not a slogan. They deserve facts, not fear-mongering. The Conservative motion before this House asks Canadians to choose between the first principle and the second. It asks them to believe that property rights and reconciliation cannot exist in harmony. This is false, and it has always been false. And the people advancing that false choice know that it is false. Let me say something very clearly, Mr. Speaker. The legal questions we are working through in Cowichan are not questions that Indigenous peoples created. They are the products of decisions made by the Crown over generations in a province where most of the land was never covered by treaty. The Crown made those decisions. The Crown bears responsibility to resolve them, and no responsible government should allow any ordinary homeowner to be made afraid or Indigenous peoples to be scapegoated while that work is carried out. Because here is what is being missed in the noise. Almost every party to this litigation has gone to the Court of Appeal. The Government of Canada is appealing. The Province of British Columbia is appealing. The City of Richmond is appealing. Musqueam is appealing. Chief Wayne Sparrow has spoken publicly about Musqueam's deep concern with a decision that declared Aboriginal title in what they assert is their own traditional territory. Tawasin First Nation is appealing alongside Musqueam on similar grounds. The Cowichan themselves are appealing on different grounds. This is not the picture of settled judgment. This is the picture of a decision that has satisfied almost no one, that produced a clarity that almost no one was looking for, and is now being worked through by our courts exactly as our system is designed to handle it. This is also not the story of homeowners on one side and Indigenous peoples on the other. It is the story of a serious country with a serious legal system doing serious work, including First Nations, who are themselves using that very system to seek the clarity that each and every one of us need and deserve. That, Mr. Speaker, is the story that members opposite are refusing to tell, because it does not serve a political agenda. Mr. Speaker, the cost of that political agenda, of this misinformation, is real and is being paid right now in the province of British Columbia, in my home province. Just yesterday, the Business Council of British Columbia released a survey of its members. 74% of respondents are decreasing investment plans in BC. One in three are reducing hiring. 41% report harder access to external financing. And 80% of these, let me say clearly, 80% of those same business leaders say they continue to support reconciliation as an important goal. So why are they reducing those investments? They're reducing those investments, Mr. Speaker, because of misinformation and uncertainty that is being spurred on by people that would like to use the Cowichan decision as a political cudgel. And in this House, in this Parliament, Mr. Speaker, we must ensure that that does not continue for the security of the economy in British Columbia and for preservation of the principle of true reconciliation. Now, Mr. Speaker, the people that are supporting reconciliation are very, very clear. This is a business community that is pro-reconciliation and it is exhausted by uncertainty. They aren't asking us to choose. They are asking us to lead. And the damage is not abstract, Mr. Speaker. Homes are not being built. Jobs are not being created. There are workers waiting for projects that have been paused while financing is renegotiated. There are businesses across BC that are delaying decisions, holding back on investment, watching the noise around this case, created by politicians, not by the courts, and concluding that the cost of moving forward is too uncertain to bear. That's what irresponsibility looks like in practice, and it is being done deliberately for the political gain of the party opposite. Mr. Speaker, the seriousness of this moment is not lost on the political leadership of British Columbia. The Premier of BC has spoken at length about the impact of legal uncertainty on his province. Mayors have spoken. The City of Richmond is in court. There is broad cross-partisan recognition in BC, not from one party, not from one ideology, but across the political spectrum of my province, that resolving this matters and that the work cannot wait. The only people that seem to disagree are the Conservative members opposite, who have decided that uncertainty and a parliamentary committee is more useful to them than actual resolution of the problem. The Conservatives know exactly what they are doing. They know that the Cowichan decision is under appeal. They know that the Government of Canada, the Province of BC, the City of Richmond, Musqueam, Tawasin First Nation have all gone to the Court of Appeal precisely because the legal questions need to be resolved. And they know that the Prime Minister has committed clearly and repeatedly that this government will defend private property rights. They know the historical record across this country is that modern treaties and negotiated agreements have always protected private property. Not one Canadian has lost their private property as a result of a negotiated agreement. Not one. They know this, and they are choosing every day to tell their constituents the opposite, because fear is more politically useful, Mr. Speaker, than the truth. It's not leadership, it's a calculation. And the people paying for that calculation are the homeowners that they claim to defend. Mr. Speaker, I want to close with a story about what is possible when we get this right. This Friday, in my riding of Vancouver-Granville, I will be at the blessing ceremony of the opening of Sanok. Sanok sits in Squamish territory at the foot of the Burrard Bridge, where it has always been, in the land, in the stories, in the people. What is new is what is being built there. 6,000 rental homes in a city desperately in need of them. This is true reconciliation, where rents to 30% below market are being provided by the Squamish Nation in partnership with the Government of Canada. The Squamish Nation is moving towards economic independence and helping Vancouver provide the housing that it needs. Property rights respected, Indigenous rights honored, homes built, jobs created for the Squamish Nation, prosperity, and for the city that I represent, 6,000 families able to call Sanok home. That is reconciliation, Mr. Speaker. That is prosperity, and that is what is possible when we refuse the false choice being put upon us by the opposition. And that is happening in real time, Mr. Speaker, in my riding. So let me say this in closing. To the homeowners in my riding and across BC who have been worried, the government has appealed the Cowichan decision. We are advancing every legally viable argument to defend the security of fee simple. We have been clear from the Prime Minister on down that protecting private property is fundamental to who we are in this country, Mr. Speaker, and we will always stand for that. Thank you.
Member for Medicine Hat, Cardston Warner.
Speaker, and thank you to my friend across the way for his speech. Despite the Liberal rhetoric, we know that the property values in the area impacted by this decision are having a significant impact on the homeowners. And I'm just kind of curious if our friend across the way could answer how this decision is impacting his house flipping business.
The Honourable Parliamentary Secretary, the Minister of Artificial Intelligence.
I want to thank the member opposite for yet again, and like his colleagues, making light of what is a very serious situation for folks in Vancouver and across British Columbia. There are people who listen to the debates in this Parliament and expect serious discussion and serious debate. What they hear, Mr. Speaker, is misinformation. They hear misinformation, which leads to market uncertainty. Market uncertainty leads to builders not wanting to build affordable homes and jobs not being created. They should be ashamed of themselves, and they should be asking themselves what they tell their constituents when their constituents ask them, is the government going to stand for property rights or not, when the answer is yes.
Question commentaire. Questions, comments. Member for Mount Royal.
For an excellent speech. Mr. Chair, Mr. Chair, my question, or Mr. Speaker, my question relates to Litigation Directive 14 that I've heard a lot, again, of misinformation about, claiming that somehow that this directive would preclude counsel for the Crown, for the Government of Canada, from making every argument necessary to defend property rights. My understanding is all that the directive does is, if I can find the right words, it requires a principled basis in evidence to support the defense. Can my honourable colleague ever tell me of any instance where the Government of Canada should advance an argument that doesn't meet that criteria?
Parliament Secretary, the Minister of AI.
I think the simple answer is no, and I would actually invite members opposite to read beyond the first line of the Directive 14, because they would see that there's substantial depth there. They just need to choose to look at the facts, Mr. Speaker, and I know my honourable friend here, who is a lawyer in his own right, has read the entirety of the decision and would understand why it is that you actually have to look at this and read the whole thing, not just headlines.
Questions and comments? I'm a member for Cowichan, Malahat, Langford.
Thank you, Mr. Speaker. The member opposite spends more time blaming Conservatives for their own failures than proposing realistic solutions in his address today. Typical desperate Liberal tactic. The member stated they will vigorously defend private property with every viable argument. Notice, however, that he could not say every argument because he knows full well that the government lawyers' hands are tied behind their backs. They cannot use the extinguishment argument in court. So what is the Liberals' plan to vigorously defend it when their hands are tied behind their back and they cannot even address private title, private property without the extinguishment argument? Thank you, Mr. Speaker.
Honourable Parliamentary Secretary.
I'm so pleased that the member opposite chooses to hang his entire argument on the word viable. I mean, the whole premise of our legal system is based on viable argument. The fact that we make arguments that can stand up in court, that we win or lose decisions on the basis of the quality of our arguments and the understanding of the law. So I would invite the member opposite to look at the agreements with Musqueam that he claims were done in secret, to understand the Cowichan decision, to understand the basis of the appeals, and what he would see is a government that is vigorously defending private property rights and doing the absolute work that is required to run this through the systems which are designed by our Constitution, which are the courts.
Questions and comments? The Honourable Member for Winnipeg North.
Thank you, Mr. Speaker. You know, I have had a good discussion with the member from Vancouver Quadra, and the concern that he raised, and I fully agree with him on this, is the attempt by the Conservative Party and the damage it does with the issue of things like reconciliation between Indigenous people and Canada. And there's a very negative side to what it is that the Conservatives are putting on the table. And I'm wondering if he could provide his thoughts and concerns in regards to the damage that's done because of misleading information at a time in which we should be actually encouraging and promoting reconciliation.
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. And it's sad that we have to rise in this House to even address this issue, but I suppose when you're dealing with an opposition party whose leader once said that Indigenous people needed a better work ethic, not support, I guess this is what you get. We have members across the way who have made comments, Mr. Speaker, that have disparaged Indigenous people, indirectly and indirectly. And what arguments about this case that are being litigated with absolutely no basis in judgment is doing is causing people to look at Indigenous people as the cause of a problem, to blame them, and to cast aspersions upon them, when in fact what we need to be doing is working through this on reconciliation in a way that creates prosperity, but that also assures private property is protected. If they focus their attention, Mr. Speaker, on that, perhaps we'd have communities that felt like we could work together, which is what the Conservatives simply have no interest in doing.
Resuming debate. Reprise du débat. The Honourable Parliamentary Secretary and Minister of Fisheries.
Mr. Speaker, I would like to use my time today to speak about the recent agreements that Canada signed with the Musqueam First Nation. These agreements build on the Constitution Act 1982, the direction provided by the courts over the last several decades, and efforts of Indigenous groups over many years to have their rights recognized and upheld by the Crown. To understand these agreements, it's helpful to begin with the Constitution. Section 35 of the Constitution Act 1982 states that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. It reflects Parliament's recognition that Indigenous nations will become partners in confederation based on fair and just reconciliation between Indigenous peoples and the Crown. Existing Aboriginal and treaty rights include rights defined under historic or modern treaties and the asserted Aboriginal rights and title of Indigenous nations which claims to land that remain unresolved. Indigenous nations have rights and title within their territory that are recognized and affirmed by Section 35 of the Constitution Act 1982. Section 35 recognized what First Nations have always known, that they have Aboriginal rights. However, Mr. Speaker, acknowledging Aboriginal rights is not the same as defining those rights. General recognition that a First Nation has Aboriginal title acknowledges a legal and historical fact. That recognition also creates an important and respectful starting point for the negotiation of agreements to address their claims. General recognition of Aboriginal rights, including title, is often included in agreements negotiated between governments and Indigenous nations, including both treaties and incremental non-treaty agreements. Agreements such as the Musqueam Rights Recognition Agreement contain general recognition, and do not create a legal interest in any specific lands. Mr. Speaker, specific recognition of Aboriginal title would mean that an Indigenous group has Aboriginal title to specific lands, including a legal ownership interest based on their historical use and occupation of those lands. This type of recognition can either happen as part of an agreement negotiated between governments and Indigenous nations, or as a result of a court decision in an Aboriginal title case, such as in the Cowichan or Silcoteen cases. Put simply, Mr. Speaker, this agreement does not create Aboriginal rights for Musqueam. It does not define the nature or scope of their Aboriginal rights. It simply acknowledges that the Musqueam have Aboriginal rights, including Aboriginal title, somewhere, not throughout within their entire traditional territory. Most importantly, it sets out a process for discussion about how and where those rights might be implemented in the future. To use the analogy of a toolbox, Mr. Speaker, general recognition of Aboriginal rights through the Musqueam Rights Recognition Agreement is like agreeing that a toolbox exists. What it does not do is decide how the tools will be used or which tools are needed. Those are questions that are worked through later, together through discussion and negotiation. Moreover, Mr. Speaker, the Musqueam Rights Recognition Agreement does not impact third-party interests, including private property. It does not impact the rights of other First Nations. It does not impact or alter the jurisdiction of federal, provincial, or local governments. No decision-making powers about lands, waters, or resources are transferred through these agreements. Mr. Speaker, the Musqueam Agreement doesn't mention private property because private property was never on the negotiating table in the first place. There has been a lot of commentary regarding these agreements. Canadians place great value on private property and also recognize the importance of advancing reconciliation with Indigenous people. Given the importance of advancing reconciliation with First Nations and the need for clarity as Canada strengthens its economy, it's critical that we are clear about what these agreements are and what they are not. To that end, Mr. Speaker, I would emphasize that private property is firmly under the jurisdiction of provincial governments. It cannot be negotiated away from provinces or Canadians without their consent, and it is not something the federal government can alter through this type of agreement. The Government of Canada respects both existing private property interests and constitutionally protected Indigenous rights within the federal government's areas of responsibility. The Musqueam have clearly stated that they have no intention of pursuing private property through this agreement. If I may quote Musqueam Chief Wayne Sparrow, Mr. Speaker, he said, "Our approach to traditional unceded territory is one of partnership and relationship with our neighbors, not trying to take away our neighbors' private property. Treaties and other agreements, such as the one with Musqueam, allow government to advance reconciliation and address Indigenous rights and title through dialogue and cooperation while protecting private property and providing certainty for all Canadians. The Musqueam Rights Recognition Agreement provides a path forward to address Musqueam's rights and title collaboratively and avoid the uncertainty and high costs of pursuing litigation in the courts. Canada has consistently stated that the best way to resolve outstanding claims is to work together in partnerships through cooperative negotiations and respectful dialogue, not through litigation. The litigation of land claims often involves unpredictable outcomes and significant costs for provincial, territorial, and federal governments and Canadians. Negotiated agreements provide an alternative that supports clarity and stability around the exercise of Aboriginal rights. Agreements like the Musqueam Agreement are about creating certainty and predictability. Predictability for investors, for major projects, for private landowners, for Indigenous groups, and for all Canadians. By negotiating agreements such as this one, Canada is taking a responsible approach to resolving outstanding claims, including through its work with the Musqueam. In so doing, we are able to advance the resolution of long-standing disputes about land and rights in ways that respect the rights of Indigenous peoples, uphold existing private property rights, and reflect the best interests of all Canadians. This approach supports a stronger and more unified Canada where private property and Indigenous rights are respected together. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The honourable member for Kamloops Thompson Nicola.
It's always a pleasure to rise on behalf of the people from Kamloops Thompson Nicola, and I have to say I'm quite disappointed in the government's response. In fact, I think they're going to resile from this response at some point. You know, when I heard the minister say, and to me this was completely unbecoming, because the minister said, this is just fear-mongering. Well, is it fear-mongering when somebody goes to renew their mortgage and they have to get a higher interest rate because the market is saying that their house is no longer worth the same amount? Crickets. Is it fear-mongering when somebody cannot get insurance at the same rate? That has nothing to do with what is being said on this side of the House. It has to do with really what is happening on the ground. The only reason that the government is dealing with this is because they're hearing about it. And they're hearing about it because of the reasons I just said. Does the honourable member not agree?
The honourable parliamentary secretary, the Minister of Fisheries.
Mr. Speaker, this motion misrepresents both the law and the government's position. It suggests that Canadians could lose their homes because of agreements with Indigenous partners, and that is simply not true. Our government has been clear. We support protecting private property rights, and we are actively defending them through the courts. At the same time, we will not support a partisan process that supports and spreads fear and misinformation about reconciliation and Indigenous partnerships. Our government has been clear that reconciliation is the way in which we want to move forward on these.
Questions and comments. Question et commentaire. The honourable member for Brampton South.
Thank you, Mr. Speaker. Thank you, honourable member, for your speech. I have a question. Can my honourable colleague tell us, explain why it is important to protect private property rights while also respecting the courts, the Constitution, and our responsibility towards reconciliations? Thank you.
The honourable parliamentary secretary to the Minister of Fisheries.
Mr. Speaker, protecting the certainty and integrity of private property rights remains a fundamental priority for our government. That is precisely why we advance all viable legal arguments to protect private property. We do not agree with the BC Supreme Court's ruling, which is why the government appealed it back in September. Our government is fully committed to ensuring stability, certainty, and confidence for Canadians who own property while we advance reconciliation. This matter is before the courts, where it should properly be addressed, not reduced to partisan rhetoric in this chamber.
Questions and comments. Question et commentaire. The honourable member for Cowichan Malahat Langford.
Thank you, Mr. Speaker. I'm feeling frustration from across my riding. We keep hearing the word all viable arguments, but we're not hearing all arguments. Will the Liberals acknowledge what the Supreme Court knows that was established in the BC Appeals Court, that the federal government lawyers will not be able to use the main argument, the extinguishment of land title argument, because they failed to do it in BC Appeals Court? So will they acknowledge that, and what arguments will they use in the Supreme Court? Thank you.
Honourable Parliamentary Secretary to the Minister of Fisheries.
Mr. Speaker, preserving the certainty and stability of private property is of importance, utmost importance. That is why we will advance all viable legal arguments to protect private property. We believed then, and we continue to believe now, that those potentially affected by decisions of the magnitude deserve to be informed and heard. That is why, as far back as 2017, Canada argued before the court that private landowners should be notified of the litigation. This is why we have supported an application which would allow Montrose, a property owner in the area, to present evidence that was not before.
We have time for a brief question. The honourable member for Kamloops Thompson Nicola. Brief.
It's always a pleasure to rise on behalf of the people from Kamloops Thompson Nicola, Mr. Speaker. And he talks about all legal options. He's talking like a lawyer here. Why doesn't he tell us why the idea of estoppel or an issue estoppel, does that arise, yes or no?
The honourable parliamentary secretary.
Mr. Speaker, it's also important to be very clear about the Musqueam agreements. These agreements do not impact private property. The agreements recognize the Musqueam's constitutionally protected Aboriginal rights in the specific areas, stewardship and marine emergency management, while creating a practical framework for collaboration between Canada and the First Nations. These agreements respect the rights of Indigenous peoples.
Order. The time has expired. Resuming debate. Reprise du débat. The honourable member for Okanagan, Lake West, South Kelowna.
Thank you, Mr. Speaker. And it's always an honor to rise in this place and to speak on behalf of the good people of Okanagan, Lake West, South Kelowna. I will inform you, Mr. Speaker, that I also have the honor of sharing my time with the honourable member from Richmond, Marpole. Now, this past week, Canadians, particularly British Columbians, received deeply troubling news. A new survey from the Business Council of British Columbia found that nearly 3/4 of businesses plan to reduce investment and 1/3 plan to reduce hiring because of the growing uncertainty around property rights and land title in this country. Now, this uncertainty is not theoretical, Mr. Speaker. It is very real. It affects homeowners, employers, municipalities, and investors who believe that in Canada, fee simple ownership meant certainty. Now, since the Cowichan ruling, Mr. Chair, I have to say I've received calls, and I was a bit shocked because Westbank First Nation is in the heart of Okanagan, Lake West, South Kelowna, and they sit side by side with the city of West Kelowna. And I had people that live in Westbank First Nation ask questions about their property and whether or not their investments were safe. And it's not surprising, Mr. Chair, because today's debate is really around a simple question. Because people in my riding are asking us, will this House of Commons stand up for Canadians who followed the rules and invested their life savings, or will you allow uncertainty and inaction to undermine private property rights in Canada? Business leaders are clear about what is driving this concern: increased costs, delay, complexity, and unpredictability caused by this court ruling, policy reversals, and an ever-changing legal landscape. As a result, investment, Mr. Speaker, is being shelved. Jobs are at risk, and confidence is eroding. What we already know is alarming. Fee simple titles held in the city of Richmond, by the federal government and the Vancouver Port Authority are now potentially invalid or effective due to this ruling. What we do not know yet is the full impact on private landowners, people who worked hard, followed every rule, paid their taxes, and put their entire life savings into their homes and businesses. They are worried, and rightly so. Now, when these concerns are raised, members opposite respond by accusing critics of fear-mongering or spreading misinformation. This is what Liberals tend to do when they do not have a substantive answer to serious questions. Because these are serious questions. To those making those accusations, I would offer this. It was this Liberal government that adopted Litigation Directive 14. That directive restricted the arguments Crown lawyers could make in court to defend fee simple property rights. That is not rhetoric. That is documented policy. Litigation Directive 14 is not fear-mongering. It's a fact. It's an inconvenient fact for the Prime Minister and his government, one that they have refused to explain why this is still on the books and instructing lawyers within their employ. The Prime Minister has been asked repeatedly why his government has continued with this directive, and he has continued to avoid giving a clear answer. Why did this Liberal Prime Minister refuse to stand up for property rights, Mr. Speaker, when it mattered? That remains unanswered. But what we do know now is after the damage has been done, the Prime Minister says he disagrees with this court decision. He now says that private property rights are fundamental and that his government will defend them. Well, I'm happy to say, Mr. Speaker, the Prime Minister will have that opportunity with this motion. This Opposition Day motion gives the Prime Minister a chance to match his words with action, something that is increasingly difficult for this Prime Minister. Will he vote to defend private property rights, or will he vote against them once again? This motion proposes practical, substantive, and achievable steps to help restore certainty and confidence. First, it calls on the government to put private property first in the Cowichan case by clearly arguing that fee simple ownership has priority. I've heard the term viable answers or viable arguments, Mr. Chair. That does not necessarily mean they are making every argument. Now, second, it calls specifically for Litigation Directive 14 to be replaced with a clear requirement that the federal government aggressively defend property rights in all litigation. Third, it requires that no agreement can be concluded without explicit protection of fee simple property rights in all future negotiations with First Nations, so everyone understands and has some certainty, something that has been failed to have been done under this government and its predecessor. Fourth, it demands a concrete plan from this Prime Minister within 30 days, complete with timelines to protect Canadians affected by the Cowichan decision and the Musqueam Agreement. Finally, it establishes a special parliamentary committee to examine every legal, constitutional, and political tool available to protect private property rights in Canada. Now, Mr. Speaker, these are not radical proposals. They are not ideological. They are responsible. They only become controversial if one does not believe that private property rights are fundamental to our system, both in terms of our system of capitalism in this country and in our Westminster system. We've always honored these things. And the lack of certainty that we see today is causing real harm. It is freezing investment, encouraging litigation, and forcing Canadians into a legal limbo with no clear path forward. Now, this is despite all the Prime Minister and his Liberal members of Parliament, as I've heard described in the Toronto Star, his deputies, they are all describing that everything that Conservatives are saying is not true. So, Mr. Chair, it should not be this way. Behind closed doors, negotiations are occurring with public tax dollars on the line, while affected Canadians are left without consultation, clarity, or protection. Lawyers disagree. Experts disagree. Lawsuits are multiplying, and government is failing to protect the interests of some of the very people it claims to serve. British Columbia already faces enough challenges. One can look at softwood lumber, American tariffs, and a NDP provincial government that appears to have no idea of what it's doing. We do not need to add property rights chaos to that list. Well, I guess it already is, but we got to make sure that we pull that off the list. And this motion, Mr. Chair, Mr. Speaker, is a way to do that. Now, this Prime Minister often says that we should focus on what we can control. Well, today, this motion, this House can control something. We can restore certainty. We can defend property rights. We can stand up for Canadians who, by every account, have done everything right. That's why I will be voting in favor of this motion. The Prime Minister himself has said private property rights are fundamental. Today, we will see if his words mean anything. So I urge all honourable members to support this motion and send a clear message. In Canada, private property rights matter. We hear the concerns raised by British Columbians. We know we have the means of which to address them, and that we are dedicated in service to ensuring that their rights, their concerns are addressed, not in some far-off land, Mr. Speaker, in some yet-to-be-determined time, but here, now, this Parliament, this country. Thank you.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Mr. Speaker. The essence of the motion that we have before us today is to try to give a false impression. An impression as if the government does not support private land rights, which is just not the case. Every Conservative member knows that, Mr. Speaker. The damage, I would suggest, by bringing forward even motions of this nature that mislead significantly is at a great cost in many ways. We talk a great deal about reconciliation, and this is a step backwards. The Prime Minister, the Minister responsible, have made it very clear. The question I have for the member is, why is the Conservative Party wanting to promote fear when there is no need to do so?
The Honourable Member for Okanagan, Lake West, South Kelowna.
As I said, Mr. Speaker, Liberal members continue to throw out any concerns as misinformation. You know what's not misinformation? In 2019, the Liberals adopted litigation guideline number 14, telling federal lawyers to avoid defending property rights. That directive is still in force today, despite multiple calls by Conservative members for this Prime Minister to show Canadians that he means what he says. He has yet to take us up on that offer. And Mr. Chair, Mr. Speaker, when we have Liberals say it's all misinformation, it's on the government website. If it's misinformation, is the government now the biggest misleader on this particular case? Because if you read the website, that's what it says. That member can't say otherwise because it's the truth.
Questions and comments. Question et commentaire. The Honourable Member for Kamloops Thompson Nicola.
It's always a pleasure to rise on behalf of the people from Kamloops Thompson Nicola, and I thank my colleague for his impeccable speech. You know, we just heard from a BC member from Surrey, and I've got to say, it sounds like a bureaucrat wrote the speech, and the reason I say that is because he read the whole speech. In fact, I asked him a question, and he went and read from a piece of paper that had nothing to do with the question. My honourable colleague clearly wrote his own speech, and I'm wondering, what message does it send when the Liberals are just reading talking points, accusing us of fear-mongering? Why don't they go to the houses in Richmond? Why don't they go to the places in Vancouver and say, how do you feel about having a higher mortgage rate? How do you feel about not being able to get home insurance? Why don't they do that?
Okanagan, Lake West, South Kelowna.
Mr. Speaker, if you read any newspaper in British Columbia, you're going to read about the Mayor of Richmond, who has broadly raised this issue while the province and federal government said nothing. They made clear representation on private property rights. All we are asking in this motion today, and of Liberal members, is to start listening to British Columbians and those that they have elected who have been raising this alarm. They've had lots of time, Mr. Speaker. The fact that they're now sending out members from British Columbia who are just reading talking points, basically giving the same line without concrete action, says to me they're prepared to vote against this because they truly do not protect the private property rights of British Columbians or anyone else.
Comments. Question et commentaire. The Honourable Member for Cowichan, Malahat, Langford. About 45 seconds.
Thank you, Mr. Speaker. Today, the Liberals repeatedly failed to answer my question on extinguishment and their failure to use that argument in the BC Appeals Court, and therefore legally not being able to use it in the Supreme Court. They mislead Canadians. They give a false impression. They say every viable argument because they know they cannot say every argument. Is this, for my honourable colleague, is this just another Liberal illusion? Thank you, Mr. Speaker.
For Okanagan, Lake West, South Kelowna.
You know, Mr. Speaker, when we have Liberal members rise and talk about that this is all part of reconciliation, you know, a judge in New Brunswick had a very different interpretation. In fact, when there was talk about, in a court case in New Brunswick about extinguishment and how that related to private property rights, the judge actually identified that the one way to draw reconciliation back, to dial that back in a negative direction, would be to put the people that I mentioned, those homeowners, those business owners who have done everything right that's been asked them under the law and puts their private property rights at risk. It causes frictions between First Nations in British Columbia, in Canada, against the interest of them, and now this government is making it all worse. We need to work together to get back to a situation where everyone is comfortable with those relations moving forward.
Resuming debate. Reprise du débat. The honourable member for Richmond Centre, Marpole.
Mr. Speaker, for 8 months, British Columbians have been left with silence. Silence after a court ruling that raised serious questions about the certainty of public property rights in Canada. Silence after repeated concerns from homeowners, businesses, municipalities, and investors. Silence after Richmond City Council sent letters asking this government for clarity. Silence after Canadians asked a very simple question. Does this Liberal government still believe in defending the legal foundations of public property rights in Canada? And after all that silence, when the Prime Minister finally addressed the issues in this House, Canadians did not get answers. They got talking points. They got attacks. They got accusations for fear-mongering, but they still did not get clarity. So, let's put some facts on the record. First, despite what the Prime Minister claimed in this House, the Liberal government did not immediately appeal the Convention ruling. They waited until the very last possible moment before filing its appeal, long after the province of British Columbia and the city of Richmond, which is a clear distinction in willingness to stand up for Canadians. If that Liberals truly believed the ruling created no uncertainty, why wait until the deadline was really expired? Second, throughout this entire controversy, the government has offered no meaningful public explanation of the ruling and no substantive public statement on the implications for homeowners, businesses, municipalities, lenders, or investors. Nope. 8 months passed before Canadians even heard a serious acknowledgement from the Prime Minister. Shameful. 8 months. Third, Richmond City Council repeatedly attempted to engage with the Liberal government. They wrote letters seeking clarity on the implication of the Cowichan and Musqueam agreements and the broader concerns surrounding land title certainty and federal litigation policy. These are not just some fringe concerns. When homeowners cannot renew their mortgage, they came from elected municipal leaders representing one of the most economically significant communities in British Columbia. And what did they receive? Silence. No meaningful engagement, no public reassurance, no detailed explanation. Fourth, when Conservatives ask questions in committees and in this House, the government consistently provides vague and ambiguous answers. They hide behind legal technicalities. They avoid direct responses. They narrow every answer to procedural language instead of addressing the border issue Canadians were actually worried about. Whether this government was weakening the legal foundations that underpin public ownership in Canada. That's not the level of clarity that business owners and investors must depend on. And finally, when the Prime Minister did speak, after months of pressure, he's still confused. He still refused to provide the one assurance Canadians were looking for. He will not clearly commit to withdrawing the 2019 directive, Litigation Guideline 14, which effectively sent its own lawyers into the court with one hand tied behind their back. Let's be absolutely clear. A central issue in this litigation is that the federal government, through Litigation Guideline 14, instructed its lawyers to restrict their arguments regarding the supremacy and extinguishment effect of fee simple rights. This directive was issued in the middle of ongoing litigation, and represented a clear change of course in the government's line of argument. Rather than fully defending the certainty and finality of private property rights, the government deliberately narrowed the arguments available to its own counsel, creating uncertainty with potentially far-reaching consequences for property owners across Canada. That directive remains publicly available on this Liberal government's own website today. So Canadians are still left asking, what exactly is this government's position? Mr. Speaker, Conservatives have been accused of fear-mongering for raising these concerns. But let's look at the real-world consequence of uncertainty. Markets react immediately. Investors react immediately. Lenders react immediately. Business react immediately. The consequences are already being felt on the ground in British Columbia. Montrose Properties has publicly raised concerns about the uncertainty surrounding land title and investment confidence. A local golf course now sits in limbo, uncertain it should continue investing in growth or prepare to sell. Farmers who have worked their land for decades are now questioning how to manage long-term operations while watching property values decline and financing uncertainty increases. A local senior couple has reportedly been unable to sell their property in order to pursue a more secure retirement. Even a deal involving the sale of a local hotel, which is not even located within the disputed area, had collapsed because of the growing uncertainty surrounding land title and future risk. Mr. Speaker, these are not theoretical consequences. These are real people, real businesses, and real livelihood being impacted right now. Canadians are not asking for abstract legal debates. These are foundational questions about confidence in Canada's economy and legal systems. These issues matter deeply in my riding, Richmond Centre, Maple. Richmond is not just another municipality. It's one of Canada's economic gateways to the Indo-Pacific. It's home to major transportation, infrastructure, international trade networks, logistic hubs, exporters, entrepreneurs, and families who have invested their life savings in homes and business. In a place where immigrants have chosen to build a livelihood. That's why Richmond's City Council raised concerns. That's why residents are paying attention. That's why businesses are watching carefully. Mr. Speaker, the Convention ruling has far-reaching consequences, yet the Liberal government is trying to water down its significance and mislead Canadians about its impact. They know they made a great mistake when they gave their lawyers those restrictive instructions, and now they're trying to distance themselves from the consequences. They know the impact of this ruling is real, yet instead of taking responsibility, they're attempting to whitewash the issue and accuse others for fear-mongering. This decision will have profound and lasting consequences, not only for Richmond, not only for the Lower Mainland, not only for British Columbia, but for all of Canada. This government's actions will be remembered as a shameful chapter in our country's history. Canadians deserve transparency. We deserve confidence, and we deserve real answers. Thank you, Mr. Speaker.
Bravo. Questions and comments. The member for Canso, Antigonish, Cape Breton. I've probably got the wrong order, but go ahead.
Yes, I'd like to thank the member opposite for that speech, but I question some of the logic around. I understand that these are concerns that his constituents have brought up, but Mr. Speaker, that there's been Aboriginal title recognized in Canada since 1973, the Delgamo case in 1997, I believe, and we've had 3 or 4 different Aboriginal title cases recognized in British Columbia. Can the member opposite point to a single time where someone lost their property as a result of Aboriginal title?
Member for Richmond, Marple.
I want to ask my colleague on the other side. Do you not admit that the Liberal government did not appeal the ruling until the very last moment, long after Richmond City and the province of British Columbia have done it? Did you not admit that you gave your lawyers the restrictive directive to tie their hand in the court? In the court? Did you not admit that you have been silent for 8 months and still up to this day, you haven't given us any clarity?
Questions and comments? Member for La Pointe-de-Lille.
Merci, Monsieur.
Thank you, Mr. Speaker. I'd like to know, in one of the sections of the Conservative motion, it says the study should last 12 meetings, but the report should be tabled before June 16th. In the case of such a complex matter, such an important matter, would it not be wise to extend that period as needed until the fall to be sure that we really delve into this matter in depth?
Member for Richmond Centre Marpole.
Mr. Speaker, I thank my colleague for this question. For one, this is an urgent matter in the sense that we have already felt the consequences on the ground. People in my riding and in the province of British Columbia are worried, and they are already being attacked and impacted by the consequences of uncertainty. And also, we have asked for emergency debate before, and that was not granted. So this is not a matter that we can keep on waiting, and we've been asking the government to work with us for a solution.
Questions and comments? The member for Haliburton, Kawartha Lakes.
Thank you very much, Mr. Speaker, and I want to thank my friend from Richmond, Malpole, for that amazing speech. I know he is very passionate about this issue, given that the Cowichan decision affects a portion of his riding, and he deals every day with people worried about the future of their homes and businesses. Maybe we can talk about the government in 2018 deciding that their lawyers stop arguing for fee simple property. I think that's the crux of the issue itself. And maybe to that point, the government says they stand up for fee simple property owners, but maybe the member could opine, how does the government expect to win a court case with an argument it can't use in appeal because they did not use it in the lower court?
Member for Richmond Centre Marpole.
Yes, this is the question I think the Liberal government has to answer. They either have to admit that they have made a mistake in giving that directive, or they would stand up and say that they're still honoring that directive. In both ways, Canadians are the losers. And also, in this case of the appeal, it's because of City of Richmond has insisted right from the beginning on the fee simple argument that we are able to proceed in the appeal for that argument. So thanks to Richmond City for insisting on that argument, and shame to this government.
Quick question. Okay, resuming debate. Go ahead. The member for Canso
Antigonish, Mr. Speaker.
Cape Breton, Canso Antigonish.
Thank you, Mr. Speaker, and I'll be sharing my time with the member for Richmond East, Stifton. Stevenson? Okay. Mr. Speaker, I want to take a few minutes today to separate fact from fiction. Because right now, when it comes to Aboriginal title, this country, there is a lot of confusion. That confusion fuels concern, and in some cases, misinformation is making it worse. So let me be very clear from the outset. Some of the anxiety Canadians are feeling right now is understandable. And it is rooted in the fact that this area of law is not settled and evolving. For many Canadians, this is not an abstract, it's about their homes, for their businesses, their communities, and the sense of security. When people hear conflicting information about something as fundamental as property rights, it is entirely reasonable that they ask questions and expect clear answers. For decades, Canadian courts have developed Aboriginal title law carefully and incrementally since it was first recognized back in 1973. The decision in the Cowichan Tribes versus British Columbia at the BC Supreme Court took a novel approach. It found that Aboriginal title could exist in area that include private fee simple lands and suggested that those interests could actually coexist. The court did not invalidate private property held titles. It did not remove land from individuals. What it did was introduce a new and complex legal question about precisely how continuing private property interests could coexist with what the court also declared was a superior Aboriginal title interest. Mr. Speaker, our government has been clear. We do not agree with the court's decision in Cowichan. We recognized that it creates uncertainty, and that's why it's being appealed. Canadians deserve clarity on something as fundamental as property rights. And that is just not our view, it's reflected in the fact that the courts themselves are not aligned on this issue. If I want to bring to your attention, in New Brunswick, the litigation involving the Wolastoqey Nation versus New Brunswick at the Court of Appeal decision reached a very different conclusion. The court states that it is open for court to make a finding of Aboriginal title over private property, which could lead to a compensation award against the Crown. But that declaration of Aboriginal title cannot be made over private property. So we now have two court decisions in Canada taking opposite approaches. That divergence is exactly why we need to have clarity from the courts, and that's why it's being appealed. And this is an important point, Mr. Speaker. When the law is unsettled, it creates space for speculation. It creates space for competing interpretations, and in that space, misinformation can take hold and facts can be twisted. Mr. Speaker, this is where myth begins to enter the picture, because while this legal uncertainty is real, it is being used and weaponized in some cases to suggest that the negotiated agreements are putting private property at risk. That is simply not true. And it is important that we say clearly, but also respectfully, because many Canadians are asking these questions, are doing so in good faith. So let me address one example directly. There has been commentary about the Musqueam Agreement and what it does and does not do. Here are the facts. It does not impact Canadians' private property. This agreement does not grant new rights. It does not define or finalize the scope of any existing Musqueam Aboriginal rights. And it does not attach any such rights to specific parcels of land. What it does is it acknowledges that rights exist, which they do under Section 35 of the Constitution, and creates a structured process for Canada and Musqueam to work together to better understand how those rights may be addressed over time. That is it. It is a framework for negotiations. It is not a transfer of land or change in ownership, and it does not affect private property. It does not override provincial jurisdiction, and it does not give any decision-making authority over lands or resources to Musqueam through this agreement. In other words, Mr. Speaker, it is about creating a path forward for dialogue and clarity, not changing who owns what today. In fact, private property was never part of these negotiations and will never be part of any future negotiations. And I would remind colleagues that in British Columbia, jurisdiction over private property rests with the province. It is not something that the federal government can simply negotiate away, and it has not done so. The Musqueam themselves have been clear that this agreement is not about pursuing privately owned land. So when Canadians hear claims that agreements like this somehow put their homes and businesses at risk, those claims are not grounded in fact. They're grounded in trying to create fear. Mr. Speaker, the distinction is important. On the one hand, we have the court's decision that are exploring new and unsettled legal territory. And on the other hand, we have negotiated agreements that are designed to create clarity, not uncertainty. And that distinction matters because litigation and negotiation do very different things. Litigation can clarify the law over time, but it often does so in a narrow, incremental way that can leave broader uncertainty in the meantime. Negotiation allows parties to sit down and address concerns directly and build solutions that reflect real-world impacts. No modern treaty, negotiated agreement, or federal approach has resulted in Canadians losing privately owned land. And this is going back to 1973, when Aboriginal title was first recognized and discussed in the Calder case. In fact, negotiated agreements consistently do the opposite. They provide predictability, they provide clarity, and they explicitly protect private interests while advancing reconciliation. We saw that recently in the agreement with Haida Nation, which addressed Aboriginal title, while clearly also providing for the protection of private fee simple lands. That is the value of negotiations. Negotiations allow complexity to be addressed directly and balanced outcomes to be reached. Courts answer legal questions. Negotiations build lasting solutions. And, Mr. Speaker, we are committed to ensuring those negotiations go forward in a way that creates clarity. So yes, Mr. Speaker, there is uncertainty right now. Canadians have legitimate questions, and we're acting to address that uncertainty by seeking clarity through the courts where the issue is already being raised. At the same time, that uncertainty cannot be used to misinterpret the facts. We will continue to engage Canadians with honesty, transparency, and acknowledging what we know, what we do not know yet, and what are doing to get clarity. Fear must not replace facts, and reconciliation must move forward through respectful, balanced, and negotiated agreements. And at the end of the day, Canadians have confidence that their rights and interests are being protected, and that reconciliation is being advanced in a thoughtful, measured, and fact-based way. That is how certainty is built. Trust is strengthened, and how we will move together. And Mr. Speaker, I want to dwell on this because there's been a lot of misinformation on this, and they continue to act as if Aboriginal title in Canada is a new thing. It's been recognized since 1973. We've seen multiple British Columbia tribes go to court and have their Aboriginal titles recognized from the Nisga'a from Delgamo to the Chilcotin. And not one example has ever happened where these court cases resulted in someone losing their fee simple property rights. Mr. Speaker, it just has not happened. And this is why, to suggest that for some reason or somehow that these tribes are going to come in after this title and take people's homes and their property is just irresponsible, unfactual, and meant to create fear and misinform Canadians. On this side of the House, we will continue to balance our efforts towards reconciliation with the interests of Canadians. We've done so in every single Indigenous case that has ever gone to the Supreme Court where the Indigenous tribes have won. And we will continue to do so moving forward. And so for the Canadians at home hearing this, our government is ready, prepared, and willing to negotiate and ensure that we're protecting property rights at the same time advancing reconciliation. Thank you, Mr. Speaker.
Questions and comments. Question commentator, the Honourable Member for Haliburton, Kawartha Lakes.
Thank you very much, Speaker, and I thank the member opposite for his speech, and I do enjoy working with him on the Indigenous and Northern Affairs Committee. The member used the comment that we've heard a lot, talking about disinformation. I don't think at any point in the debate today we have implied that the Cowichan Band would be kicking people off their land. I don't think anyone on this side has said that in all the time we've been debating this, so I don't know where that member is actually getting it from. We have said it creates uncertainty within the marketplace, being private business and private home ownership, and that's exactly what it's creating. So much so that the province of British Columbia actually had to come in to backstop homes and business owners that are trying to obtain financing through the banks. So there is uncertainty. That is true. That is not misinformation. The government also in 2018 told their lawyers to stop arguing for fee simple property. That is a fact. There is also numerous other things the government has done that creates this uncertainty, and that's what we're arguing here. The government expects to win in court on appeal with an argument it cannot make.
The Honourable Parliamentary Secretary, the Minister for Crown Indigenous Relations.
Mr. Speaker, I respect that member, and I want to respectfully say that I've heard a lot of Conservatives get up and pretend they know a thing about Aboriginal litigation. As someone who taught Aboriginal and treaty rights law at the university, I've heard some of these arguments. Mr. Speaker, when a court case comes to the Supreme Court of Canada, many interveners will come in with many different arguments, and so for the members opposite to suggest that there was one opportunity to have an argument that might go to the Supreme Court of Canada is unfactual, and it's not based in any kind of actual fact of anyone who's ever read an Aboriginal title case or anyone who's actually looked at the court cases and said, here's what happens when Indigenous nations have proved that their Section 35 rights are proved. We will sit down and negotiate with them. We protect interests of Canadians, but we also do it in a way that doesn't create fear, mistrust, and...
Questions and comments. Question et commentaire. L'honorable député de La Pointe.
The Honourable Member for La Pointe de l'Île. Thank you, Mr. Speaker. I'd like to know what my colleague thinks of this. Does he agree that we should be able to study the matter, either at Indigenous Affairs Committee or in a special committee, as the Conservatives are proposing?
The Honourable Parliamentary Secretary.
Merci pour la question.
Thank you for the question.
Mr. Speaker, I think that this determination needs to go through the court system. When you have things that are before the courts, we have an independent judiciary, and it's really important that when it comes to the law, we have the application of those facts and law done in independent ways.
Questions, comments. The Honourable Parliamentary Secretary, the Minister of Environment and Climate Change.
Thank you, Mr. Speaker. And I have memories of being in high school in the early 1990s when the BC Treaty process was opened up because of the many title cases that my colleague had talked about. And I had students, my fellow students, ask me, "Are you coming for our house? Are you coming for our land?" We had to have leadership come say, "Absolutely not. Absolutely not. We will never do that. We want to work in cooperation. We want to live in harmony with each and every person that lives in and around our territory." I wanted to ask the Honourable Parliamentary Secretary, he's been involved in First Nations politics for a very long time across this country. Has he ever once heard a First Nations person, a chief, or anybody say, "We want private property rights"?
Secretary to the Minister for Crown Indigenous Relations.
Thank my colleague for that question. And truthfully, when you go across this country, you hear chiefs and leaders talking about justice. They talk about the rights that they had, the title, the resources, and they just want their fair share. They're not asking for over and above what Canadians receive. They want to be a part of a system. They want to be a part of growing. And they have these rights recognized by Section 35, often upheld in the courts. And when those rights are upheld, they often negotiate with our federal government to figure out how we implement those rights. It's happened for the Mi'kmaq in 1990 with the Marshall decision. It happens in British Columbia with Aboriginal title. The government and the nations and the province find ways to create dialogue, get to the negotiation table, and ensure that we're representing all rights in a situation where all parties are winning and that no one loses out.
Time for one last question, relatively brief. The Honourable Member for Haliburton and Kawartha Lakes.
Thank you, Speaker. The member opposite talked about the argument of private property at court. The member opposite, being involved in the law, should know that if you don't make the argument in the lower court, you can't use that argument at appeal or if it goes to the Supreme Court. The government can't make that argument. The other thing the court decision did, it eviscerated Sections 23 and 25 of the BC Land Title Act. That is the underpinning of private ownership in the city of Richmond and within the province of British Columbia. So how does the government, again, expect to use an argument and win at court on something they can't actually use?
Order. The Honourable Parliamentary Secretary and Minister of Crown Indigenous Relations.
Mr. Speaker, I would invite that member to look at every single Aboriginal title litigation or every Section 35 case out there, there are things called interveners. And interveners can come, and the Conservative Party of Canada could actually apply to be an intervener and ask the court, since they have all of the answers when it comes to litigating First Nations rights, they can ask for that. I doubt they'll be granted because the Supreme Court looks at rational and reasonable arguments and not political and irresponsible arguments.
Order. There's been a little bit of back and forth here, and it's been pretty order. There's been a bit of back and forth. It's been relatively in good nature. I'll just remind people to try to wait for the question and comment period before asking questions across the floor. We are on to resuming debate. Reprise de débat. The honourable member for Richmond East, Steveston.
Thank you, Mr. Speaker. I appreciate the opportunity to speak on the matter of the Cowichan Court decision today, as it has raised understandable questions in this House, in my hometown of Richmond, British Columbia, and across Canada. So let me first say that our government disagrees with the British Columbia Supreme Court's decision, and we immediately appealed the court decision. As this case is before the courts, it wouldn't be appropriate for me to comment further on the ongoing aspects of the litigation itself. I will, however, provide background on the history of this case and speak to private property interests. So it's helpful at the outset to understand the scope of this litigation and the number of parties involved. Besides the federal Crown, there are 5 other defendants in the litigation: the Vancouver Fraser Port Authority, the Government of British Columbia, the City of Richmond, the Musqueam First Nation, and the Tsawwassen First Nation. The litigation began in November 2014. The Cowichan sought a declaration of Aboriginal title to 1,846 acres of land located in the City of Richmond, along with a declaration of an Aboriginal right to fish for food in the south arm of the Fraser River. The claimed lands included federal lands owned by Transport Canada and managed by the Vancouver Fraser Port Authority, Richmond Municipal Lands, and some lands held by private landowners. Given the complexity of the issues and the number of parties involved, it's not surprising that the case unfolded over several years. On August 7th of 2025, the British Columbia Supreme Court delivered its decision, ruling that the Cowichan hold Aboriginal title over approximately 40% of their claimed area, as well as an Aboriginal right to fish for food in the south arm of the Fraser River. And soon after that release of the decision, all parties took further steps within the court process. The court's decision is being appealed by all parties to the litigation, including Canada. Some of the court's findings have potentially significant implications, including with respect to private property rights. Because the decision is not entirely clear on certain points, and that clarity is being sought through the proper legal process, I myself have been working to seek clarity also, and I recognize that this decision has raised questions or concerns. We know Canada defended the validity of fee simple title granted by the Crown at trial. Canada also defended the principle of transparency in this trial, particularly for parties who are not directly involved in this case, but who may be affected by its outcome. In 2017, Canada brought an application seeking an order requiring the plaintiffs to notify private landowners within the claim area in this case. The court declined to exercise its discretion to require the Cowichan to give formal notice to private landowners. I should note that all Aboriginal title claims are unique, and the reason in this decision will not necessarily apply to other cases. It depends on the facts of the case in question. With that background in mind, I will turn to more recent developments. 3 related private real estate companies, which I'll refer to as Montrose, operate in Richmond and claim they are the largest landowner in the declared Cowichan title area. Montrose has applied to the British Columbia Supreme Court to reopen the trial, be added as a party, and file new evidence and argument. Its application would allow the company to present its perspective on how the declaration of Aboriginal title impacts its legal and financial interests. Canada has filed a response to support Montrose's application. It is important for all parties to be heard when they are directly and significantly affected by a court decision.
Canada's position is consistent with the application it brought in 2017 regarding the need to provide notice of the trial to private landowners. If successful, Montrose would become an official party to the litigation, and the record would be reopened so the court can receive Montrose's evidence and submissions, including submissions related to the impacts of the ruling. The Montrose application is scheduled to be heard before British Columbia Supreme Court on May 25th and 26th of this year. Mr. Speaker, the Government of Canada respects the right of all parties to pursue their own legal strategies. Canada's approach in this litigation reflects the use of appropriate court process to address legal uncertainty, while continuing to advance reconciliation in accordance with the Constitution. I will add that private property rights are fundamental, and our government will always protect them. For the Government of Canada, private property cannot and will not be negotiated. This is not only because our government would never negotiate Canadians' private property, but also because, as you all know, private land ownership and land deeds fall under provincial jurisdiction, not federal jurisdiction. And it's important to note that any agreement on Aboriginal title at the federal level protects private property. In fact, no modern treaty, negotiated agreement, or federal approach has led to Canadians losing their privately owned land. As a Member of Parliament for Richmond East Steveston, I have been and will continue to work with the Minister of the Crown Indigenous Relations to address residents, their concerns, share constituents' perspectives with the government, and advocate for the people of our city. At the same time, I will work with Richmond City Council and all levels of government to ensure that residents of our city are engaged and informed on these matters as they proceed in the months and years to come. Thank you.
Questions and comments. Question commentary. The member for Langley Township, Fraser Heights.
Yeah, thank you. I'd like to thank my colleague from Richmond Centre, Steveston, for his speech. All morning, we on this side of the House have been raising some of the issues, some of the complexities that have arisen from the Cowichan decision of the BC Supreme Court. And it's been suggested by the Liberal side of the House that we're fear-mongering or misleading. But I'm very happy that the member opposite raised the issue of the Montrose application. Montrose, he will be aware, had a land development project that has now run into complications on account of the Cowichan decision. This is not fear-mongering, this is just facts. I wonder if you could have a comment about that.
The honourable member for Richmond East Steveston.
Well, I think if you listen to some of my colleagues from before, they talked about the fear-mongering we're talking about is the what the members opposite are implying, that private property lands will be taken away. But back to the issue at hand here, Mr. Speaker, this is a provincial matter. I've outlined how federal government cannot and will not negotiate private lands. And most of these questions should be directed to the province and the Premier of British Columbia. And we've seen the decision, a corresponding decision of a similar case happen in New Brunswick. And that Court of Appeal issued a decision in the context of an Aboriginal title claim on the issue of whether Aboriginal title can coexist with fee simple title. And the court found that it could make a finding of Aboriginal title leading to compensation for a Indigenous nation, but it went the other way. So this is a provincial matter. Thank you so much.
Comments. Question commentary. The Honourable Parliamentary Secretary of the Minister of Environment and Climate Change.
Thank you, Mr. Speaker, and I thank my colleague from Richmond East Steveston for his, and I know that he's been very involved. He's very concerned as well because he does take this very seriously with his residents and his constituents. I've seen him on the ground working well, not only with them but also with those that are appealing this decision, along with the federal government. There's the municipality, there's other First Nations, there's the province of British Columbia. So there is a unified approach to make sure that this is appealed. I just want to ask him what he's hearing from the other parties, so that we know that they're all working together to ensure that this is appealed.
The honourable member for Richmond East Steveston.
I want to thank that member and for the question and his hard work on this issue as well. if you look at, to his question, when we talk about the other members that are involved, the concerns are there, and what they're sharing is the opportunity to be involved in the case. And I'd like to mention that a member from Richmond Centre, Marple, who's been talking quite a bit about this, sat as a Richmond City Councillor when this issue was in courts, did not inform residents, but now is speaking, bringing this issue forward. And he also ran for the NDP, the provincial government, who was responsible for this issue at the time. And now we're hearing contradicting information from the other side, and it, again, begs to question why the misinformation is being brought forward into this House.
Comments, the Honourable Member for Haliburton, Kawartha Lakes.
Thank you, Speaker, and thank you to the member opposite for his question. The member opposite just a few moments ago implied that this is only a provincial matter. Well, I guess I should say to the member opposite, it was so much of a provincial matter that just a few days ago that member asked the Prime Minister a lob question about this very issue, to which the Prime Minister had to respond. So clearly a provincial issue, but yet had the Prime Minister answer. The member also talked about the city of Richmond and that they should have notified residents. They were the only ones in court in the longest trial in Canadian history to argue for private property owners. Why did the government not do its job and avoid the situation we're in now?
A member for Richmond East, Steveston.
I want to thank the member for his question, but as I stated in my speech, in 2017, the federal government applied to the court to make sure that they notify the residents. And if you look at the question that he's brought forward with respect to the Prime Minister taking responsibility for this country, and he wanted to ensure Canadians understand that the federal government will not negotiate private property rights. So thank you so much for that question.
Time for a very brief question. The Honourable, a question? Oh, the Honourable Member for Winnipeg North.
Just to quote the Prime Minister directly and to get my colleagues' comments on it, this is what the Prime Minister said just the other day. All federal agreements with First Nations and Indigenous peoples with right holders protect private property rights and protect Indigenous peoples' rights. The Prime Minister has been very, very clear on the issue. If my members can just reinforce that particular thought.
Yeah, thank you so much.
Just a second. Order. The Honourable Member.
Thank you, Mr. Speaker, and thank you to the member for the question. And I'll continue and I'll add there. When I talked about the Prime Minister taking responsibility to make sure Canadians know what our position as a federal government is, and we will have their backs. And I'll reiterate one more piece of that. The federal government would never negotiate Canadians' private property, but also because, as you know, private land ownership and land deeds fall under provincial jurisdiction. That is why I'm stating that this is a provincial matter. Thank you so much.
Resuming debate. Reprise du débat. The Honourable Member for Nanaimo, Ladysmith.
Thank you, Mr. Speaker. The most important changes in life are often invisible at first. Seeds sprout underground before the first shoots appear. A ship that changes course by 1 degree makes no waves but ends up somewhere entirely different. A coastline can look unchanged for years while the tide quietly reshapes it grain by grain. On August 7, 2025, when the BC Supreme Court released the Cowichan Tribe's decision, nothing happened. No Canadian lost their home. Richmond continued to function. The Cowichan Tribes repeatedly said they never intended to interfere with private fee simple title. And yet, the judge decided first that the Cowichan have Aboriginal title to land in Richmond, and second, that Crown grant of fee simple in those lands unjustifiably infringes that title. The court did say that private fee simple interests remain valid, but only until such time as a court may determine otherwise, or the conflicting interests are otherwise resolved through negotiation. With that until, a seed was planted, Mr. Speaker. Homeowners are now aware that a court could determine otherwise, and many of them are nervous. And at paragraph 3543 of a very long decision, the judge added, and I quote, "I accept that a declaration of Aboriginal title may give rise to some uncertainty for the fee simple title holders, and it may have consequences for their interest in land." Within days, it became clear that uncertainty had taken root, and within weeks, the first sign of a growing set of complications became visible. When a person gets a mortgage, their home is the collateral for the loan. If the mortgager's title is uncertain, they're going to have a problem. When a person sells a property, they promise valid title. If the seller's title is uncertain, they're going to have a problem. Anyone who claims to understand the full implication of the Cowichan Tribe's decision at this point is fooling themselves, Mr. Speaker. We are now seeing transactions delayed, financing reconsidered, and investment decisions paused in British Columbia. The case has already reportedly tanked a $100 million deal and created complications with mortgage and property transactions. The BC Financial Services Authority is recommending independent legal advice before buying affected properties. Real estate agents are adding new clauses to purchase agreements across the province. Title insurers are reassessing risk. The Musqueam Agreement followed quickly on Cowichan Tribe's decision, adding additional uncertainty. Investors are skittish and wondering what is coming next. Uncertainty is undermining confidence in land-based collateral in BC. The decision is adding cost we can't afford and disrupting parts of BC's economy at a time when stability is badly needed. The problem, Mr. Speaker, is not that Canadians are unwilling to support reconciliation. In British Columbia, we desperately want to live in harmony. But anxiety creates strain, Mr. Speaker, and government failure to negotiate treaties that would have provided legal clarity before these issues reached a crisis point is dividing our communities. For years, these Liberals talked reconciliation, but dragged their feet on negotiation. They failed to negotiate a treaty with Cowichan Tribe, so they got sued and lost. Now ordinary Canadians are paying the price. Families trying to buy homes, Indigenous communities seeking certainty, municipalities planning infrastructure, and businesses deciding whether to invest in British Columbia face years of legal limbo. Despite their insistence that they are going to appeal the decision and make everything fine again, the Liberals have painted themselves into a legal corner. The Prime Minister admits that property rights are fundamental. The Parliamentary Secretary admits that there are potentially significant implications, including for property rights, that could extend across the country, Mr. Speaker. The Prime Minister and the Liberals say repeatedly that they will make all viable legal arguments. But here's the problem. Appeals are not do-overs, and the raise-it-or-lose-it principle is a core one of how our legal system works. You're not allowed to save some of your arguments for appeal, just in case you don't get what you want at trial. If you could, litigation would cost even more, and it would never end. My dad used to refer to this as the you snooze, you lose principle. Paragraph 2096 of the decision says that Canada initially pled extinguishment, but abandoned its reliance on this defense in its amended response to civil claim filed in November of 2018. In plain English, what that means is that the Liberal government told its lawyers not to argue that fee simple title is superior to all other forms of title, and those lawyers amended the court documents in 2018 to take the argument out. A lot of Canadians are wondering how that could have been allowed to happen. Well, we investigated, Mr. Speaker, and we found the government legal directive, still online, that strongly encourages admissions of liability and discourages defenses like extinguishment that would support fee simple title. It turns out that the one argument the government needed in a 513-day trial is the one they didn't make. And that means it isn't viable on appeal. Conservatives have repeatedly asked how the Prime Minister is going to win an appeal with an argument he isn't entitled to make. In response, we've been accused of misinformation, fear and misinformation, fear-mongering, spreading misinformation, and causing disruption to the economy of British Columbia, and worse. We are not fear-mongering, Mr. Speaker, nor are we spreading misinformation. I have just laid out the problem in plain English, and it is not unreasonable to want to understand how this government is going to deal with this very serious issue that is causing unsettling divisions among Canadians. Those divisions are not being caused by Conservatives, Mr. Speaker. They are being caused by a Liberal government that doesn't make all available arguments, hides their mistakes, and attacks anyone who asks them how they're going to fix it. British Columbians bought their homes in good faith. They are trying not to lose them in face of the rising cost of everything and an economic crisis already made worse by government. What is perhaps most frustrating for the homeowners that I talk to is that there will be no clarity on these issues anytime soon. We are staring down months, if not years, of litigation while the courts sort this out. The order itself has not been fully finalized. A 513-day judicial record still has to be assembled. Preliminary motions have to be heard before the appeal can start, including numerous intervenor applications and a motion to reopen the case by landowners who claim they should have been involved from the beginning. The Justice Minister has indicated that Canada is supporting that application, which will make the case drag on even longer if granted, and I can't help but wonder if they're doing so in part because reopening the trial might get them that actual do-over. This is one of those cases where the process has process, but we got here through a complete failure of political leadership. The government knew this decision was coming. They knew there were more court cases coming. They yielded the field 8 years ago. But they've avoided doing the hard work in that time of creating a clear legislative policy and framework around reconciliation, Aboriginal title, private property rights, and legal certainty. Instead, they left it all to the courts to be sorted out piecemeal through massive and voluminous constitutional litigation while they stack the court with activist judges. Long trials may work for lawyers billing by the hour, but it does not work for families trying to buy a home, businesses trying to invest, or First Nations trying to build a stable future. Reconciliation requires clarity, fairness, and predictability for everyone. We need a government that is willing to find real solutions instead of continually asking the courts to do their job for them. I hope that all members of this House will support our Opposition Day motion, and in particular, our call for a special multi-party committee to study all legal, constitutional, and political steps that can be taken to protect private property rights in Canada. Indigenous and non-Indigenous Canadians alike need us to work together to come up with solutions to government incompetence on this file. The ship needs to change course, Mr. Speaker, because it's currently headed for the rocks. Thank you.
Questions and comments. Question commentary. The Honourable Parliamentary Secretary, the Minister of Environment and Climate Change.
Thank you, Mr. Speaker, and I thank my colleague, who I have much respect for, from Nanaimo territory, for her speech. She did mention that this government failed to negotiate a treaty with the Cowichan tribes. However, the Chemainus tribe, who's a part of the Cowichan tribes, dropped out of the treaty process in 2014. Who was in government at the time in 2014? So I just want to ask, I mean, we try to negotiate on this side. They go to court. These sorts of things happen. Then they criticize negotiations on government-to-government level. What are we supposed to do? What's their solution to either negotiating with First Nations or going to court? Because they're saying both don't work.
I'm a member for Nanaimo, Lady Smith.
I spoke about the negativity that comes across the aisle when we ask questions and raise issues, Mr. Speaker. Stephen Harper delivered the residential schools apology in this House. A Conservative government led by Prime Minister Stephen Harper created the Truth and Reconciliation Commission, which resolved hundreds of specific claims, extended human rights protections on reserve, and introduced reforms aimed at improving accountability and transparency for Indigenous communities. Were there disagreements? Absolutely. Were there tensions? Of course. But reconciliation is not advanced by pretending that nothing meaningful happened before 2015. Some of the most significant steps towards acknowledging historical wrongs and building new relationships with Indigenous people happened under Conservative governments. And when you ask what we want to do about it, we have proposed that all parties, that parties get together, that we form a special committee, and that we work on this together because we owe it to Canadians, Indigenous and non-Indigenous alike, to make progress on this file.
Questions and comments. The Honourable Member for Winnipeg Centre.
Thank you so much, Mr. Speaker, and I agree with my colleague that the Liberals have been sitting on this. And in terms of spreading disinformation and paranoia, I do agree with the Liberals on that, absolutely, and I would liken the behavior, the same behavior that's being perpetrated by the Liberals. So it's like, I don't know why they're calling that name when they're doing exactly the same thing. But to my question, we know property rights are protected, but also constitutional rights, and that includes Section 35 of the Constitution, which affirms and recognizes that Aboriginal rights and title are not secondary rights. We've taken an oath of office, all of us in here as members of Parliament, to uphold the rule of law, and that means the Constitution. The Conservative motion that has been put forward suggests that we should not respect the Constitution. Now, I'm not just talking about the Conservatives. The Liberals are playing the same game. Does my honourable colleague respect her duty as a parliamentarian to respect and uphold our Constitution and the rule of law, yes or no?
The honourable member for Nanaimo, Ladysmith.
Mr. Speaker, I have to admit I'm confused by the honourable member's question. Of course, we respect the Constitution, and everything that I have stated and in this speech, there's nothing in it that suggests that I want to do anything other than uphold it. Our proposal is to create a special committee. It is to work together. It is to find a way through this. And the reason that I support that proposal is because I believe in reconciliation. I believe in creating certainty. It is important for all Canadians, and I hope that the member will work with us to move this forward in a way that is good for everyone. Thank you.
Questions and comments? The honourable member for Aurora Oak Ridge is Richmond Hill, about 35 seconds.
Thank you, Mr. Speaker, and I want to thank my esteemed colleague for that absolutely excellent speech. My question is simple, Mr. Speaker. Anytime we make a very thorough, good explanation, we ask questions of the government, we hear them get up and go back 15 years ago, 10 years ago, refer to other places, the other governments that were here, other prime ministers. Does she think it's an effective way or a responsible way for a government to respond to members of the opposition who have a right to question in this House, who have a right to try to make suggestions to make legislation better?
Member for Nanaimo, Ladysmith, about 40 seconds.
Thank you, Mr. Speaker. I mean, look, I tried to stick to some pretty boring, cold, hard legal facts in my speech. There are, unfortunately, this is a very complicated case. It has been made more complicated by decisions, litigation decisions that the government made in this particular case. It's been made more complicated by litigation directives that quite frankly, don't make sense to many Canadians. And if we're going to move forward on this, we really need to be thoughtful, we need to be collaborative, and we need to walk alongside Canadians of all kinds in negotiating real solutions to these problems.
Resuming debate, reprise du débat. I'll call on the honourable member for Similkameen, South Okanagan, West Kootenay. I'll just let her know that she'll have about 3 minutes before I have to interrupt her. The honourable member.
Mr. Speaker, I rise to speak to an issue of great concern to every British Columbian, the impact of the BC Supreme Court decision in Cowichan Tribes versus Canada and its effect on private property rights across British Columbia. It is the first time in Canada's history that a court has declared Aboriginal title over non-Crown lands, privately owned lands. 150 private landowners, farmers, homeowners, and businesses in Richmond discovered that their titles were now in conflict with Aboriginal title designation. This is not a matter of reconciliation. It is a matter of confusion. It creates tension. It does not create a path forward. We have seen that the Business Council of British Columbia conducted a survey of its members on the current uncertainty regarding BC property rights and found that 98% of respondents are very concerned. Not a little, very concerned. We have already seen financing for job-created projects, including those for Indigenous communities, pull back. Reconciliation remains the goal of every British Columbian I speak with, whether they have called their province home for a few years or for a few millennia. Let's not forget that our Indigenous peoples own huge swath of private property in British Columbia. They too are left in confusion by Cowichan. Our province wants to prove that the stewardship of British Columbia's many Indigenous communities, both on their lands and in many projects of prosperity they are engaged in, can be a model for the nation. So what we are not calling for today is for the government to appeal this decision. as they have already and rightly said they will do so. What we're asking for is the federal government to engage with British Columbia straightforwardly throughout what will likely be a long judicial process. Engage with British Columbians who are confused as to whether their private property is still theirs in full, and whether their property rights, a long and ancient feature of our legal traditions, stretching back centuries, are still theirs. Decry those who use an error of the court to spread hate, but seek to understand those who don't know if their home, business, or property in their name will remain theirs. The decisions of courts will not be swift. Uncertainty will persist so long as Ottawa remains in court and Victoria remains deadlocked. A very real and local example of this uncertainty is occurring in my riding in the community of OK Falls.
I'm going to interrupt the honourable member, and she'll have about 7 minutes remaining following question period today. Order. Following discussions among representatives of all parties in the House, I understand there's an agreement to suspend the sitting until 2:00 p.m. Therefore, this House is suspended to the call of the chair.
Déclaration de député, the honourable member for Winnipeg Centre.
Thank you, Mr. Speaker. Workers from across Canada are supporting the NDP's Bill C-247 to uphold workers' right to strike and repeal Section 107 of the Canada Labour Code. The Liberals have repeatedly used this undemocratic law to shut down strikes and undermine workers' fight for fair, livable wages. At Air Canada, the Liberals sided with CEOs and used Section 107 less than 12 hours after flight attendants began their strike against unpaid work. This affected workers everywhere. Today, cabin crew representatives from CUPE told me that in over 7 months of bargaining with WestJet, they are concerned the use of 107 may discourage management from coming back to the bargain table, believing the government will shut down any future strike. This is unacceptable. New Democrats stand shoulder to shoulder with all workers, whether at airlines or rail lines or in the public service or the postal service, telling this government, stop the attack on the right to strike, pass.
The honourable member for Prescott Russell Cumberland.
Mr. Speaker, I rise today to highlight the growing importance of Canada's plant-based industry for our economy, our farmers, and our future. Across the country, producers are diversifying into plant-based proteins, creating new markets, strengthening supply chains, and adding value to Canadian crops. This sector is driving innovation, supporting rural communities, and positioning Canada as a leader in sustainable agriculture. I believe this growth must be built in partnership with producers, with practical, market-driven policies grounded in the realities of those who feed our communities. Finally, I'm delighted to acknowledge a distinguished delegation from Denmark, along with members of World Animal Protection Canada, who are visiting Ottawa this week and whose insights are advancing this important conversation. Thank you, Mr. Speaker.
The honourable member for Vaughan Woodbridge.
I rise to recognize something truly special happening in Vaughan Woodbridge. I recently launched a youth advisory council, and the response has been remarkable. Young people in our community are stepping up. They're showing up, and we're saying we care about the future of this country, and we want a seat at the table. That's exactly the spirit that built Canada, and that spirit is alive and well in Woodbridge. After more than a decade of Liberal government, our young people are worried. They're worried about crime in their neighborhoods, worried about the rise of artificial intelligence, and wondering what it means about the future and its impact on jobs. They look at this country and they wonder if the cultural fabric can still hold together. And many of them have stopped believing they'll ever own a home or raise a family in the community that they grew up in. That's not the Canada we promised them, and that's not the Canada we're willing to accept. Mr. Speaker, to every young person in Vaughan Woodbridge, I want to hear your voice. You deserve to be heard. Thank you, Mr. Speaker.
The honourable member for Charlottetown.
Mr. Speaker, May is Multiple Sclerosis Awareness Month, a time to recognize the strength and resilience of the nearly 90,000 Canadians living with MS, including many in my home province of Prince Edward Island. This week on Parliament Hill, representatives from MS Canada met with members of Parliament to advocate for a $15 million investment in MS research. This funding would help Canada continue working alongside international research partners toward what so many families are hoping for, a cure. To everyone living with MS, to caregivers, researchers, advocates, and organizations like MS Canada, thank you for your leadership and your perseverance. Together, we will keep pushing for better treatments, stronger supports, and ultimately a world free of MS. Thank you, Mr. Speaker.
The honourable member for Elgin St. Thomas, London South.
Food affordability remains a serious challenge for families in my community and across the country. Today, I want to recognize some of the unsung heroes meeting that challenge head on. Founded just 6 years ago by Jim and Jacinta Collins, Harvest Hands in St. Thomas has rescued more than $45 million worth of surplus food, nearly $20 million last year alone. What started in a small church space is now a major distribution center with a fleet of trucks and nearly 300 volunteers. Harvest Hands rescues unsold and surplus food from farms and producers and sorts and ships it out to more than 380 partner organizations, including food banks and shelters. To quote Harvest Hands, we are the trucks, the warehouse, the volunteers, the cold storage, the sorting tables, and the systems that move food at scale. Organizations serve the people. We serve the organizations. Harvest Hands is tackling food insecurity with compassion, dedication, and action. Thank you to the Collins family and every volunteer for making this possible.
The Honourable Member for Brome-Missisquoi. Mr. Speaker, today I'd like to share a heartwarming story with you, a story that took place right here in our community in Mansonville. It's the story of Vladislav and Yulia, two Ukrainians who arrived here in Canada in 2022 to rebuild their lives. Their journey hasn't been easy, complicated procedures, moments of uncertainty, but they never gave up, never. They held fast, and above all, they found a community that decided to stand by them. I'm thinking of Nexkimia, their employer, who was there for them throughout the process. I'm thinking of the Missisquoi Nord Volunteer Center and its director, Mabel Hastings, who welcomed them as if they were part of their own family. And today, what's beautiful is that Vladislav and Yulia can keep working, but they're also giving back in turn. They're getting involved. They're part of us. When we went to meet them, Mr. Speaker, there were tears, but above all, a great deal of gratitude. That's the Quebec and the Canada that we love, a community that sticks together and chooses hope. Thank you, Mr. Speaker.
Just a reminder to mind the noise level as colleagues read their statements. The honourable member for Calgary Skyview.
Mr. Speaker, with over 100,000 people expected to gather in Calgary this week, the Nagar Kirtan organized by Gurdwara Dasmesh Culture Centre stands as one of the most anticipated Sikh celebrations in our country. A powerful public expression of faith, humility, and principle of seva, selfless service to all of humanity. Led by President Harpal Singh Grewal, the DCC has built a legacy of service that extends far beyond celebration. Through their No Hungry Tummy initiative and food bank operations, they feed thousands of Calgarians facing food insecurity, regardless of background, belief, or faith. DCC reminds us that true faith is expressed not only in prayers, but in action, showing up for neighbors in need. I invite all members in congratulating Director of Operations, Raj Sidhu, the entire DCC committee, volunteers, and Sikh community of Calgary on this joyous occasion. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh.
The honourable member for Mount Royal.
Mr. Speaker, I rise today regarding a deeply troubling complaint filed with the Canada Revenue Agency and targeting 11 Jewish schools in Montreal and Toronto. These schools are essential pillars of Jewish life in Canada. They exist to teach language, history, culture, and identity, just as faith-based schools across this country do. For months, there has been a coordinated effort to mischaracterize Jewish schools, to strip them of funding, and to undermine their place in Canadian society. Let me be clear. Attacking Jewish schools or Jewish day camps is a direct attack on Canadian Jewish life. And the CRA must be unequivocal that it will not allow tax laws to be weaponized against any group. Jewish schools in this country have already faced serious threats, including repeated gunfire attacks. All Canadians have a right to be safe and feel safe. This includes Canadian Jews, and this includes Canadian children. I hope all members of this House will join me in denouncing these attacks on Jewish community institutions.
The honourable member for Regina Wascana.
Mr. Speaker, every third Thursday in May, we celebrate Vyshyvanka Day. This year marks 20 years of this tradition in Ukraine and 10 years here in Canada. What began as a student initiative at Chernivtsi University has grown into a global celebration of Ukrainian heritage, identity, and resilience. This Vyshyvanka Day, more than 4 years into Russia's illegal invasion, we are reminded that this symbol has endured centuries of attempts to erase the Ukrainian people, both physically and as a nation. Like every stitch of a Vyshyvanka, every act of support matters. Canada must continue to step up by providing the military support that Ukraine needs and by dramatically increasing our energy exports to displace the Russian resources that are financing this war. On behalf of Canada's Conservatives, I reaffirm our unwavering commitment to stand with Ukraine until victory. Happy Vyshyvanka Day and Slava Ukraini!
The honourable member for Jonquière. Mr. Speaker, today I want to talk to you about quite a man, Mr. Gérald Savard, mayor of the municipality of Bégin for nearly 30 years. He's part of a long line of public servants, indeed, like his father and grandfather. He has dedicated his life to serving the people in his municipality. Gérald has also served as prefect of the Fjord du Saguenay RCM for 13 years, during which time he was deeply committed to the development of our region. Gérald often speaks of Lucien Bouchard, who once told him that to succeed in politics, you have to love people and show courage. I can assure you that in this regard, Gérald has distinguished himself since the start of his career through his love for the citizens of Bégin and his sincere interest in the people of our region. And today, I especially want to highlight Gérald's exemplary courage and perseverance. Despite a diagnosis of incurable cancer, he continues to serve as mayor with the same passion and dedication we've known him for over the last 30 years. On behalf of our community and with the utmost respect, I extend my sincerest congratulations to him for an exceptional career.
The honourable member for New Westminster, Burnaby Mallardville.
Mr. Speaker, today many of us in this chamber wear a Vyshyvanka, a symbol of Ukrainian heritage and resilience that has endured through some of history's darkest moments. For Ukrainian Canadians, these embroidered shirts carry identity and the stories of generations who held on to their culture through hardship and persecution. Canada is home to one of the largest Ukrainian communities in the world outside of Ukraine. For more than a century, Ukrainian Canadians have helped shape our country. These roots also exist in my own family. My grandfather came from Ukraine after his family endured persecution under Stalin's regime. He came to Canada in search of freedom and opportunity, and he was always grateful to live in such a welcoming country that allowed him to give back to the next generations. Today, as Ukraine continues to defend its sovereignty and democracy, Canadians stand in solidarity with the Ukrainian people. To those celebrating, Happy Vyshyvanka Day. Slava Ukraini!
Heroям slava!
The honourable member for Similkameen, South Okanagan, West Kootenay.
Gas prices across Canada remain higher than they need to be, not just because of the war in Iran, but because of unnecessary federal taxes. The last time a barrel of oil cost $100 in 2014 under a Conservative government, and gas prices never reached their current levels. In Penticton and Oliver, gas prices are now $2 a litre, with communities like Castlegar, Grand Forks, Osoyoos, and Princeton over $1.90 a litre. We need to offer real relief for longer. Our Conservative plan would scrap all federal gas taxes, excise, GST, and fuel standard tax for the rest of 2026. We'd pay for this by ending liberal waste like their gun grab program. Uncertainty abroad does not mean Canada cannot be affordable and strong at home.
Hear, hear.
The honourable member for Whitby.
Mr. Speaker, families in my riding of Whitby are working hard, but rising costs are certainly stretching their budgets. This spring's economic update responds to that reality with action and tangible help that people can count on. It delivers a new federal benefit this year for almost $1,900 for the average family to help them with the cost of groceries, along with real relief at the pump, saving 10 cents a litre for daily commuters. It also protects families from unfair banking fees and helps workers keep more of their hard-earned paychecks through lower Canada Pension Plan contributions, while offering higher tax deductions for tradespeople who must relocate for work. It also accelerates over $7 billion in financing to build more homes faster and offers support to recruit, train, and hire up to 1,000 new skilled trades workers. For families and workers in my riding, it means a boost today and a bridge to a better tomorrow.
The honourable member for Calgary East.
Congratulations. Liberals turned Canada's economy into a buy now, pay later scheme. Canadians now finance their meals. Never before have you ever heard Canadians buying pizza in 4 separate installments. And the Liberals' only financial plan is to spend like crazy now, Canadians pay forever. This Liberal Prime Minister doubled Trudeau's deficit, added even more to the national credit card. More costs, more taxes, all on the heads of struggling families. No wonder Canada has the highest food inflation in the G7. 2.2 million Canadians in a food bank in a single month, and 1 in 10 Canadians are living in poverty. This is what happens when Liberals tax the farmer, the trucker, the grocer, the restaurant, then act shocked when the price of meals go up. Scrap the Liberal food taxes, stop inflationary spending, bring home affordable food for Canadian families. Because in Canada, feeding your family shouldn't be put on a line of credit.
The honourable member for Ottawa Vanier Gloucester. Thank you, Mr. Speaker. Today, I'd like to highlight the release of the white paper by the Réseau francophone d'enseignement à distance, a landmark document that charts a clear path for the future of French-Canadian distance education in Canada. Through solid recommendations firmly grounded in on-the-ground realities, REFAD highlights the systemic barriers that still hinder access to inclusive, high-quality education for Francophones and minority community. We're talking about more inclusive, fair, accessible systems for Canada. And I'd like to highlight the work of REFAD, the working group that have taken part in this essential work for the Francophonie in Canada. Thanks to these initiatives and the Government of Canada's commitment to official languages and accessibility, we are building a more inclusive Canada where everyone can have access to learning, regardless of one's reality or one's journey. Thank you very much, Mr. Speaker.
The honourable member for Haliburton, Kawartha Lakes.
Speaker, British Columbians are increasingly concerned about the security of private property rights. Following the Cowichan decision, many Canadians were looking for clear assurances from the federal government about the stability of fee simple ownership and the implications for homeowners across British Columbia. Instead, questions remain about the government's approach in court and about agreements reached with the Musqueam First Nation, which some homeowners and stakeholders believe have added further uncertainty. Conservatives believe reconciliation should proceed in a way that provides transparency, certainty, and fairness for all. We respect Indigenous rights. We respect the Constitution. We recognize the importance of meaningful reconciliation and the need to address historical wrongs. That's why Conservatives are calling on the government to provide greater certainty and clarity on how private property rights will be protected, to ensure future agreements give homeowners certainty, and to restore confidence in Canada's land title system.
The honourable member for Coquitlam, Port Coquitlam.
Mr. Speaker, I wish to inform the House that on Friday, April 24th, I was arrested by the Coquitlam RCMP. The crime? Drinking too much coffee while on house duty. Mr. Speaker, I pleaded guilty. I was cuffed for a cure. Cuffed for a cure is the lighter side of Cops for Cancer. The harder side is the cycling. Each year, officers across Canada cycle hundreds of kilometers, raising funds for life-saving childhood cancer research and supporting families facing the unimaginable. Their commitment reflects the very best of our community: compassion, resilience, and a deep sense of service. I encourage all Canadians to support Cops for Cancer and to help ensure that no child faces cancer alone.
Oral questions, questions orales. The honourable member for Long Range Mountain.
Canadians are broke, they're lining up at food banks, and our streets are more dangerous than ever. Yet this Liberal government has spent over $742 million on a failed gun grab, while in Newfoundland and Labrador, hardworking Canadians are choosing between gas for their trucks and heat for their homes. This Prime Minister is wasting nearly $25,000 per gun to target law-abiding hunters. It's more costs, more corruption, and more Liberal waste. So when will this Liberal Prime Minister cut the waste and cut the gas taxes so Canadians can afford to live?
Hear, hear. The Honourable Government House Leader.
Well, Mr. Speaker, of course, we've cut the gas tax by 28 cents, but this member from Newfoundland and Labrador gets up, and maybe we'll ask her, because we haven't really had success of late getting that list of things that they consider to be inflationary spending on that table. We have no idea what the Conservatives consider to be inflationary spending. Is it the child benefit? Is it employment insurance? Is it small craft harbors? Mr. Speaker, Newfoundlanders and Labradorians want to know.
The honourable member for Long Range Mountain.
Well, Mr. Speaker, to start, Conservatives would cut $20 billion in consultants. The failed gun grab is another example of the $1 trillion of spending by this costly Liberal government. The Prime Minister is more interested in $524,000 being spent on food for his private jet rather than making life more affordable for hardworking Canadians who actually pay the bills. More costs, more cover-up, more Liberal waste. This Prime Minister is just another costly Liberal. So when will this Liberal Prime Minister remove all the taxes on all the gases for all the year so Canadians can get real relief?
The Honourable Secretary of State, the Honourable Secretary of State for Financial Institutions.
Mr. Speaker, we're going to continue to focus on this side on affordability. We just launched a groceries and essentials benefit that will put up to $1,900 in the pockets of hardworking families. We just cut the excise tax, that's 10 cents. You combine that with the carbon tax cut, that's 28 cents. The spring economic update continued to confirm our economy is strong and growing. Mr. Speaker, on this side of the House, we're laser focused on building a strong economy. That side can continue with the rhetoric and the riddles. Thank you, Mr. Speaker.
The Honourable Member for York-Durham.
For weeks now, the Liberals have blamed external events for homegrown problems. Higher gasoline, blame Iran. Higher diesel, blame Iran. But yesterday, the CEO of Cenovus said it wasn't external events, but Liberal policies that were making resource development and investment in Canada uncompetitive. He said the industrial carbon tax incents industry to invest outside Canada. So Liberal policies equal higher costs and more debt for Canadians and fleeing investors. So will the Minister of Energy instead give Canadians a break, cut all the gas taxes for the entire year?
The Honourable Minister of Energy and Natural Resources.
Maybe he should read about what the CEO of Shell said. The CEO of Shell said Canada is the best place in the world to invest, and he just put $20 billion behind that statement, Mr. Speaker. And the CEO of Enbridge put $4 billion behind his statement. So maybe they should look a little harder in the paper, Mr. Speaker.
The Honourable Member for York-Durham.
Mr. Speaker, CBC is reporting that the Liberals will change the rules for resource development and pipeline approvals to allegedly try and speed them up. But forgive me, we've been here before. Last year, they promised big projects at speeds never seen before. If the minister was right, we'd have projects coming out of everywhere. But in that year, no project has been approved in the national interest. Nothing has been fast-tracked. Not one anti-development resource law or tax has been removed. It's beginning to feel a little bit like Alice in Wonderland, where the rule is pipeline tomorrow, pipeline yesterday, but never a pipeline today. So if that's not the case, will he tell us when the next pipeline will be approved?
The Honourable Minister of Energy.
Speaker, if he took the cotton out of his ears, he would have heard there was a pipeline being built from Taylor to Gordondale. He would have heard there was an expansion of the largest pipeline system in British Columbia. He would have heard there was $8 billion just being spent in Goose Bay. He would have heard there was $500 billion being spent on a new wood farm in Nova Scotia. He would have heard about the new transmission line between Nova Scotia and New Brunswick. I could keep going, Mr. Speaker. They should listen a little more carefully.
The Honourable Member for Montmorency-Charlevoix. After 11 years running Canada, the Liberals will have us believe that it's normal that the deficit is over $60 billion a year. While the Liberals squander billions, Quebecers are having to pinch every penny. A new Fraser Institute study has shown that Canada is going through a youth unemployment crisis. In 2022, youth unemployment was about 12%. It has climbed to 19%, something never seen outside a recession. When will this very Liberal Prime Minister finally start focusing on our youth's future when he makes decisions? The Honourable Minister of Government Transformation. Thank you, Mr. Speaker. I heard that question, and I certainly hope that the member across the way will support our spring economic statement, which will invest $6 billion over 5 years to train young people so that they can have job opportunities in fields like construction. We know there will be a great need for construction. Why? Because this government believes in building major projects, building the future of our country, and ensuring our economy is the strongest in the G7. The Honourable Member for Montmorency-Charlevoix. Let's talk about major projects. The Major Projects Office has already spent $41 million. They have not announced a single major project. Properties are losing value. There's no retail jobs. There's no jobs in food and dining. All the government has created are new taxes and new red tape. The government wants young people to make sacrifices, but they say affordability has never been so good. When will the Prime Minister stop running up charges on the national credit card and start making sure our youth have a future to look forward to? The Honourable Government House Leader. Mr. Speaker, my colleague has just noted all we are doing to invest in training so that our youth can enter the skilled trades. where they will find well-paying jobs. Meanwhile, Conservatives, including that member, are opposed to us getting major projects done. They are opposed to the Alto high-speed rail project, which will create 51,000 jobs in Quebec. They are against the $18 million of planes sold by, that were manufactured in Quebec. They are opposed to all that we are doing to help the economy. The Honourable Member for Saint-Jean. Mr. Speaker, today we learned that the Liberals have decided to speed up pipeline construction by cutting regulations. I guess there's too many rules. Why combat greenhouse gas emissions and ensure social acceptability when there's oil in the ground and money to be found? Regulations be damned. Conservatives are being edged out as the party that loves oil and gas the most. Soon, Liberals will be wearing I love oil and gas buttons on their lapels. Is there a single Liberal left who actually cares about the environment? And if so, what the heck are they still doing in that party? The Honourable Minister of the Environment and Climate Change. Mr. Speaker, I have said this once, I'll say it again. Our government is committed to continuing the fight against climate change and protecting the environment. We have a nature protection strategy which will invest heavily in the future of our country. We put in place methane regulations. This is something that people are looking at in other countries and saying, wow, Canada is showing leadership. We are doing our job, and I hope that the Bloc Québécois will join us. The Honourable Member for Saint-Jean. Mr. Speaker, I'm sure there are Conservatives just itching to cross the floor to the other side of the House. This Prime Minister is promoting the monarchy and the tar sands. Gosh, Conservatives must really recognize themselves in this Prime Minister. We get it. The Liberals believe that the future of Canada should be built on dirty 19th century fossil fuels. Sure, we know what we're up against, but I have a simple question. What are Liberals who still believe in climate change waiting for to leave that party? The Honourable Minister. So, I would assure the entire House that this government is committed to continuing the fight against climate change. We are putting in the work. We will continue to put in the work. Look at our automotive strategy. That is one way we will reduce greenhouse gas emissions, while creating jobs in the manufacturing sector. Look at what we are doing to protect nature. Look at the regulations we have put in place to regulate methane. Our greenhouse gas emissions will be reduced by 400 megatons. We are putting in the work, and we will continue to do so. The Honourable Member for Jonquière. Goodness gracious, Mr. Speaker. The Liberals have adopted Bill C-5 to speed up projects so-called in the national interest. C-5 allowed the government to exempt itself from legislation that would prevent pipeline construction. Now the government has yet another solution to speed up pipeline construction. They will just shred the regulations. If the rules are making it too hard to move oil through the ground, just throw out the rule book. Mr. Speaker, the Liberals themselves set the goal of reaching carbon zero by 2050. Do they understand that they have just caused themselves to wildly fail in that goal? The Honourable Government House Leader. Mr. Speaker, Quebecers understand that major energy projects can change economies. That's what Robert Bourassa understood. That is what we understood. Be it nuclear energy, wind energy, solar energy, renewable energy of any kind, and yes, unconventional energy. Our government will act. We will build major projects, but we will not stop there. We will invest in logistics projects like the Port of Contrecoeur and the Port of Saguenay, which my colleagues should know more about.
A shocking new report found that nearly 500,000 young Canadians were unemployed in 2025. That's a 57% increase in 3 years, and that's worse than the recessions of 1981, 1990, and 2008 for young people. Liberals ran over $1 trillion debt.
Unbelievable.
And they priced Canadians out of the housing market, the highest housing costs in the G7, and then loosened the foreign work restrictions and flooded the labor market. A decade of their support, and somehow every single door is closed for young Canadians. How is it that this government is locking young Canadians out of both the housing market and the labor market at the same time?
Unbelievable. The Honourable Secretary of State for Labour.
Canada's new government is fiscally responsible. We've reduced the deficit by $11 billion. We're in the strongest fiscal percentage of the G7. Wow. Mr. Speaker, we're making investment in major infrastructure investments that are transform and connect our economy. Amazing. Our workers know this, Mr. Speaker. Let's hear from our workers. Let's hear from the UA that's in that member's riding. This update delivers investments to expand training and a multitude of apprenticeship needs. It will increase youth, Indigenous and diverse participation in the trades for upcoming projects of national interest. Mr. Speaker, that's how you build a Canada strong for all.
Honourable member for Thornhill.
Despite all of that rhetoric, despite the $1 trillion in Liberal debt, young Canadians now make up over a quarter of all unemployed workers. That's double their share of the workforce, and they still can't afford a home. They still can't afford groceries, and they still can't afford to get ahead. Right. They are borrowing record billions on the national credit card to stimulate the same economy that they are cooling with record immigration, and they handed the bill to Canadians for all of it. At what point does any Liberal take responsibility for an entire generation that is priced out, crowded out, and left holding the bag for their incompetence?
The Honourable Secretary of State.
Again, this new government is fiscally responsible. We reduced the debt by $11 billion, the deficit by $11 billion, and we are in the strongest fiscal position in the G7. Mr. Speaker, the Conservatives, though, can't stand up and say they support Canadians while voting against all the supports that Canadians rely on, including youth. Mr. Speaker, they oppose tax relief, they oppose child care, they oppose dental care, the school food program, and national school food program. Who could be against that? So, Mr. Speaker, my question is, you can't oppose all of that, then claim you support it. You cannot have it both ways. So my question, Mr. Speaker, is when will they table their list of inflationary spending that they're going to cut?
The Honourable Member for Oshawa.
Mr. Speaker, young Canadians are working hard, getting an education, and trying to build a future. But after 11 years of costly Liberal policies, they are still struggling to find good jobs. Yeah. Fraser Institute reports youth unemployment has surged to almost 19%, with young Canadians unemployed longer than at any point since the records began. When will this Prime Minister stop being just another costly Liberal and end his credit card budgeting so young people in Oshawa and across Canada can afford to work, eat, and get ahead?
Yeah, well said. Well said.
Honourable Member, the Honourable Minister for Housing and Infrastructure.
Thank you, Mr. Speaker. Well, I had the honour of being at BCIT, the BC Institute of Technology, earlier this week to talk about 100,000 jobs for young Canadians building homes and infrastructure. And the members opposite have an opportunity to support the spring economic update that dedicates $6 billion for training young Canadians to be part of our economy and to build the affordable housing that we need to house the young Canadians. Mr. Speaker, it's a great opportunity for us to build Canada strong. Thank you.
Honourable Member for Oshawa.
Mr. Speaker, when will these Liberals realize that they keep having to create these support programs because they created the crisis in the first place?
Right.
And get this, even with these programs, young people are still worse off than ever before. So clearly, they don't work. Under this Prime Minister, Canadians are seeing the same old Liberal agenda we saw under Justin Trudeau, only worse, with more costs, more taxes, more debt, more on the national credit card, more of the same. Why are Liberals forcing young Canadians to pay the price for their failures?
Here, here. Well said. Well said.
The Honourable Parliamentary Secretary to the Minister of Finance.
Speaker, I understand the member opposite's concern for our youth, and I empathize with our youth, but what I can't understand is how that member from Oshawa can go and visit Ontario Power Generation and see the jobs that are being created in our region with the new nuclear project at Darlington. That's 21,700 jobs and a $2 billion investment through this government's efforts that she voted against. How can she stand here and lecture us about youth jobs in our region and our country and vote against the very supports that are creating good, skilled, trained jobs across our region?
The Honourable Member for Richmond Hill South.
After a decade of
costly Liberal credit card budgeting, young Canadians are facing more costs, more taxes, more debt, more of the national credit card, and more of the same. This Prime Minister is just another costly Liberal who has surged youth unemployment beyond recessionary levels. Since 2022, youth unemployment has surged from 12.3% to 18.9%, and young Canadians are remaining unemployed longer than at any point since records began in 1976. Liberal labor and immigration policies are driving up the cost of rent, groceries, and homes for young Canadians. When will this Liberal Prime Minister end his costly credit card budgeting so young Canadians can afford to eat, work, and live?
The Honourable Parliamentary Secretary to the Minister of Industry.
Thank you, Mr. Speaker. Our plan is investing in jobs and is supporting those private sector innovators that are bringing jobs, including to places like York Region in the members region, where AMD has a major facility there where they're centralizing their innovation supports in York Region, in Markham, bringing thousands of jobs. I recently visited the University of Toronto's Masters of Applied Science and Computer Science program, and every single one of those graduates now has a job in that program. It's because of the work that our government is doing, supporting the post-secondary system, supporting not only the industrial side, but the technology side. We're very proud of our record.
The Honourable Member for Sherwood Park, Fort Saskatchewan.
Mr. Speaker, objectively, their so-called plan is simply not working. Conditions are extremely difficult in this country for youth and for young families. The Liberals' $1 trillion of debt means less growth and fewer jobs, especially for those just starting out. Credit card budgeting, high taxes, poor immigration policy, these have all contributed. We see more costs, more taxes, more debt, more on the national credit card, more of the same. This Prime Minister is just another costly Liberal with no results to show for this way. So when will Liberals reverse policies that are objectively not working so that young people can get back to work?
The Honourable Parliamentary Secretary.
The International Monetary Fund has affirmed, Mr. Speaker, as we know, the sound fiscal framework that the government has embraced. That is also true of the key ratings agencies. But my colleagues keep talking about a credit card. Yes, there are Canadians, young Canadians included, who do have credit card debt. They want to make it worse, Mr. Speaker. They want to make it worse by forcing them to not receive the Canada Child Benefit, to not receive support for childcare, to not receive support for the school food program. They want them to pay for it. In this country, we believe that government has a role in fundamentally making sure that Canadians have a chance. That's exactly what these programs do.
Member for Sherwood Park, Fort Saskatchewan.
Mr. Speaker, this government has $1 trillion of credit card debt, and they keep telling us that everything is fine. Everything is not fine, but in the midst of this environment, Conservatives are offering constructive proposals to support youth and young families who are struggling. In the fall, we announced the Conservative Youth Jobs Plan. Just today, we announced big new ideas to reform parental leave to make it easier to start and grow a family. Now, instead of doubling down on more of the same failure, will Liberals listen to and support the big ideas that we're putting forward to help young people and families finally succeed?
The Honourable Minister of Jobs and Families.
Here's a big idea, Mr. Speaker. Don't vote against childcare that's saving families in Saskatchewan thousands of dollars a month per child. One of the most effective measures to make sure that young families get ahead, that women can participate in the workforce, that women's productivity and wages grow along with their career, that CPP enhancements are there for women at the end of their career. You know what? Instead of these big ideas, Mr. Speaker, maybe stop voting against the big ideas that Canadians have fought so hard for.
The Honourable Member for Repentigny. Mr. Speaker, Radio-Canada has just broken the news that the Liberals are about to scrap the entire pipeline regulatory framework. They already passed Bill C-5, which suspends virtually all federal legislation. But no, that wasn't enough for them. Now they want to limit all pipelines to a single environmental assessment, the federal assessment, which always gives a green light. Now they want to restrict consultation. So say goodbye to the Quebec consultation process, say goodbye to grassroots engagement, and say hello to climate change. Is this truly why Quebec Liberals ran for office? The Honourable Minister of the Environment, Mr. Speaker. I will repeat myself once more. Our government is absolutely committed to fighting climate change and protecting the environment. Looking internationally, we are global leaders when it comes to climate funding. Domestically, we are investing in a clean electricity grid It is so important to reach carbon zero. This is so important to our future. They are complaining while we put in the work to fight climate change. The honourable member for Repentigny. Mr. Speaker, this is ridiculous. Liberals are planning to fight climate change with pipelines. According to Radio-Canada, later this week, Liberals will announce that they are scrapping the pipeline regulatory framework. And talk about timing, because Danielle Smith is coming to town tomorrow for her far-right family reunion. Who would have thought that the Liberals would get a standing ovation from Preston Manning's far-right think tank? What's funny is that for months now, the Liberals have been trying to cobble together a majority one floor crossing at a time. Wouldn't it have been easier for them to just merge with the Conservative Party? The Honourable Government House Leader. Mr. Speaker, we know that transportation represents 20% of our greenhouse gas emissions, a significant amount. Now, our government is proposing a solution, a high-speed rail project, which will cross Quebec. It will be 1,000 kilometers long. It will get people from Quebec City to Toronto in 4 hours. The Bloc Québécois is opposed to this project. They are opposed to this major environmental project. How come the Bloc is opposed to the best thing we could possibly do to protect the environment, get Quebecers moving? How come Quebecers are opposing environmental policy? The honourable member for Lévis-Lotbinière. Mr. Speaker, with this illusion of a prime minister, it's more of the same. Everything costs more costs, more taxes, more debt, and the national credit card is maxed out. Mr. Speaker, the average Canadian family is spending $4,000 a month just to live another day under this Liberal government. What was once a dignified wage is now barely enough to survive on. How do they expect Canadians to make ends meet under this illusion of a prime minister? The Honourable Minister of Government Transformation. Thank you, Mr. Speaker. You know what used to be more expensive for 19,000 Canadians? Dental care. But the Conservatives are opposed to our dental plan. People used to put off dentist visits because they couldn't afford it. Not anymore. These Conservatives also want it to be more expensive to raise a family because they're opposed to the groceries and essentials benefits that 12 million Canadians will receive. Thank you, Mr. Speaker. The honourable member for Lévis-Lotbinière. Mr. Speaker, yeah, talk is cheap. But you know what isn't cheap? $2 a litre gasoline, $2,000 a month for a 2-bedroom, $17,000 a year to feed a family of 4. Mr. Speaker, we saw how bad things got this morning when a new liquidation-style grocery store opened in Granby. The police were called in to manage the line of people lining up for food at 5 o'clock in the morning. The situation is desperate. The national credit card is maxed out. When will this Liberal Prime Minister finally take the issue seriously? The Honourable Minister. Talk is cheap? Is dental care cheap? Is support for 12,000 families in his riding cheap? People in his riding depend on our government measures. On June 5th, millions of Quebecers will receive our groceries and essentials benefit. They will receive the assistance we need because here, on this side of the House, we believe that prosperity ought to be inclusive. The honourable member for Chicoutimi-Le-Fjord. Mr. Speaker, $1.475 trillion. That is how much the Liberals have charged to the national credit card. Because of Liberal debt, seniors are being forced to choose between groceries and prescription medication. Young families are not able to afford a first home. Despite the illusions, this Liberal Prime Minister is more of the same. He is just another costly Liberal. When will the government stop governing for bankers and start governing for everyday Canadians? The Honourable Secretary of State for Nature. Mr. Speaker. That's an important question. Over and over, the Conservatives talk about illusions. Canadians are not receiving illusions in my riding. They are receiving real benefits. The groceries and essentials benefits is not an illusion. It is over $1,800 over a year for a family with 4 kids. These families will receive that money in just a few days. They will see that it is a tangible support, because that's what we do on this side of the House. We help Canadians in the short term and invest over the long term.
The Honourable Member for Chicoutimi-Fjord. Mr. Speaker, this question is important. If the Liberals really want to help families and seniors, well, they should start by closing the open bar in Ottawa. The Prime Minister is being irresponsible with Canadians' money. Interest on Liberal debt is costing more than $53 billion this year. That's money that isn't going to seniors, it isn't going to families, and it isn't going to public services. Well, Canadians have to cut back everywhere just to get by. Why does the Prime Minister refuse to cut red tape and cut unnecessary spending? The Honourable Secretary of State for Nature. Thank you, Mr. Speaker. Well, I'll continue with things that aren't illusions for Canadians. The Canada Child Benefit. $8,000 per child per year. That's major. It's useful. Canadians are seeing the results because we are going through a difficult time. I just talked about groceries. The dental care benefit. Almost 18,500 people are saving up to $800 a year. That's the reality, and that's without counting everything that we're doing with major projects, because we need to invest for the long term. Thank you.
The Honourable Member for Airdrie-Cochrane.
All veterans get from this Liberal government are excuses and cuts. The Liberals slashed billions from veteran services, leaving veterans facing longer wait times and fewer supports. And now they're covering up the fact that the housing minister hid $3 million they cut from homeless veterans, claiming they couldn't find any. Unfortunately, there's thousands of homeless veterans in this country, and rather than covering up these cuts, why didn't they spend their time trying to find veterans they could help? So why does this Liberal government always seem to find money for Liberal insiders, but never for veterans who fought for our country?
They're here. The Honourable Minister of Veterans Affairs.
Mr. Speaker, I thank my colleague across the way for the question and the opportunity to clarify that there has been no cuts to services and benefits offered to veterans.
That's right.
We continue to ensure that veterans have access to the services and benefits which allow them to be successful in their post-service life.
The Honourable Member for Sarnia-Lambton-Bequidgewinong.
Mr. Speaker, I'm proud to be part of a government that's committed to defending Canadian trade and ensuring our businesses are not overly reliant on any single market. By opening doors for exporters and supporting small businesses to reach customers around the world, we're strengthening our economy and creating more opportunities in my riding of Sarnia-Lambton-Bequidgewinong and across the country. Could the Minister of Women and Gender Equality and Secretary of State for Small Business and Tourism update this House on the historic progress we've made to diversify Canadian trade?
The Honourable Minister of for Women and Gender Equality, Small Business and Tourism.
I thank the member from Sarnia for her small business advocacy. Mr. Speaker, I've got good news. We don't just have one, we have 2 new trade agreements that have made law with the United Kingdom and Indonesia, Mr. Speaker. Together, these agreements are going to boost our trade ties and give Canadian businesses access to markets that more than 340 million people. That means new customers for our exporters, new opportunities for our small businesses, and more good-paying jobs in this country. Mr. Speaker, that is how you build Canada strong.
Honourable Member for Calgary Centre.
Mr. Speaker, the Minister of Defence signed a $200 million contract for access to a spaceport that the company itself leases for just $14,000 a year. That's $20 million a year for a decade. Worse, the contract is backdated by a full year when no lease was being negotiated, while the company's own auditor warned it may be bankrupt. After the deal was signed, the company's stock surged, and a well-connected Liberal insider cashed out for millions. Will the Minister explain how this is not another multi-million-dollar boondoggle, rewarding friends while taxpayers carry all the risk?
The Honourable Minister of National Defence.
Needless to say, Mr. Speaker, the premise of the question is frankly stupid.
Mr. Speaker, establishing Canadian sovereign space launch capabilities will drive billions in investments. It's going to create good-paying jobs. It'll increase Canada's sovereignty. It'll reduce our reliance on the United States. And it's going to support a commercial space launch and re-entry industry that can be worth up to $40 billion. That's what we're investing in. These are the essential capabilities that protect Canada and create massive economic benefits for Canadians, coast to coast to coast.
The honourable member for Calgary Centre.
Let me explain stupid to the minister. He gifted $20 million backdated to a company on the brink of bankruptcy. The company's chairman, someone with a history of securities infractions, made millions on a quick pump and dump sale of shares. The lease the taxpayers are paying for is nowhere in the company's previous regulatory filings. The company's Liberal insiders met with officials 158 times. Someone's going to face the music here. Will it be the Liberal insiders who are stuffing money into their jeans, or the minister who signed this god-awful document?
Exactly. The Honourable Minister of National Defence.
Mr. Speaker, you know, the interesting thing about all this commentary coming from the other side of the floor is this. Every single measure put forward to strengthen the Canadian Armed Forces, every single investment in housing, in equipment, in munitions, right? In our bases, in our housing stock, every single one, pay increases, all opposed. I'm not sure, Mr. Speaker, what these people stand for anymore, but it's becoming very apparent to the ladies, the women, the men of the Canadian Armed Forces.
The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
The Liberal government spent $300 million on the failed Prescribe IT program that had less than 5% uptake. Now that it's being scrapped, we've learned that the CEO responsible for this failed scandal-plagued program was being paid $900,000 per year. And when Conservatives looked to have the minister testify at committee, Liberals blocked it. So will the minister stand today and explain to this House the justification for paying this CEO $900,000 while Canadians are lined up at food banks?
The Honourable Minister of Health. Thank you, Mr. Speaker. Listen, the situation with the CEO of that company is indeed unacceptable. As you know, this is a company that is not directly under Health Canada. However, I spoke with the board and corrective measures have been taken, and I can assure the member of the opposition that I am on this file and that I'm doing everything in my power to clarify all of the problems.
The honourable member for Leeds, Grenville, Thousand Islands, Rideau Lakes.
Well, let me clarify some of the problems for the minister. They spent $300 million on a program that didn't work and wasn't used, and they oversaw the CEO being paid $900,000. And they don't seem to want to agree to have the Auditor General review this scandal-plagued program, and the minister doesn't seem to want to come to committee to face questions about it. So, will the minister stand up today and commit to having the Auditor General review this program in detail and report findings to this House, and to come before committee to testify about this failure?
The Honourable Minister. Thank you, Mr. Speaker. I take the committee's work very seriously, the Health Committee, and I will come back to the Health Committee at a later date. As I have said, we have taken action. We spoke with the Board of Directors, and they have taken measures to revoke the person who is responsible for the company. I continue to work on the file, and I will take the necessary steps.
The honourable member for Moose Jaw, Lake Centre, Lanigan.
Mr. Speaker, airshow organizers across North America are quietly being told that this is the final season of the iconic snowbirds. I wrote the Minister of National Defence almost 6 months ago asking about the future of the snowbirds. No reply. Senator Batters did the same in the Senate. Crickets. Tomorrow is the Snowbirds acceptance show in Comox. Why won't the Liberals come clean about their decision to cancel the iconic Snowbirds, and when will they reverse this terrible decision?
The Honourable Minister of National Defence.
Mr. Speaker, the RCAF's fleet of Tudor aircraft was first introduced in the 1960s, and the fleet will reach its end of life in the coming years. The member knows this. The Snowbirds will continue air demonstrations with the Tudor fleet for as long as it is feasible and safe. The member knows that as well. And the Snowbirds remain committed to their performances. As we've stated, we're beginning the process of examining potential aircraft options for the Snowbirds mission once the CT-144 Tudor fleet reaches its end of life. Thank you.
The honourable member for Moose Jaw Lake Centre Lanigan.
Mr. Speaker, jet noise is the sound of freedom, not white noise. Canadians want to be inspired by other Canadians. Do you know how we got the second female Snowbird pilot? Because a flame was planted in her heart when she, at the age of 12, she saw the first female Snowbird pilot. Why are the Liberals hiding the fact that they plan to cancel the Snowbirds after the season, and why won't they immediately reverse this terrible decision? It's SOS time, Mr. Speaker. Save our Snowbirds.
The Honourable Minister.
Mr. Speaker, I share the member's concerns about the future of the fleet. It's an iconic part of Canadian culture. He and I would agree. But here's the difference. Here's the difference. This member surely can't be suggesting he's going to put the pilots, the women and men of that fleet, in harm's way. Have him stand up, Mr. Speaker, make it plain that he intends to have pilots flying planes that should not be flown under mechanical watch today. Have him explain that.
The honourable member for Yorkton Melville.
Under this Liberal government, our Canadian forces' morale has been attacked, traditions erased, and attrition has become highly damaging to our capability to defend Canada. Canadian Forces Snowbirds must continue to be the souls of our Canadian military. They exude Canadian pride and international reputation for expertise, precision, and high standards that have given our allies confidence in us in the past. Will these Liberals do the right thing? Save our souls, save our Snowbirds.
Yeah. The Honourable Government House Leader.
The Minister has spoken very eloquently about our need to be the adults and be responsible and to keep our pilots safe. And that's exactly what we're going to continue to do. But the temerity, the gall of Conservatives to stand in this House, the 0.99% of GDP crew here talking, giving lectures, will take no lessons on defense spending, on defense investments, on investments in our veterans, on investments in our armed forces, and equipping our men and women in uniform from those Conservatives who starved them.
The honourable member for Saskatoon South.
SOS, Mr. Speaker, save our Snowbirds. The Snowbirds are a proud Canadian institution based in the land of the living skies, Saskatchewan. We now hear the Liberals are going to cancel the Snowbird program. It is unthinkable that we could see the end of this precision squadron that proudly represents this country at home and abroad. Will these Liberals reverse this mistake and keep our Snowbirds in the sky?
The Honourable Minister of National Defence.
Mr. Speaker, let's be clear here. Surely these members...
I really want to hear this. I really want to hear this. The Minister should... the Minister can start over.
Thank you, Mr. Speaker. Mr. Speaker, surely the members on the opposite side, including those who have distinguished service in the Canadian Armed Forces, they are not suggesting that we continue to put the pilots of these aircraft in, frankly, harm's way. They know these planes have got to be replaced. They know this assessment's ongoing. And lest I...
It's still too noisy. Still too noisy. Still too noisy. Does the Minister have more to say? Or okay. Okay, well, pardon? I know, I can't hear either. So the Minister, now that it's a little quieter... now that it's a little quieter, Now that it's a little quieter, or just a little bit quieter. Yeah. Before, everyone in the House was calling for quiet. The Honourable Minister of National Defence may continue.
Thank you, Mr. Speaker. We'll try again. Mr. Speaker, as my House Leader colleague was saying just a moment ago, it's a bit rich. For a party that had funding for the Canadian Armed Forces and Defence below 1% of GDP, like really, honestly, Mr. Speaker, stand up, join us as we reinvest in the women and men of the Canadian Armed Forces.
The Honourable Member for Charlebourg-Saint-Charles. Mr. Speaker, if you think about one symbol that unites all Canadians from coast to coast to coast, it's the snowbirds. But now, for 4 questions now in a row that the Minister of Defence has gotten from my colleagues, and all he can say is, we're putting our pilots' lives in danger. And, what have they done for 11 years? It seems like we've known for a long time something has to be done, and now the snowbirds are in danger. What does the Minister have to say to that? The Honourable Minister of National Defence. Mr. Speaker, here are the facts. The Tudor aircraft fleet was put into service in the 1960s, and it is coming to its end of life in the coming years. The member knows it. He's known it for a long time. The snowbirds continue with demonstrations with the Tudor flight, and they will continue to do so as long as possible and as long as it's safe. The snowbirds are determined to continue with their performances. The member knows that. We continue our good work. The Honourable Member for Beauport-Limoilou. Mr. Speaker, yesterday marked a historic moment. For the first time, 2 international trade bills received royal assent on the same day. These 2 agreements with Indonesia and the United Kingdom provide for the gradual reduction of many tariffs, with the aim of improving market access and the competitiveness of our businesses. As the Member of Parliament for Beauport-Limoilou, I know that this trade diversification is essential for Quebec City's small and medium-sized businesses and workers. Can the Quebec Lieutenant explain how these agreements will help SMEs in Quebec City and across the country grow, export, and create good jobs here at home? The Honourable Government Quebec Lieutenant. It's an excellent question. I'd like to thank my excellent colleague from Beauport-Limoilou, first of all, for the work that he does on the international trade. And it's clear, exports in goods and services outside the United States went up by $33 billion over the last year, but we're not finished, Mr. Speaker. As he said yesterday, 2 historic agreements with Indonesia and the United Kingdom came into force. That represents 350 million new clients and new opportunities for our businesses. For Quebec, this means access to an Indonesian market that's worth billions of dollars for the forestry sector, the aerospace sector, and the pharmaceutical sector. It's good news.
South Kelowna. British Columbia, land title certainty is foundational. Families buy homes, secure mortgages, and plan their futures on the strength of our land registry. But today, homeowners in Richmond are being told that certainty no longer exists because of the Cowichan decision. That ruling followed a federal choice. The Liberal government instructed its lawyers not to defend private property rights in court. In 2019, the Liberals adopted Litigation Guideline 14, telling federal lawyers to avoid defending property rights. That directive is still in force today. Why is the Prime Minister choosing Liberal ideology over British Columbia homeowners by continuing to tell federal lawyers not to defend their private property rights?
The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. The Cowichan case is still in active litigation, and we're not going to talk about our legal strategy on the floor. However, what we can talk about is the public agreement, which the Conservatives have called secret, the Musqueam agreements. They're available online, and I encourage my Conservative colleagues to read them. These agreements did not appear overnight. In 2017, Musqueam and Canada signed a Memorandum of Understanding. And in February 2026, that work evolved into a framework agreement. However, it's not a title agreement, it's not a land claim, so let me be absolutely clear, the agreement does not affect Canadian.
The honourable member for Abbotsford South Langley.
Mr. Speaker, the Prime Minister claims he will defend property rights, but his Liberal government's own website still shows that Litigation Directive Number 14, which was announced as a directive back in 2019, still remains in effect today. The directive instructs federal lawyers not to defend private property rights in court. While the Prime Minister makes promises publicly, his government policies have not changed. Will the Prime Minister reverse his directive today so British Columbians can have certainty of home ownership?
The Honourable Minister of Veterans Affairs.
Here. Mr. Speaker, let's be clear. What is happening with the opposition is they are creating uncertainty and fear. Right. They are intentionally scaring Canadians. They're making investors scared. And they're making reconciliation out to be a bad thing. Our government has appealed. We will continue to defend private property rights in Canada. Mr. Speaker, real leadership means working together to address problems, not creating more fear in the world. Real leadership is respecting the Constitution, respecting the courts, and respecting the work of advancing reconciliation.
Honourable member for Pitt Meadows, Maple Ridge.
Mr. Speaker, British Columbians bought their homes, paid their mortgages, and followed the law. But because the Liberal government directed its lawyers not to argue for property rights in the Cowichan case, the judge did not protect private property. In 2019, the Liberal government issued a directive called Litigation Guideline Number 14, which discourages federal lawyers from defending property rights in court. This Liberal Prime Minister has kept that guideline in place. In fact, it's still on their website today. Why do Liberals continue to tell lawyers not to defend homeowners?
Great question.
The Honourable Secretary of State for International Development.
Let me be clear. The federal government is defending the property rights. The property rights are not at risk. The only people that are saying the property rights are at risk are the Conservatives over here and their counterparts in the province of British Columbia. You know it, we know it, Mr. Speaker. The Canadian government will always defend the private property rights. None of the treaty agreements take away those rights. We will defend the rights of Canadians. They are just disseminating fear in the hearts of British Columbians and Canadians for the wrong reasons.
The Honourable Member for Sackville, Bedford Preston.
Mr. Speaker, we know young people are the foundation of Canada's future. Can the Secretary of State for Labour tell this House what our government is doing through the spring economic update to invest in the next generation, ensuring they have both the opportunities to stay active and the pathway to build meaningful careers across this country? Thank you, Mr. Speaker.
The Honourable Secretary of State for Labour.
Thank that member for all of his hard work on behalf of his constituents in Nova Scotia. He's an excellent member. Our spring economic update, Mr. Speaker, is investing in the next generation. We are creating paid pathways for 100,000 Canadians to get into the skilled trades with a $6 billion investment, helping young people build good careers right here at home, Mr. Speaker. And we are making the largest investment in sport in Canadian history, so kids have the ability across this country to stay active and thrive. Mr. Speaker, these are some of the things we're doing to support Canadian youth and to build Canada strong for all.
Member for Simcoe North.
The Prime Minister recently recalled MPs off a trip and delegation to Taiwan. He's been sitting on for over a year an updated and finalized trade cooperation framework arrangement with Taiwan. It's just awaiting his signature. And Taiwan has been patiently waiting for additional flights to operate to Canada, only to see the government recently fast-track and announce new flights with China. So what does it say to our democratic allies around the world when this Liberal government stonewalls Taiwan in favor of getting closer to an autocratic Beijing?
The Honourable Minister of Foreign Affairs.
Actually, Mr. Speaker, the member opposite is not accurately reflecting the importance with which we take the Indo-Pacific region in general and including Taiwan, which is an important economic partner. We enjoy strong people-to-people ties with Taiwan, Mr. Speaker, and we will continue to ensure that Taiwan continues to be an important economic partner for this country as we diversify trade and double non-U.S. trade over the next 10 years. Thank you, Mr. Speaker.
The honourable member for Vancouver Kingsway.
Mr. Speaker, the Liberals' privatization agenda is disturbing and dangerous. They're planning to sell off Canada's ports and airports, strategic assets that will end up in the hands of foreign buyers, compromising our security. When Heathrow was privatized in the UK, it resulted in Saudi Arabia, Qatar, and China controlling major stakes in that airport. Passengers paid more and services declined. Will the Prime Minister commit to keeping Canada's ports and airports in public hands, or will he sell our sovereignty to the highest bidder?
Hear, hear.
The Honourable Minister of Transport.
Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Well, friend, of course, the Government of Canada is exploring all possibilities, but one thing we will not compromise on is we want to actually improve the travel experience, keep air travel in this vast and beautiful land accessible to all, and we want to make sure that pricing continues to favor Canadians' ability to move around the country. We want to explore all possibilities in terms of our safety and in terms of our accessibility and in terms of making travel and a responsive and comfortable and good and positive experience for all Canadians.
The honourable member for Rosemont-la-Petite-Patrie. Mr. Speaker, the Earth has a diameter of 13,000 kilometers, and that's not going to change. Our resources are limited. It's not up for debate. It's just physics. And unfortunately, capitalism doesn't get that. We've already passed 7 of the 9 planetary boundaries. Here, the Liberals are missing their climate targets, and they want a new pipeline. It's just ridiculous. On top of that, they'd committed, along with Alberta, to take action on the industrial carbon tax before April 1st. And since then, nothing at all. The Prime Minister says that climate action is not just a moral duty, but an economic imperative. Does he even listen to himself? The Honourable Minister of Environment and Climate Change. Thank you, Mr. Speaker. We are very clear that we need to continue to fight climate change while we put in place an economic plan for future generations. And we are doing that work. As I've said, we have strengthened our methane regulations. That's reducing greenhouse gas emissions by 400 megatons. We've made investments to protect nature, and at the same time, we are making investments at the international level to help other countries fight climate change. We are doing the work.
That ends question period for today. The honourable member for Mégantic-L'Érable, Lotbinière. Thank you, Mr. Speaker. During question period, the government House leader made statements saying that called into question some members, the words of some members of the official opposition. Do we have unanimous consent? So this brings us to the weekly statement, also known as the Thursday question. The Honourable Government House, Honourable Leader of the Official Opposition.
So maybe we should all pause and allow a little bit of time for the millions of Canadians to run over to their televisions to turn on CPAC so they can catch the Thursday question here in the House of Commons. But I would like to ask the Honourable House Leader for the government what the business for the rest of this week will be. And after our 2 constituency work weeks where we will celebrate Victoria Day and hopefully spend some time with our constituents and families, when we come back, if the Leader of the government in the House can inform us what the business will be then. I note that there's a lot of chatter in the public about energy regulations and impediments to natural resource development. We've got the actual people who do the investments and do the developments and build the projects saying that this Liberal government is shackling them with unnecessary costs and regulation. The Prime Minister, who has had a year with his powers of C5, the Major Projects Office powers, has gotten absolutely nothing approved through that office. Will the government bring in bills to repeal the anti-development legislation that the Trudeau government implemented and that the current government with the current Liberal Prime Minister has kept on the books. Can we please start seeing legislation entitled An Act to Repeal? Thank you very much, Mr. Speaker.
Honourable Government House Leader.
Well, thank you, Mr. Speaker. And like every, we are approaching the two constituency work weeks that my honourable friend described. And every good season must end with a cliffhanger. So that's why, Mr. Speaker, that the member will have to come back, stay tuned, and we will have, of course, legislative plans on a number of things that will respond urgently to the needs and desires of Canadians as we conclude this spring session of Parliament.
But for the time being, Mr. Speaker, tomorrow we will be studying Bill C-11, Act to Modernize the Military Justice System, at third reading. And when the House will resume its proceedings on Monday, May 25th, we will continue debate at second reading of Bill C-30, Act to implement the Spring Economic Update for 2026, and Tuesday and Thursday will be allotted days.
On Wednesday, we will start second reading debate of Bill C-31, the Budget 2025 Implementation Act number 2, which was introduced yesterday. And finally, pursuant to Standing Order 81-4A, I would like to designate Tuesday, May 26th, for consideration in Committee of the Whole of the main estimates for the Department of Finance, and furthermore, debate on the main estimates for the Department of Citizenship and Immigration will take place on the evening of Thursday, May 28th. Merci beaucoup, Monsieur le Président.
Thank you, Mr. Speaker.
Ordre du jour.
Orders of the day.
Orders, business of supply, resuming consideration of an opposition motion on the protection of private property rights in Canada, standing in the name of Mr. Schmale.
I believe the honourable member for Similkameen, South Okanagan, West Kootenay has 7 minutes remaining in debate.
Here. Thank you, Mr. Speaker. A very real and local example of this growing uncertainty is occurring in my riding in the community of Okanagan Falls, whose narrow vote to incorporate last year as a municipality is now being reevaluated as a whole community. From the decision-making powers of the town council to the municipality's actual name, uncertainty persists because of these title changes brought about by the BC government, which now risks serious consequences across the nation. When the community of OK Falls, over 100 years old, Okanagan Falls, 100 years old, literally no longer knows and is waiting to be told what is the name of their community they voted to incorporate will be, that is a sign of poor consultation brought on by error-ridden provincial government. While our motion today is focused on the federal government, I join with my local and provincial representatives in encouraging Victoria to engage fully with every resident and neighbour in the beautiful community of Okanagan Falls on the future of the community. As for the government across from me, Conservatives are calling for a common sense approach that keeps federal government involved with British Columbians throughout the entire legal process. We are calling on the government to put private property first in the Cowichan case at the Department of Justice. Statements by Liberal MPs in the House are not the same as the direction they have provided to their public lawyers, who argued and lost in the Cowichan case because of that. Litigation Guideline number 14 from the Attorney General of Canada's Directive on Civil Litigation involving Indigenous peoples prevented the federal government from defending property rights in the Cowichan case, as many Canadian lawyers have pointed out. This is what the Cowichan decision itself said in a paragraph in 2096. Canadians initially pled extinguishment but abandoned its reliance on the defense in its amended response to civil claim file November 22, 2018. What is called the principle of extinguishment, and that the Crown's creation of fee simple title supersedes historical Indigenous title, was the legal argument Canadian governments rested their defense of private property historically under both Liberal and Conservative attorneys general. It does not cancel any existing treaties. It simply upholds the property rights created through Canadian history, particularly the last century of property division in British Columbia. It was our best line of defense for property rights, and the Attorney General's guidelines limited its use. The federal government itself has also created confusion on this intersection of title claims with their own Musqueam Rights Recognition Agreement, which failed to say anything definitive about fee simple property rights, a dangerous precedent going into their appeal. Until Cowichan is resolved, it is clear that federal government should be negotiating the defense of private property rights into its agreements with our First Nations. It is not that First Nations are trying to take private property. They're not. It is that legal agreements create precedents that could cause greater problems in the decades ahead. This creation of legal gray areas is how we got to Cowichan. It should not be continued in agreements like the Musqueam one. Legal matters are never simply aspirational. They are law. That is why we, on this side of the House, are also calling for the Liberal government to publish a plan within 30 days to protect property rights for Canadians affected by the Cowichan decision and Musqueam agreement, and appoint a special committee with the mandate to study all legal, constitutional, and political steps that can be taken to protect property rights in Canada. This should be a multi-party committee that will hold multiple meetings over the next several weeks to hear from legal experts and develop advice to be published in an interim report by the summer, with a full report to follow later. Both sides of the House feature great legal talent, many of whom are Indigenous and many more familiar with Indigenous law. There is no reason they cannot provide the government with clear advice before we rise for the summer. Canada does not require international law to pursue reconciliation. We have our own law and our own lawmakers here in the House who wish to find common ground, equal rights, and shared prosperity. Section 35 of our Constitution already recognizes and affirms existing Aboriginal and treaty rights of the Aboriginal people of Canada. No one pretends this framework is perfect, but it is our framework, built and improved by all Canadians. Few nations around the world maintain this kind of legal framework with their Indigenous people. It is a process of ever greater improvement, but to maintain it, we need all parties, the Crown, First Nation leaders, and everyday Canadians who are extremely worried right now to sit in a common understanding of how we'll proceed and how we will recognize the rights of land and property and consultation. Let's maintain it as legislators of Canadian law. Setting aspirational goals aligned with UN resolution in our laws does not serve anyone. Real Canadian law, real Canadian reconciliation can serve everyone fairly. Thank you.
Hear, hear. Questions and comments. Question commentaire. The Honourable Parliamentary Secretary, Government House Leader.
Thank you, Mr. Speaker. Once again, I find myself disappointed in the Conservative Party of Canada as the far right has taken a position of stirring the pot and promoting fear over facts, Mr. Speaker, and it is indeed unfortunate because there is a substantial cost to that when misinformation is promoted. My question to the member is, how does she feel the Conservative positioning on this file helps in terms of building a stronger Canada when in fact Indigenous people, provinces, municipalities all play an important role of that, as does reconciliation, and that is a major aspect that's being hit by the Conservative Party today.
Yeah, member Similkameen, South Okanagan, West Kootenay.
As I said, Mr. Speaker, First Nation leaders, the Crown, and everyday Canadians, we all need to sit at a table in order to proceed. What I don't understand is how members of how the member can say that there's not a problem. I know that I'm getting calls, I'm getting emails, I'm getting people knocking on our door wondering if they still are going to own their property in the next little while. I know that the member who just spoke is not from British Columbia, but this is a Canadian issue that needs to be addressed immediately.
Here, here. Good answer.
Député de Repentigny.
The member for Repentigny. Mr. Speaker, I would like to thank my colleague for her speech. If I understand correctly, this issue has not been studied in a parliamentary committee where it could have been discussed. It has been tabled here directly. Can my honourable colleague explain why there hasn't been a procedure to have work done in committee on this issue?
Okanagan West Kootenay.
That's a really good question. I thank the member for that. Liberals have shut down all communication. Everything that we've tried to bring forward to committee has been shut down.
Shameful.
I don't think I know it's not a good idea to keep pretending that this issue is minor or that somehow conservatives are stirring the pot or making people scared. Again, how is it that this government does not realize that people are scared? People are scared about the future of their property rights, and they're scared to develop. They're scared to invest in Canada right now.
Questions comes. There, member for Calgary Centre.
Well, thank you, Mr. Chair. And I just want to ask my colleague a question here, because the questions that are coming at her all the time are from the Liberal side, or that we shouldn't be talking about this in the House of Commons because Canadians are uninformed, so we shouldn't be discussing it here. And I can ask her if she thinks it's incumbent upon us as parliamentarians to raise issues and discuss the issues and get the facts on the table here about how we deal with the issues, rather than to bury our heads in the sands like ostriches.
Member for Similkameen, South Okanagan West Kootenay.
I want to thank my colleague for that, because I think it's exactly what he said. The government members are burying their heads in the sand, pretending that this is not something that could grow into something that we won't be able to address further down the road. We need to get together, as I mentioned in my speech. There are a lot of people on all sides of this House that have great experience in legal experience, Indigenous experience. We have lawyers on both sides that can look at this and make sure, and we need to be leaders out here. We need to show people that, yeah, they don't need to be frightened, because we're going to do something about this.
Member for Winnipeg Centre, about half a minute.
Yes, thank you. Directly out of the court documents, it says, in quotes, the plaintiffs, the Cowichan, seek declarations that fee simple titles and interest in the federal claim. And it goes on, they do not seek a declaration of invalidity regarding the fee simple titles held by private property owners. There is no risk to private property. This has been indicated by the plaintiffs. Does the member opposite understand that?
Similkameen, South Okanagan West Kootenay, a very brief response.
I thank the member for her question, but it just confirms the fact that we all need to sit together. This is what the motion says. We need to sit together and talk about what our next steps are. This is a very complicated issue, and we cannot continue to pretend that it's not serious.
Resuming debate, reprised by the Leader of the Opposition.
Thank you, Mr. Speaker. Before I begin my speech, I would like to state that the medias are saying that the Liberal Prime Minister will once again allow a new law to accelerate projects just a year after promising the same thing. This is a déjà vu all over again. Bill C-5 was adopted in 5 days, almost a year from the first date. It was stated that the Prime Minister was going to make it possible for building to happen more quickly than ever before. But he did not use that power to approve even a single new project anywhere in Canada. And now he's repeating the same promise all over again. There are 500 projects awaiting federal approval. All he has to do is one thing to let them move forward, and that's get out of the way. Mr. Prime Minister, get out of the way by eliminating the carbon tax, by giving permits, get out of the way by legalizing the exports of oil from the West, and get out of the way by allowing pipelines. That's how we are going to make it possible for builders to build, make it possible for investors to invest, and for businesses to create.
I just want to address that the Liberal Prime Minister is again spreading illusions. CBC ran a big headline that he's going to introduce a new law to get projects built. Where have we heard that before? 11 months ago, this House gave him unprecedented legal powers under Bill C-5 to approve projects quickly. He said these powers would allow him to build at unimaginable speeds. 11 months later, he has not used them once to approve a single solitary project. There are 500 of them waiting for his approval. There's only one thing in the way: him. We don't need an announcement, a symbolic signing ceremony, or any other illusions. We need him to get out of the way. Get out of the way, get rid of the industrial carbon tax. Get out of the way, approve the 500 projects waiting. Get out of the way, grant a permit for a pipeline to the Pacific. Get out of the way and legalize shipping oil off the West Coast. Let builders build, workers work, and investors invest. To do that, though, we also need to protect private property, which is the foundation of any economic civilization. Last August, the BC Supreme Court ruled in the Cowichan case that Aboriginal title had prior and senior status over private property rights, what is called fee simple. Fee simple is the legal term for the title you have to own your home. This is an unprecedented ruling, Mr. Speaker, and it changes everything. And now, we have to acknowledge how this ruling came to pass. It was the result of the Liberal government refusing to defend property rights in the court. See, the federal government is the defendant in this case. It is named, and it is frankly, the only defendant. The Liberal government passed litigation guideline 14, an instruction from the Liberal cabinet that federal lawyers were not to argue for the seniority of fee simple property rights. The judge noted in her 800-page ruling that this is one of the reasons she could not protect property rights in her decision. That guideline is still on the Liberal government's website, meaning the Prime Minister has kept it in place. 8 months went by after this ruling, which affects 800 acres and over $1 billion of private land, and the Prime Minister, who is the head of the government that is the defendant in the case, said absolutely nothing. He said nothing, he did nothing. Then the other day, he stood up and spread the illusion that he suddenly supports property rights, all while he is instructing his lawyers through an explicit guideline still on the government website not to defend those same property rights. Already there are reports of over $100 million of investment being canceled because land title cannot be secured, and as a result of the fact that there is not guaranteed collateral for the investors and the lenders. To make matters worse, the Prime Minister directed his Liberal government to sign the Musqueam Agreement, which began the process of granting title to the Musqueam over lands that include Metro Vancouver, Delta, and even the same Richmond lands that the Cowichan decision granted to the Cowichan people, causing an even greater mess. Now, the Liberals claim that their framework agreement with the Musqueam has no legal force and it doesn't matter, which raises the question of why they signed it at all. But what is clear and what legal experts say is that there is no protection for private property rights in that agreement either. All of this raises big concerns, not just for Richmond and the Lower Mainland, but right across British Columbia, because there are claims on almost the entire province. Because British Columbia is not a province where land cession has happened through the treaty process, there are going to be countless other claims that will come forward from other nations using the same precedent that came from the Cowichan Agreement, for the Cowichan ruling, that could threaten literally millions of homeowners. In the meantime, investment is paralyzed and suspended. Liberals across the way are trying to downplay the concern, but let me quote Mayor Malcolm Brody of the City of Richmond, quote, property owners in Richmond and throughout the province can no longer rely on their title confirming a fee simple interest as conclusive evidence of absolute ownership of their land. The court's untenable decision cannot remain unchallenged. Clearly the mayor of the city of Richmond would not be raising this prospect that his own residents do not have clear title over the homes that they bought if it was not truly a concern. And frankly, I don't know how the Liberals can deny the consequential impact of a court ruling that says that there is one form of title that takes precedence over home ownership, fee simple land title. Of course, that is a revolutionary change. It is an unprecedented change, and it threatens the very economic foundations of our entire land-owning system. Mr. Speaker, without property rights, there are no economic rights. There is no country in the world where people are able to feed themselves, to house themselves, to prosper, to start businesses without having secure title. It is literally the single biggest determinant of economic prosperity. The great economist De Soto even pointed out that there are literally trillions of dollars of wealth that are deprived of people in third world countries simply because the people who live on the land do not have title of that land and therefore cannot build anything, including a home for themselves on that land. Therefore, to have a property-owning, free market democracy, you need to have secure land title. And that is why Conservatives have come forward with a solution to clean up the mess the Liberal Prime Minister has made. This motion today calls for the following. One, we call for the Prime Minister to cancel litigation guideline 14 and instead replace it, that guideline which bans federal lawyers from defending property rights, and replace that guideline with a new one which requires they defend property rights in all such disputes. Two, to set a policy that the federal government will not sign any more agreements with any First Nations that do not explicitly protect fee simple property rights as having seniority over all other claims. Three, within 30 days, the Liberal Prime Minister should present his plan to protect the property rights of British Columbians. It's been 8 months since this ruling. This is a federal issue where he is the federal defendant. He is the head of the federal government. He, by now, should have come up with a plan to defend the property rights of the people of British Columbia. And four, that we immediately convene a parliamentary committee to begin studying how we can save the property rights and the home ownership of the people of British Columbia and all of Canada. A 4-step action plan that will immediately allow us to step up and do our jobs, defend the homeowners. Mr. Speaker, these are people who in good faith bought the land, paid down the mortgages, followed the rules. They deserve to have the security and the certainty that they own the homes that they live in. Conservatives will fight for you. We'll fight for your home, for your land, for your property, and for all Canadians.
Hear, hear. Questions and comments. Question and commentary. The Honourable Secretary of State Rural Development.
Thank you very much, Mr. Speaker. We absolutely reject the premise of the Leader of the Opposition's argument. Yeah. And I want to make sure, Mr. Speaker, and I quote what the Prime Minister said several days ago, the government will always defend private property rights. And I'll say it again, the government will always defend private property rights. We immediately appealed the Cowichan decision. We have always defended private property rights, we always will, and we'll always defend the rights of Indigenous people to build a Canada that is stronger, fairer, and more independent. So why does the Leader of the Opposition try and divide Canadians and misrepresent our Prime Minister?
The Honourable Leader of the Opposition.
Mr. Speaker.
What are you doing here?
It's all an illusion, Mr. Speaker. The Prime Minister says one thing while doing precisely the opposite. That has actually been the signature trait of his entire Prime Ministership. He does precisely the opposite of what he says. While he was making those comments in the House of Commons, on his own federal government website was litigation guideline 14, which forbids federal lawyers from defending fee simple property rights in challenges by First Nations. So it is another example of the Prime Minister providing an illusion of one thing while doing precisely the opposite. If he will actually defend property rights everywhere and always, then he can simply vote for our motion, which requires we defend property rights in court.
Questions and comments? The honourable member for Gaspésie, La Madeleine, Restigouche. Thank you very much, Mr. Speaker. I'd like to thank the Leader of the Opposition for his speech. I have this question. Given that the decision is an interpretation of Section 35 of the 1982 Constitution Act, there must be an interpretation of that section of the Constitution by the courts. So how could the government provide a solution today without allowing the judicial process to do its work?
Monsieur le Président, c'est un mal.
Mr. Speaker, it's a bad interpretation of Section 35 of the Constitution Act, and it's an interpretation that occurred because the Liberal government ordered its lawyers to withhold from defending private property. Instead, and in fact, the judge herself stated that the Liberal government in Ottawa and the provincial NDP government in British Columbia did not defend the precedence of, or the importance, the main importance of homeowners in British Columbia. And that led to this threat of people losing their private property, and we're trying to reverse that today.
Thank you, Mr. Speaker, and I appreciate the Leader of the Opposition's remarks today. Many British Columbians are afraid. They don't have certainty right now. In 2019, the Liberals adopted litigation guideline number 14, telling federal lawyers to avoid defending property rights. That directive is still in force today. The Prime Minister likes to talk about things that we can control and focusing on them. Would the Leader of the Official Opposition maybe tell the Prime Minister what is under our control here in this Parliament and what the Leader of the Official Opposition intends to do about it?
Honourable Leader of the Opposition.
Yes, well, what the Prime Minister can control is the directives he gives his lawyers. We have a very simple system when it comes to lawyers and clients in our legal system. The lawyer advises, the client instructs. The Prime Minister is the client. He has absolute authority to instruct his lawyers however he wants. And right now, the instruction he has given them, as published in Guideline 14 on the Government of Canada website, is that they should not defend private property rights. So when he stands in the House of Commons and puts his hand on his heart and claims he's for property rights, it's exactly the why is it that this Prime Minister is saying one thing to the Canadian people and the opposite to his lawyers?
Exactly. Very briefly, the member for Winnipeg Centre, a brief question.
Yes, thank you, Mr. Speaker. The previous speaker to the motion spoke about putting international law aside and sitting down together to a Canadian version of reconciliation. Does the Leader of His Majesty's Loyal Opposition know and agree that as Parliament, legislation we adopt in this place is presumed to be consistent with our international obligations, yes or no?
The Honourable Leader of the Opposition, a brief response.
We pass laws in this country for our people in Canada. We do not pass laws based on what some multinational bureaucracy tells us to pass. We work for Canadians in this country. We are Canadians first, Canadians always.
Resuming debate, reprise débat, the honourable member for Edmonton Northwest.
Thank you, Mr. Speaker. Why is it that when Albertans feel frustrated and they're being held from reaching their full potential to share their energy with Canada and the rest of the world, there is a Liberal government in Ottawa? Why is it today Alberta's separatism is at an all-time high and there's a Liberal government in Ottawa? Why is it that throughout history, when a Quebec separation referendum happens, there's a Liberal government in Ottawa? Who is the government in Ottawa over the last decade as separation sentiment in Quebec reaches heights not seen in generations? Liberals. Lack of leadership, villainization of provinces for political benefit, and causing divisions between the people of Canada is the Liberal record. Mr. Speaker, today in British Columbia, we see a lack of leadership. We see a villainization of those asking for certainty and clarity around property rights. And we see an all-time high of division between British Columbians and First Nations. And who is the government in Ottawa today during the lead-up to this in British Columbia? Liberals. This is not just a provincial government issue. First Nations are a federal jurisdiction under Section 35 of the Constitution. Treaty making, agreements, and court action involving First Nations require federal government leadership, vision clarity, and the desire for unity. But all we have from this government for the current challenges in BC is avoidance, a lack of transparency, contradictions, and reconciliatory rhetoric. The situation regarding Cowichan is not an isolated failure. It reflects a broader and more troubling pattern under this Prime Minister and his Liberal government. As a first-term member of Parliament, I have seen trust repeatedly broken with Indigenous peoples, political negligence at the expense of lasting progress, and an inability to take full responsibility when things continuously go wrong. This Prime Minister says he's all about reconciliation, but he and his government have reduced reconciliation to a cheap political talking point. His record over 1 year shows a complete lack of respect and neglect for Indigenous peoples. In 2015, his government promised to end boiled water advisories in 6 years. Now they're 6 years past their promise with no end in sight. After the last election, his government promised new water legislation for the fall of 2025. Fall came and went with no legislation. He then told AFN chiefs at the Winter Assembly there will be water legislation in the spring of 2026. Well, Mr. Speaker, there has been no water legislation tabled this spring, and there are only weeks left until the summer break for them to keep their word instead of breaking another promise regarding water. This government creates uncertainty and stress by not keeping its word, and it is doing that in BC at this moment. A core source of uncertainty in BC under the Musqueam Agreement, treaties, and other such initiatives is the application of UNDRIP. I note this Prime Minister said several times that he will uphold free, prior, and informed consent, a key piece of UNDRIP. But we know when he says this, it's just political rhetoric, just as his party has said it now for years. Their strategy seems to be to exploit First Nations when it suits their political purposes, even create and sow division and chaos amongst Indigenous peoples themselves. Recently, First Nations have written this government as it tried to expedite the Manitoba Métis Federation Bill. Their question to the Liberal government is, do you have the free, prior, and informed consent of First Nations to sign a new modern treaty while you have yet to honor the historic ones which lay claim to the same territory? The government has several public letters now from Treaty 6, 8, Manitoba First Nations, the AFN, and more citing their concerns over a lack of consultation, a lack of consideration on historic treaty rights. Conservatives make it clear, and so have First Nations leaders, nobody is against Métis self-government and determination, but there remains outstanding answers to be had before moving ahead with modern treaties that overlap with historic rights. Surely the government considered this, because their silence to First Nations concerns on this matter is deafening. Furthermore, we have the United States tribes now attempting to leverage DRIPA and UNDRIP to cause chaos in our country's developmental affairs. Where are the Liberals on this issue? Silent. Conservatives know to put Canada first on such things and raise them in this House so that the government might do its job to stand up for this country. What about other modern treaties? Clearly, this government is not serious about UNDRIP, free, prior, and informed consent when it comes to modern treaty processes in BC. Several of the recent agreements in BC have raised threats of blockades, protests amongst the First Nations themselves. While the government has a big role to play, the provincial government has a big role to play, the federal government is ultimately responsible for these treaties and agreements. To pretend otherwise and to use the excuse that things should wait until the process comes to this Parliament formally is neglect, reactive, and only sows more division in the future. So far, it really seems like their Liberal strategy is to sow division, chaos, and water down the spirit and intent of treaty to avoid the rights of those who sacrificed to help build this country. Did this government have free, prior, and informed consent of other tribes in the area when it signed their Musqueam Agreement? An agreement negotiated in secrecy, sprung up on the people of Vancouver and other First Nations in the Lower Mainland? The answer is no. The government is hypocritical when it comes to free, prior, and informed consent, as evident by the Squamish, who had to release a public statement saying they were not consulted, meaningfully engaged by the federal government prior to the announcement of these agreements. The people of Vancouver were not consulted, nor were the other local tribes such as Tsawwassen when it comes to the Musqueam Agreement. Speaking of consultation, Mr. Speaker, First Nations are asking this government right now in committee, why are you weaponizing consultation against First Nation women and families by creating a 4-year delay sham process for S2 legislation, which ends discrimination against women and families? Women are now saying this government uses consultation as an excuse to delay human rights legislation through a 4-year sham process, but it rams through other bills that have implications on First Nations rights. Clearly, this is, again, the Liberal government being hypocritical, because they know the Mikisew court case protects Parliament when it comes to a lack of consultation in legislation development. The Vice President of the Justice for Girls said just days ago regarding the government's lack of urgency to change discrimination To resist doing this under the guise of consultation and supporting UNDRIP is absolutely flabbergasting to me. Such hypocrisy and political games by this Liberal leadership to exploit our people. So they are just stalling to keep the Indian Act discrimination going against women and families. For what reason, nobody really knows. So this government avoids lacks transparency, vilifies fair questions, and shows a complete lack of leadership. It's a wonder why we have this situation in BC, separation in Alberta and Quebec. But Conservatives are ready to lead, Mr. Speaker. We are ready not to just talk about balancing property rights and Section 35 rights. We are acting. We are challenging the government to lead, to bring clarity and certainty to homeowners, First Nations, and investors. We call upon the government to put private property first. We need to start analyzing how to do this in respect to all perspectives. When my nation settled a land claim over the west side of Edmonton that had residential and commercial property on it, we never went after private property, and we worked with negotiators for solutions. We call upon the government to aggressively defend property rights in all litigation. To do otherwise would prove that this government wants to see chaos and division. Stop watering down the treaty process and bring these structures necessary to protect private property in all future agreements, negotiations, modern treaties, so that Canadians can have certainty for both First Nations and Canadians. Our Treaty Number 6 brings certainty to First Nations in Canada. It says as long as the sun shines, the grass grows, and the rivers flow, this treaty cannot be changed. The government is signing these modern treaties with easy backout clauses, using performative language such as living agreements, is not truly the treaty process and only delegitimizes all treaties. And we call upon the government to put aside differences in this House to strike a cross-party committee to address this, to show real leadership from this House, to be proactive in First Nation and Canadian relationships. Because otherwise, courts, division, conflict will define where we go next if this House does not act. While this government claims to be a party of reconciliation, they only act for true change when challenged in court. In areas such as Indian Act discrimination, child family services, water, and more, the government is only forced to the table through court. There is an opportunity to be better and to do the role of leadership from this House, not just reconciliate rhetoric. Canada must do better. This government, under the Liberals, must do better. Real reconciliation does not come from rhetoric. It comes from responsible governance, honest engagement, and the resolve to follow through. It requires a government that says what it means, does what it says, and is willing to be held accountable at every step of the way. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The Honourable Parliament Secretary, the Government House Leader.
Yes, thank you, Mr. Speaker. You know, the essence of the motion is to promote and encourage fear amongst Canadians, and ultimately, I would argue, spread misinformation. And, you know, we listen to members opposite, and they try to even misquote or misrepresent what it is that the Prime Minister is saying. I would like to quote the Prime Minister directly, and I quote, "The government will always defend private property rights. We immediately appealed to the Cowichan decision. We have always defended private property rights. We always will. And we will always defend the rights of Indigenous people to build a Canada that is stronger, fair, and more independent." Mr. Speaker, as we continue to be able to defend those property rights, and it is something that's going to continue well into the future, we have the Conservatives, on the other hand, trying to plant the seed.
Order. The Honourable Member needs time to respond. The Honourable Member for Edmonton Northwest.
Thank you, Mr. Speaker. And, you know, I've been here as a first-term member of Parliament for 1 year. Canadians were hoping for something different, but they got more of the same, just more Liberal rhetoric. And for my communities, you know, it's really disappointing for me to say they really have cheapened reconciliation to a political talking point. It is reconciliation rhetoric now. So as much as this Prime Minister says something in this House, all of his actions outside of it prove otherwise. Actions speak louder than words, Mr. Speaker, and this Prime Minister continues to fail in that regard.
Questions and comments. Question et commentaire. L'honorable député.
The Honourable Member for Saint-Hyacinthe-Bagot, Acton. Thank you, Mr. Speaker. I thank my colleague. I must admit that we in Quebec are very used to it. He said that under a Liberal government there was an independence referendum. Well, the next one will also occur under a Liberal government in Ottawa in the next few years, and we will win it this time. And then you can have your country and you can decide who you want to govern your country. We would love that. We can handle things for ourselves. But this is an interesting issue. In addition to being a proud Quebecer, I'm a proud member of the Wendat Nation. that is a part of my identity that I'm proud of. We have different laws and a different legal system, especially when it comes to property. Does he feel that this ruling for British Columbia, because it's hard for us to form an opinion on the situation. He can tell us more about that, but does he anticipate that this ruling can have an impact on Quebec in the future?
Well, that's the fear, Mr. Speaker, and it's disappointing when the Liberals deny Canadians fear. That's a real emotion at the end of the day, and Quebec or any other provinces need to take a look at what's going on in BC, because there is an aspect of federalism. First Nations are a Section 35, so this has federal implications. And for First Quebecers and the people of the Wendat, there are mechanisms to work together, but continuously this Liberal government doesn't take all advantage or performs reconciliatory rhetoric when it comes to creating real partnerships at the end of the day. So, we're looking for leadership. People of the Wendat can provide that in spite of what this Liberal government does.
Comments. I member for Haliburton, Kawartha Lakes.
Thank you very much, Speaker, and thank you to the member from Edmonton Northwest for that amazing speech, and I do appreciate everything he's done on the Indigenous Northern Affairs Committee. I've learned a lot from him and look forward to continuing to work with him on this very important file. Now, the member from Winnipeg just a few moments ago read a statement which in normal circumstances would be a good thing. However, everything that was repeated on that script is the exact opposite what the Liberals were doing. They actually decided in 2018, a conscious decision, not to argue fee simple property rights in court. Meaning if you don't do it in the lower court, you can't do it on appeal, and if it gets to the Supreme Court, you can't do it there either. So how, again, do they expect to use that argument when they aren't allowed to?
Member for Edmonton Northwest, about 40 seconds or less.
I have to have humility. I'm not a lawyer, so I do stand to read what lawyers say in this regard. But I do take the member for his point. That is my understanding of it as well. But I hope the Liberals have more humility too. They admit they got things wrong. They admit that things are not going in the right direction, and they shouldn't dismiss people's fears, because this is a real issue that British Columbians are facing, and ultimately Canada. And we need them to step up in that regard as well, and not be fearful of addressing the issues.
Resuming debate. Reprise de débat. Resuming debate. The honourable member for Winnipeg Centre.
So much. Thank you so much, Mr. Speaker. So here we are again, debating a court decision in the House of Commons based on arguments that misrepresent and distort a ruling confirming the Aboriginal title of the Cowichan Nation. This motion does not reflect the actual goals of the nation or the findings of the court. Instead, it attempts to pit individual property rights against Indigenous rights protected under the Constitution. It manufactures fear about what this ruling supposedly means rather than dealing with what the court actually said. It is shameful that the Conservatives and Liberals are trying to score political points by spreading narratives not in fact, but in fiction so obnoxiously that you can almost hear the gears turning in the fiction mill. When did this Parliament, which is supposed to uphold the rule of law, decide that some rights matter more than others? This is a dangerous political game. At a time when division is growing across the country, Conservatives and Liberals are shamefully pitting Indigenous peoples against communities and homeowners. They are creating unnecessary fear among homeowners who are struggling more than ever just to make ends meet while failing in their responsibility as legislators to uphold the Constitution and rule of law. The facts are clear. In fact, the Cowichan Nation stated in court, and I quote, that they do not seek a declaration of invalidity regarding the fee simple titles held by private owners. And the BC Supreme Court Justice reinforced this directly, stating, in quotes, these are not my words, these are the courts. I also find that as Aboriginal title, the Crown may coexist. It follows that Aboriginal title and fee simple can coexist, as the latter is a derivative of Crown title. Moreover, the paranoia being fueled by the Conservatives and Liberals around this threat this decision poses to homeowners in Richmond is unfounded. In reality, the decision affects land that is largely undeveloped and will not displace homeowners. And just before I continue, Mr. Speaker, I'd like to state that I'll be splitting my time with the member from Saanich Gulf Islands. The court made it very clear, and they stated this in quotes: the Richmond lands that fall within the Cowichan title lands are generally unoccupied and undeveloped, and there is no set plans for their occupation or development other than possible dike redevelopments. These are the lands in question in Richmond. So let's be honest with Canadians. Homeowners are not at risk here. This decision is not about, and has never been about, how individually owned private property. Has never been about that, affirmed by the courts. Not only does the Cowichan decision not affect homeowners, but the Cowichan Nation never even intended it to do, as stated in court documents. The Liberals and Conservatives need to get out of the business of deciding whether they will respect the rule of law based on political convenience, economic interests, and fundraising purposes. Rights do not become optional depending on who it is affected or whether acknowledging them are politically uncomfortable. We already have clear legal guidance. Section 35 of the Constitution affirms Indigenous and treaty rights. Section 25, in fact, of the Charter, Mr. Speaker, protects those collective rights within Canada's constitutional framework. As legislators, we swear an oath of office to uphold the Constitution. This means respecting the Constitution in its entirety, which includes Indigenous rights. It also means respecting the United Nations Declaration on the Rights of Indigenous Peoples, which this Parliament affirmed its application through Bill 15 in the 43rd Parliament. And let me be clear, UNDRIP was never about placing Indigenous rights above the rights of others. Quite opposite. It was about balance, fairness, coexistence, and justice. Article 46, in fact, of the Declaration makes this explicit. It states that, in quotes, all provisions of the Declaration must be interpreted in accordance with principles of justice, democracy, human rights, equity, non-discrimination, good governance, and good faith. So, I'm here to do some myth-busting today, Mr. Speaker. Canadians deserve facts, not panic, designed to divide people against Indigenous nations and against reconciliation itself. The truth is simple. The court upheld the rule of law. It rejected the argument that unlawful Crown grants should erase Indigenous title. That decision does not undermine property law. It, in fact, clarifies it within the framework of reconciliation and the Constitution. In fact, the Cowichan Nation and BC's provincial government issued a joint statement that the ruling did not seek to invalidate privately held homes or fee simple title. Did not seek to invalidate privately held homes or fee simple title. The suggestion that homeowners could suddenly lose their homes is simply false. The court recognized that the Cowichan deliberately tailored its remedies to avoid impacts on third parties like homeowners. The ruling leaves rooms for negotiated solutions, compensation, shared jurisdictions, and agreements that protect existing homeowners while respecting Indigenous rights. As a matter of fact, the BC court affirmed that the Cowichan Nation's position that Aboriginal title and private ownership are not a in, quote, zero-sum game. An Aboriginal title and property ownership can coexist and reconcile. So why are the Conservatives putting forward a motion today when people are dealing with the everyday emergency of just getting by? Shameful. In Canadian history, in fact, there has been no record, not one single record of a single case where an Indigenous nation has displaced property owners. In reality, this whole debate is a complete oxymoron. The true struggle has been for Indigenous people to prove Aboriginal title on their own lands. Moreover, the Supreme Court has already repeatedly affirmed pre-existing sovereignty of Indigenous peoples. For example, in 2004, the Haida Nation case versus British Columbia decision affirmed the need to reconcile the pre-existing sovereignty of Indigenous peoples with the assumed sovereignty of the Crown. Mr. Speaker, we have heard claims that this decision will unleash chaos and endless lawsuits. But Indigenous rights and title have been recognized repeatedly by the Supreme Court of Canada. Reconciliation through law is not new. Modern agreements across the country have already shown that Indigenous rights and private ownership can coexist. Most claims are resolved through negotiation, not litigation. Court cases usually happen only when governments refuse to negotiate, like the Liberal government, in good faith. Mr. Speaker, the leader of the official opposition claimed that Crown lawyers pulled their punches because they were not denying Indigenous rights in court. But Section 35 rights are protected under the Constitution. The Crown has a legal obligation to act honorably and in good faith in its dealing with Indigenous peoples. Finally, last week in question period, the Prime Minister stated, in quotes, private property rights are fundamental, and this government, indeed this House, will always protect them. Property rights are protected, in fact, Mr. Speaker, but so are constitutional rights. Section 35 of the Constitution affirms and recognizes that Aboriginal rights and title are not secondary rights. They are protected rights within Canada's constitutional framework. The Prime Minister is obliged to uphold our Constitution without qualification or question. Reconciliation does not mean choosing one group's rights over the other. It means finding lawful, fair, and balanced solutions that respect Indigenous peoples, uphold and honor the Crown, and provide certainty for everyone. That is what this decision moves us towards, and we must reject attempts to weaponize fear and misinformation for political gain. Thank you, Mr. Speaker.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Mr. Speaker. Even though I do take some exception to the member's belief that the government is somehow feeding misinformation, I believe that the government has been very straightforward, whether it's been the Prime Minister in the statements that he's made earlier this week, or the minister responsible that stood up today and articulated in great detail in terms of a number of points that the member opposite has just raised. I believe the government is working in collaboration with other jurisdictions, First Nations, and the provinces. And the question I would have for the member is, what does she believe in terms of the importance of working in collaboration, and what is the NDP's position on the motion itself? Will they be voting in favour of it?
Member for Winnipeg Centre.
Well, thank you, Mr. Speaker, and I disagree actually with the member opposite. This government, in fact, Amnesty International, confirmed the backsliding of Indigenous rights by this Liberal government. I want to know if he agrees with me that the Prime Minister actually should do his duty and uphold the Constitution. Why his government is choosing to put forward a litigation against constitutionally enshrined rights in Section 35. That is not a respect of the Constitution or the rule of law. Thank you, Mr. Speaker.
Comments, the Honourable Member for Haliburton, Kawartha Lakes.
Thank you, Speaker, and thank you to the member opposite for her speech today. I don't think, though, with respect, she was actually paying attention to what we were saying on this side of the House, because at no time has anyone on this side even applied that the Cowichan tribes would be forcing people off their land. At no time did anyone on this side say that, but she continues to repeat that, unfortunately. We have said it has created massive uncertainty because the government did not do their job. And don't take my word for it. According to David Eby, the NDP Premier of British Columbia, quote from the Canadian Bar Association, Mr. Eby has repeatedly raised the alarm about the Cowichan decision, saying it threatens private property rights. He goes on to say that the court decision was very unhelpful. And she says that there are more important things to talk about. Well, how about a $100 million project, a hotel, a luxury hotel that was canceled? How about widespread uncertainty, according to CBC News and the Vancouver Sun, affecting Richmond and elsewhere? So this is very important, and we need certainty.
Member for Winnipeg Centre.
Thank you so much, Mr. Speaker. And I want to actually speak to the multi-million-dollar project in question that was raised by Councillor Alexo Liu. This is actually what the bank said, not what she said, of why the project didn't go through. And I'm quoting, in quotes, National Bank initially said in a one-sentence response that, in quotes, no specific directive has been given to our teams regarding this court ruling. In a second statement hours later, the bank said, in quotes, we cannot comment on specific cases for confidentiality purpose, but we can confirm that this is not a factor that it is currently taken into account in our financing decision, and no guidelines have been issued by the bank in this regard. What does this mean? The fact that they didn't receive financing is a separate matter, and the bank confirmed it had nothing to do with the Cowichan decision. Thank you.
Questions and comments, Honourable Member for Gaspésie, Île-de-la-Madeleine. Thank you. I'd like to thank my colleague for her contribution. I think we have to work towards reconciliation, and we also need to reconcile diverging interests on both sides. So I'd like to hear what my colleague has to say. She seems to be minimizing the legal gray area that surrounds the Cowichan decision. And this decision opens the door to negotiation, and that's what it says. And we understand that the legal process, well, we also have to understand some private landowners, and through some political discourse seems to be more succinct than it should be, but Aboriginal rights can exist on private property. And does my colleague not agree that there's some concern that could be legitimate with regard to this?
Thank you so much, Mr. Speaker. And as the court ruled, it's not a zero-sum game, which means that we have real examples where both realities coexist: private property and in Aboriginal, the recognition of Aboriginal rights and title. I want to point out, though, we're talking about this like it's something new. That's actually false. I pointed in my discourse about in 2004 and the Haida Nation case, where the court determined the pre-existing sovereignty of Indigenous peoples with the assumed sovereignty of Crown. There is no threat. There's no case in history where Indigenous people have gone after a private property interest, just fought for their own recognition of Aboriginal title. Thank you, Mr. Speaker.
Resuming debate, reprise du débat, the Honourable Member for Saanich Gulf Islands.
Thank you, and I really do want to thank my honourable colleague from Winnipeg, and I'm so sorry that, and I'm grateful to her for splitting her time with me. This day's debate, I don't want to attribute motivations and the reasons we're doing it or which side is right or wrong, but the problem is it's posing a question as if it's a live issue that needs to be addressed. And that's largely due to misunderstandings and misinformation. So let me try, because I am a British Columbia MP. So when other British Columbia MPs say that the proof of the fact that the court decision has created real problems is that we're getting calls in our constituency office. So I can say, yeah, I'm getting calls in my constituency office, and I'm getting constituents emailing me. And I take it as my responsibility to dig in to what the court said and to share with my constituents. I want to reassure you, there's no threat to your fee simple ownership of your place. There is no threat to ownership of land by settler culture British Columbians at all from the Cowichan decision. So I want to go back to what it is about, because what the court did, and it's a declaration of the British Columbia Supreme Court, and I wish, by the way, I think the Prime Minister was wrong to stand in this place and commit to appealing, and I think the British Columbia Premier should be ashamed of his running away from DRIPA and his decision to demonize this decision as if it puts anything into a state of confusion at all. I'm more upset with the Premier of BC because he is a lawyer, so we should know better. Prime Minister isn't, and the Leader of the Opposition isn't. And I dig into these things because I think it's my job. I'll never forget one of my favorite professors at law school, and Mr. Speaker, he used to thwack a cane across a desk right in front of it. It was like something out of Paper Chase on TV. And he'd say, "Develop the habit of thoroughness." So I've dug in. I've learned more about what this is about, and I want to share it with people because I think it will help take the notion that this is in any generalized way, that the Cowichan decision has anything to say about fee simple property rights in Canada. What the court said was that British Columbia, the British Columbia government has a duty to negotiate in good faith with the Cowichan, now that the facts are clear, in, quote, a manner consistent with the honor of the Crown. Now, we use the term honor of the Crown quite loosely, and the minister responsible for Crown Indigenous relations, this isn't some anachronism that we still talk about the Crown. That's at the essence of Indigenous nations' relationships with the country of Canada, is something that happened before there was a country of Canada, the Crown. The Crown's relationship with nations that were here before we got here. So in this case, what happened? Because it is an interesting story, and I hope that other colleagues here will realize how specific this was to a specific historical injustice, not a generalized one. What happened here, and again, to the honor of the Crown, the first governor of British Columbia appointed by the Crown, Governor James Douglas, was a very interesting person and a person of real integrity. He was, interestingly enough, and I won't digress too much about James Douglas, but he was black. He married an Indigenous woman when he came to BC, so his mother was black, his father was Scottish. He was our first governor of British Columbia. And he set a moral tone that was fascinating. With 8 engineers at his side, not armed once, he stood down a whole bunch of armed folks coming up from the U.S. I know we sometimes think about this now and hope it never happens, but he stood down a whole bunch of armed folks from the U.S. who, in the mid-1800s, were coming up to B.C. in the gold rush. They were armed to the teeth. They said they wanted to kill Indians, and they wanted to get our gold. And Sir James Douglas, how the heck he did this, I don't know, but it's a great story, with 8 engineers, stood down, and he said to them, "You're entering British Empire now. Put your guns over there and queue up over there to buy your license to go pan for gold if you want on the Fraser River." Astonishing. Sir James Douglas, Governor James Douglas, also negotiated with the Indigenous nations, particularly in the region I'm honored to represent here, the Saanich Nation. There were a lot of individual nations that entered into negotiated agreements with the Crown. Through Sir James Douglas, they're called the Douglas Treaties. And they're really fair and largely ignored over the generations. Now, Sir James Douglas specifically said to the Cowichan Band, and this particular court decision is about one specific village site on Layaloo Island that had been occupied for a very long time, as proven in this, by the way, the court case we're talking about is over 800 pages long, and much of it is about this story. What happened? What was the double cross? Was there a double cross? What happened? So you go back. Sir James Douglas, in 1853, and again in 1859, assured the Cowichan people that this particular village site on Layaloo Island, which I think is pronounced Tclunkenden, but I'm probably getting it wrong, that had been heavily populated, an important village site, would always be Cowichan lands. They set it aside in reserve. That's what Sir James Douglas did. He was an honorable man. Unfortunately, a little later in our history, along comes Colonel Richard Moody, who was given the job of being land commissioner for the province of BC. So the Cowichan had a specific commitment from the governor. This is where you can stay. This is reserve land for you. We're basically, by the way, we're taking everything else, but this is reserve land for you. And then along comes Colonel Richard Moody, who later on, not that much later on, within about, about 10 years later, he comes along as land commissioner and he buys the land for himself as a land speculator. So he dishonors the honor of the crown. He is, and as the court found out, and as the court described it, surreptitiously purchased the land for himself to make himself rich, while violating a commitment of the crown to the people of the Cowichan Nation. Now, time goes on, but the Cowichan people don't forget this is actually their land. They had a commitment from the crown, from Sir James Douglas. And the skullduggery of Colonel Richard Moody can't dishonor the crown. So the Cowichan never gave up. They launched a court case in 1911 saying, this is our land. The chief of the Cowichan actually in 1913 traveled to London, England, and met with King Edward VII to say, this is our land. Can you please repair this injustice that's been done to us? Well, as you can see, I mean, time marches on. They're still trying to get a resolution to this. The gold rush of 1858 was, again, what triggered Colonel Richard Moody's double cross. It's what, as I said, Sir James Douglas stood them down. The history of British Columbia is fascinating. I find it fascinating. But this case isn't about any kind of generalized discussion of Indigenous land title versus fee simple title. Not at all. Not ever. This is about a very specific injustice to a very specific nation over very specific land that was always theirs. That's what the court said. And then the court said, because the land now is basically Crown land and Vancouver Fraser Port Authority, so it's saying, and the BC government has no legal right to extinguish title. That's federal, as the honor of the Crown to these peoples. As my friend, who was once the Green Party member of the legislature representing me, he's Sartla First Nation, Adam Olson, in response to this Cowichan decision, tried to emphasize, quote, when First Nations win, the rest of society does not lose. And I'd like my honorable colleagues in this place to think about how significant it is for us all that what may knit us together, our sovereignty as a nation, is better protected by the honor of the Crown and its relationship with Indigenous nations than almost anything else. If we're dealing with a U.S. president that thinks we could be the 51st state, lots of luck. Section 35 of our Constitution says Indigenous lands are inherently held and are Indigenous title. Now, it's very important, again, and some of us have gone to law school in this place, like the Honourable Member for Nanaimo Ladysmith, so I know she knows this stuff, but you can't conflate title, Indigenous title, with fee simple title. It's like saying, if it's Crown land, Crown land is in a different kind of category, and in that sense, Indigenous title is more like that, akin to that. As my honourable colleague from Winnipeg has said, we have the Haida decision, the Delgamuukw decision, but really the Chilcotin decision of the Supreme Court of Canada made it really clear. Fee simple title is held specifically and personally and can be bought and sold. Indigenous title, as the court said in Chilcotin, is collective and intergenerational. So in the 5 seconds I have left, Mr. Speaker, please, all concerned, please let's not let people believe something that isn't true. This Cowichan decision doesn't threaten fee simple land or property rights. Let's wait for the courts to conclude and let's stay calm.
Comments, member for Langley Township, Fraser Heights.
Thank you. I want to thank my honourable colleague from Saanich Gulf Islands for her very interesting speech and a recap of some of British Columbia's history. I'm also a history fan, so I've read the whole case and would confirm some of the things that she said. But she's saying that Cowichan does not stand for the proposition that Aboriginal title threatens fee simple title. Well, the problem with that, of course, is that the Delgamuukw case that Aboriginal title gives the holder thereof exclusive rights to possession. And fee simple does the same. So you can't have the same on the same piece of land. I would also note that the Cowichan case was the first time in Canadian history, as far as I know, that a plaintiff First Nation group actually claimed Aboriginal title over privately held lands. The Chilcotin case, which you cited, did not. It was only public lands. So I'm challenging you on saying that Aboriginal title has no effect.
I'm a member for Sandwich Gulf Islands.
And thanks, my honourable friend from Langley. And it's already been quoted by my honourable colleague from Winnipeg that the court confirmed that the Cowichan Nation did not seek to invalidate or render ineffective fee simple lands. It is true there are some fee simple lands within the area that used to be the village. It's primarily federal land, it's City of Richmond land, it's Vancouver Fraser Port Authority. But the declaration by the court does not affect one iota the fee simple property rights of those people. The burden here is on the province of British Columbia that for 100 years ignored its duty to properly negotiate this dispute and to pay attention to the rights of the Cowichan Nation.
Questions and comments? Question et commentaire. The Honourable
Questions and comments?
House Leader.
So thank you, Mr. Speaker. And I think it is important to recognize when you think of the modern treaties or agreements between the federal government and First Nations and so forth, there has never been an example where the federal government has forfeited private property rights. And that's a challenge I put to conservatives. You know, give me an example where that has actually taken place. Is the leader of the Green Party aware of any?
Member for Sandwich Gulf Islands.
Well, I know a lot of my conservative friends are wondering about the expropriations built into Bill C-15 for Alto. Now, that's based, again, on what kind of title rights do we have in this country? Nobody's title rights in fee simple are absolute vis-a-vis our own government, but they are absolute vis-a-vis potential Indigenous title, which hasn't been in any way put forward, as my honourable colleague from Winnipeg says. There's no case ever where Indigenous title has resulted in fee simple title rights being lost for settler culture Canadians. Only fee simple rights are taken when a government expropriates for something big like the Mirabel Airport or what have you.
Un commentaire, l'honorable député de Repentigny.
The Honourable Member for Repentigny. Mr. Speaker, we can see, because my colleague just mentioned the Alto project, the major issues where the government has taken upon itself the power to no longer respect legislation on expropriation. So what we're talking about here today does seem related to the court decision and the value of homes and the funding of projects. So I would like my honourable colleague to go into more detail about why she's saying that there is no issue there. The honourable member for Saanich Gulf Islands. Thank you, dear colleague, for Repentigny. It is difficult now because now all of the issues are mixed together. And with that mix, we can see the beginning of untruths as well. So we can see where, for resource projects, it's important and necessary to create honest and complete consultation processes before the projects are set up. But at the same time, the decision here that we're talking about, the Cowichan, the decision by the British Columbia Superior Court, has no impact on issues linked to major resource projects.
Smith.
Thanks, Mr. Speaker. I can't help but reflect that if the circumstances were different, this would have been a very interesting discussion. I thank my colleagues, all of my colleagues, for their commentary on case law and all of the legal arguments that have been made. I'm just wondering, in the short time that we have left, if my colleague might reflect on a little bit on the fact that it is such a tragedy that the government didn't actually negotiate a treaty that would have allowed us to avoid all of this uncertainty.
Member for Sandwich Gulf Islands, a very brief response.
My friend from Nanaimo Lace, it's a shame that Richard Moody was a thief. And it's a shame the government of British Columbia didn't long ago negotiate in good faith with the Cowichan. It's a shame the government of Canada didn't long ago negotiate with the Cowichan. But this degree of shame, we must not let the honor of the Crown be dishonored now.
Resuming debate. Reprise débat, the Honourable Secretary of State, Rural Development.
Thank you very much, Mr. Speaker. I have the incredible pleasure of serving as MP for Northern Saskatchewan seat, and as an Indigenous person within the House of Commons, I just feel it's compelling to me to make sure we correct the record in terms of what the opposition motion is suggesting, Mr. Speaker. I want to point out I'll be sharing my time with the member from Winnipeg North. And before I go into my presentation, Mr. Speaker, I want to say that somewhere along the lines of discussion that it's important to call upon all our intentions when we talk about the country of Canada. And I want to briefly expand on that notion before I do my critique of the Conservatives' presentation. First of all, to clarify to all of Canada and the folks that might be paying attention to this particular debate, that the Prime Minister on May 5th, and I'm quoting, "The government will always defend private property rights. We immediately appealed the Cowichan decision. We have always defended private property rights. We always will, and we will always defend the rights of Indigenous peoples to build a Canada that is stronger, fairer, and more independent." End quote. Now, Mr. Speaker, that is the Prime Minister of Canada being very clear as to the whole notion around private property rights as the Cowichan decision impacts some of those statements. Now, I listened to the presentation by the leader of the opposition, and I rejected the premise of his presentation because it's not intended to provide solutions to the problems, Mr. Speaker, Deputy Speaker. It is really an intention to divide Canadians, in my opinion, for cheap political theatrics, Mr. Speaker. And that's something that should never happen in the House of Commons. I want to point out that from the whole perspective of Canada as a country, who helped build this nation were the First Nations, the Métis people, the Innu, and many other Indigenous groups throughout the land. We stood side by side through centuries of conflict, through centuries of negotiations, but more so through centuries of sharing the land, Mr. Speaker. And this is where I go along and I say, from our perspective, where is our responsibility to the country as a whole as we grapple through some of these issues that impact not only BC, but it impacts Saskatchewan, it impacts Alberta. And Mr. Speaker, we see many good examples of how Canadians, First Nations Canadians, non-Indigenous Canadians, Innu Canadians, Inuit Canadians, Métis Canadians, non-status Canadians, many from my own communities that are trying to keep this country together. And all of the discussions that we're having here, Mr. Speaker, it is all about strengthening and uniting Canada. And that, I think, is an important point that I want to raise during this discussion.
Right on, Buck.
So as I listened to the presentation by the Leader of the Opposition, and all I see is division from some of the points that he raised. On one hand, he's suggesting in his forum that we don't look at any other agreements of this sort. That's what I understood from his presentation. And on the next hand, the member from Edmonton Northwest says, well, we need to strengthen the treaties. Well, how does that work for them, Mr. Speaker? You cannot do the same speech with a contrasting view like that and try and be everything to everybody, because quite frankly, you'll be nothing to nobody if you don't make up your mind on which perspective that you want to support. So I see a huge divide within the Conservative caucus. They say one thing on one hand, they say another thing extremely different on the other hand, and sooner or later, Canadians are going to catch up to that. So as I stand here today, I tell the folks of Canada who is looking after Canada's interests and why is it important to me as an Indigenous person, whether we're from BC, whether we're from Saskatchewan, or whether we're from Alberta. So I think it is very clear that the member from BC mentioned earlier, there is no threat to private property ownership in this bill. So why did the Conservatives want to make it become a threat to Canadians? Because it's in their political interest, Mr. Speaker. Now, when we look at the Canadian perspective, as I mentioned before, I was raised in a household that our father was a World War II vet, and he was Métis, and his mom was an Indigenous woman, and every day when he came home from his service to Canada during the Second World War, he spoke about the value of Canada as a whole.
Right on.
And as an Indigenous person, he was proud to serve his country. So somewhere along the line, Canada's interests need to be maintained in all of these discussions. And it is only through respectful dialogue, discussions amongst the many provinces that are impacted, and I look at modern examples of today, who's strengthening Canada. I reject the member's notion from Edmonton Northwest that we are creating division. Absolutely not, Mr. Speaker. This government is working very hard to deal with economic reconciliation, to engage the Indigenous community on many fronts, Mr. Speaker, on many fronts. And I dare say I will compare our record on any day of the week to the Conservative record when it comes to Indigenous rights, Indigenous opportunities, and the Indigenous right to sit with us as partners in developing this great country. At the end of the day, there are many Indigenous people across this country that are trying to strengthen our country in all kinds of ways. Many times I talk to the people in my particular riding about social and economic justice for the Indigenous people, and we will achieve that, Mr. Speaker, as long as we have respectful dialogue between all parties engaged. In the Cowichan decision, Mr. Speaker, as I mentioned, we will respect private property ownership. Now, I'll go back to my father's service to this country. It is a beautiful country, Mr. Speaker. We had a number of my family members serve in the military, and that includes my older brother who served as a warrant officer in the Air Force, my younger brother who served as a warrant officer in the Army, and I had another sister that also served in the Air Force, and my daughter almost joined the Navy until her mother spoke her out of it. Yeah. Fact of the matter, Mr. Speaker, is we come from a proud military history within my family. And how did we get that service to Canada perspective? It came from our father, who was a World War II veteran, that spoke about the value of keeping Canada together, and he was one solid, strong patriot. And yet he was Indigenous. And if you saw the discussion here today and the talk about dividing the country over Indigenous rights versus private property rights, he would say to us, it's important to keep our country strong and together. So, Mr. Speaker, I would say again, our Prime Minister has been very clear. And for the record, I'm going to read to the opposition his quote. The government will always defend private property rights. We immediately appeal the Cowichan decision. We have always defended private property rights. We always will, and we'll always defend the rights of Indigenous peoples to build a Canada that is stronger, fairer, and more independent. Mr. Speaker, I end the quote, but I'd say those are the exact same words I think my father would say to us all. Let's make Canada stronger, let's make Canada fair, and let's make Canada more independent.
Questions and comments. Question et commentaire. The member for Yorkton Melville.
Thank you so much, Mr. Speaker. And I'm really curious about his brother who served in the Air Force. Would love to hear him have a conversation with him around the snowbirds and encourage them to also support the fact that they are such a wonderful representation to young people who would also like to join the Air Force. I just want to quote one thing from the British Columbia Supreme Court when it released its decision, concluded that the Cowichan tribes hold Aboriginal title to a portion of their lands, and it says, including private lands held in fee simple. Justice Young made a number of findings and issued a series of declarations that, according to, sir, I'm speaking to the member.
He's not even listening.
He's not even listening.
No, you're talking to him.
Order. Let's just order. Okay, order. Let's just have. We have a question. We'll have an answer. The honourable member for York Melville, quickly wrap up her question.
So here's the part that I would like him to respond to, because they're blaming us on this side of the House for causing the angst. Justice Young made a number of findings and issued a series of declarations that, according to Aboriginal legal experts and academics, create significant uncertainty for fee simple title holders in the province of British Columbia. And
we'll have to leave it there for the honourable member to have a response.
Thank you very much, Mr. Speaker. As we spoke about the value of Canada, and of course, I spoke about my family's service to Canada in the snowbird response, I would say this, that I think my brother, being a flight engineer with the Royal Canadian Air Force for, I think it's 26 years, I think we should never put any pilots or any of our members of service in an older aircraft that may not be safe. And I would also dare say, Mr. Speaker, that all the information that we have agreed to in terms of strengthening and protecting Canada more, pay attention to that perspective as well. As you talk about the snowbirds, they have the opportunity to showcase more of what they can do. The minister is absolutely correct. They have a great history, and they're going to always, Mr. Speaker, always make sure that they do Canada proud in many ways, shapes, and forms. But
Question and commentary. Questions, comments. L'honourable Deputy Gaspé.
The Honourable Member for Gaspésie, Les Îles de la Madeleine, Listigouge. Thank you, Mr. Speaker. I thank my colleague for the speech. I heard in his tone reassurance. But why then did the government appeal this case?
Honourable Secretary of State.
Mr. Speaker, what is important as we work our way through the court system, which will be dealing with this matter, not on the House of Commons, all I'm saying today, as a result of some of the discussions we're having, is don't misrepresent what the Prime Minister has stated in this House of Commons. That's why I've read very slowly 3 or 4 times his exact quote when it comes to private property rights. What is not fair, Mr. Speaker, is when the opposition starts off their presentation trying to divide Canadians, misrepresenting what the Prime Minister is saying, and not listening nor defending Canadian interests overall.
Questions and commentaires.
Questions and comments. The Honourable Member for Trois-Rivières. Thank you, Mr. Speaker. I thank my colleague for his very important speech. I'd like him to tell us how many times this question has been asked and answered in this House in the past few months. Once again, day after day, day in, day out, the same question has been asked and answered. The colleague talked about how the Prime Minister has expressed very clearly Canada's position on the matter. But how does it further debate to just ask the same exact question and get the same exact answer? That's not what Canadians expect of us. The Honourable Secretary of State for Rural Development.
Mr. Speaker, and that's exactly the point. Why does the Conservatives keep bringing up the issue in their effort to divide Canadians? I think it's time, and it's more crucial at this time, that we unite our country in many ways, and as many ways as we possibly can. Somewhere along the line, Mr. Speaker, somebody's got to start talking about Canada's interests. And I notice as an example, Mr. Speaker, is that the Alberta Northern Chiefs, First Nations leadership have come forward and they're defending Canada as a country. That's another example I would share with the Assembly, because they are doing their part to strengthen Canada through treaties. So, Mr. Speaker, a lot of great champions. Stop trying to divide Canada.
Order. Conformément.
Pursuant to Standing Order 38, it is my duty to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Saanich Gulf Islands, Labour, the Honourable Member for Kamloops, Shuswap, Central Rockies, Taxation, and the Honourable Member for Sherwood Park, Fort Saskatchewan, Employment.
Please debate. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And it's, really enjoyed listening to the Minister of State responsible for rural development. I think that he sends a very powerful message. A message that it's time in which we recognize the need and the importance of collaboration. working together to try to build that stronger Canada. Listening to what his father would have given him advice. Canada, building it together, building it stronger. I think it was good, sound advice. And it is something that you can actually apply today inside the House of Commons. We need to understand the motivation behind the motion that the Conservatives have put on the floor today and what it's about. What is the real purpose, Mr. Speaker? As the Minister of State for Rural Development said, that we want to have that Team Canada working together, working in collaboration. This actually does the absolute opposite. The Conservatives, using the term of private property and protection of private property, that's what they're trying to wrap it around, Mr. Speaker, and then implant in the minds of Canadians, in particular the residents of BC, that they are going to lose their home, that the potential is there, it's real, and it could happen. They're promoting fear where there is no need to promote that fear, because it's just not true. And the Conservatives know that, Mr. Speaker. The Conservative or the far right today understands the issue of private property rights. It hasn't changed. It's been happening for generations now, Mr. Speaker. They cannot cite one example, one case where a negotiated agreement, a modern treaty, a federal agreement between Canada and First Nations, where a homeowner was forced to sell their property, Mr. Speaker. The Prime Minister has been very clear. The minister responsible for Indigenous reconciliation and Crown Indigenous relations articulated it exceptionally well. And I would like to provide a couple of quotes. As the Conservatives try to give misinformation and misquote what it is that the Prime Minister is saying, let's be very clear. I just did a very quick search in the last few days. The Prime Minister said, May 5, the government will always defend private property rights. We immediately appealed to the Cowichan decision. We have always defended private property rights. We will always will. And we will always defend the rights of Indigenous peoples to build a Canada that is stronger, fairer, and more independent. Another quote, again, on May 5. All federal agreements with First Nations, with Indigenous peoples, and with rights holders protect property rights and protect Indigenous peoples' rights. Back in April, the Prime Minister stated, we will always advance viable legal arguments to protect private property. Federal agreements, including agreements about Aboriginal title, have always protected and will always protect private property. Mr. Speaker, the Prime Minister has been very, very clear, as the government has. Take a look, listen to what it is that the Minister of Crown and Indigenous Relations just said earlier today. And I would quote, it is already the Government of Canada's policy to only make rights and title agreements that protect the private property of Canadians. I can assure this House and all Canadians that we will not, nor would we ever, entertain or even consider an agreement where Canadians lose their private property. I don't know how much more clear the Government of Canada can actually be on the issue. So it begs the question, why is it that we see this type of a motion before we have us today? At a time in which we're trying to build a stronger, healthier nation. And in order to achieve the potential that Canada has, you have to recognize that you have to work in collaboration with the many different stakeholders and governments that we are obligated to do so, whether it's municipalities, First Nations, Indigenous communities, our provinces, and so forth. It is not an option. The Government of Canada needs, and there is an obligation. We're talking about billions upon billions upon billions of dollars of investment of major projects. There's a great deal of consultation and working that's taking place. Put it in the perspective of the importance of reconciliation. 94 calls for action, of which, Mr. Speaker, the government over the last number of years has been proactively moving forward on the calls for action. We have a Prime Minister that was just elected just over a year ago that is determined, as every Liberal member of Parliament is, to deliver for Canadians an economic and society in which we can all be very proud of. What does this motion actually do? Does it add value to what it is that we're trying to accomplish as parliamentarians? I would say no, it's not. It is not, Mr. Speaker. It isn't because it actually promotes misinformation. It causes Canadians to become worried where they do not need to be worried, Mr. Speaker. In many ways, it puts us a step back in terms of the issue of reconciliation. You have to ultimately appreciate, Mr. Speaker, that when you get divisive motions of this nature being debated on the House, yeah, it might be good for the far-right Conservatives to do some fundraising with it. It might fit the far-right agenda, but I would argue it doesn't fit Canadians' agenda based on the values that we have, because we understand the importance of reconciliation. We understand the importance of private property rights. And you can actually do, Mr. Speaker, both at the same time. And if you continue to do the collaboration that we have been very successful at doing over the last number of months since we've had a new Prime Minister elected, all one needs to do, Mr. Speaker, is take a look at the results. So on the one hand, you have at least the government that is prepared to do the collaboration that's necessary, and where there's a need for legal action, the Government of Canada will in fact be ready for the legal actions. But we're not going to abandon our responsibilities, nor are we going to allow for Conservative misinformation being let out and ultimately causing fear amongst the population. Because when we talk about reconciliation, Mr. Speaker, when we talk about Indigenous and non-Indigenous relationships, this motion does not help. The attitudes in many of the comments we hear coming from the Conservative Party, the far-right Conservative Party, Mr. Speaker, today, does not support the idea of reconciliation and working in a collaborative way in resolving the issues that are so important to our nation. If you want to build a stronger, a healthier nation, you have to recognize the role of First Nations, of provinces, and others, Mr. Speaker. If we don't do that, we will never hit the potential that Canada can hit. And that's why it's so critically important, Mr. Speaker, that we continue to look at ways in which we can improve the conditions, that we continue to look at ways in which the Prime Minister has set an agenda that will rise the level of support and economic and social benefit for all Canadians in all regions of the country. I would ask the Conservative...
Questions and comments. Question commentary. The member for Brandon Souris.
Well, thank you, Mr. Speaker. And the only result of the last two Liberal speakers they're going to have those speeches is the unfortunate of any Canadian who's had to listen to them will likely have a hard time tying their shoes tonight. But I digress. I just wonder where the BC Liberal caucus is. You know, the last speaker was from Manitoba. The one before that was from Saskatchewan. They're under the numbered treaties. Very different legal context when it comes to land claims and fee simple property. Our Conservative BC MPs have been out speaking about this issue that matters to British Columbians. Why are the BC Liberal MPs in hiding? Where are they? Why won't they get up and defend the disastrous Liberal record on this issue?
They're ashamed.
Thank you.
The Honourable Parliament Secretary, the Government House Leader.
Well, Mr. Speaker, as you know, it's against the rules for me to say whether the member has been in the House or not. But I can guarantee you he hasn't been listening, because there has been many members of Parliament from the Government caucus addressing this issue today. And if he would have been listening, he would have seen a good representation from BC. But I can tell the member opposite that this is more than just a British Columbia issue. This is an issue in which there is that whether it's from coast to coast to coast, Canadians as a whole want to see reconciliation. They want to see us move forward in making sure that, unlike what the Conservatives want, that there's more unity in the country as opposed to division that they promote.
Order. Question commentaire. L'honorable député de Pontigny.
Questions and comments. The Honourable Member for Repentigny. Mr. Speaker, I'd like to hear my colleagues' thoughts on something. Since the Liberals got a majority, thanks to Conservative floor crossers and other floor crossers, there seems to be a new way of doing things in committee, going in camera, shutting down discussion, not allowing us to thoroughly study things and get to the heart of things. And this is not necessarily what voters expect of us. Conservatives mentioned that the Liberals refused to even discuss this matter in committee. I'm far from being an expert. I know there are many different opinions about this file, but can you explain why you didn't want to let a committee really get to the bottom of this?
Well, Mr. Speaker, I appreciate the question, but I disagree with what he's implying in terms of a conclusion. I would suggest that we all need to be humble and working for Canadians first and foremost. The very first action that we actually did when the new members were introduced and we had the majority is we actually passed Bailey's Law. Bailey's Law was a Conservative bill. Yesterday, again, we talked about a Conservative bill and seeing it go to committee. I think that we will get collaboration where there's a need, and at times we might not necessarily agree with the unholy alliance of the Conservatives and the Bloc on issues. That's possible.
Questions and comments. Question and commentaire. The Honourable Minister.
I'm wondering if the member can speak to the risk of directing litigation through the House of Commons and the risk of blurring the line between judicial and parliamentary. Thank you, Mr. Speaker.
Parliament Secretary.
Mr. Speaker, I appreciate the question. It is so critically important. You know, in Canada, rule of law, respect for judicial independence. Here, you take a look at the motion. It's suggesting that we have a standing committee do what it is that our courts are in the process of doing, Mr. Speaker. It's somewhat bizarre if you really want to stop and think about it. Maybe what might have been more appropriate is that the official opposition might wanted to consider to raise the issue as a possible agenda item, change maybe the topic somewhat, maybe broaden it. I think they should have gotten better advice before they even introduced this, the motion. And as I say, it causes more damage, it's more divisive, it's a motion that shouldn't be supported, quite frankly.
Time for a brief question, the member for Winnipeg Centre.
Thank you so much, Mr. Speaker. And the member talks about how committed to this government is to reconciliation when Amnesty International is quoted saying that when it comes to Indigenous rights, this is quoted, we are stepping back. He talks about how great they are at consulting. Bill C-5, passed in record time, violates the constitutionally enshrined rights of Indigenous people, but yet S-2, that will take out discrimination against Indigenous women in Canadian law, First Nations women. Their excuse is they need to consult more, in spite of the fact this has been going on for years. I wonder if my honourable colleague can be a little more truthful about their record. Certainly, researchers and legal experts are noticing their failures.
The Honourable Parliament Secretary, a very brief response.
Yeah, thank you, Mr. Speaker. I like to think that I'm always truthful, and I can tell the member that every time I've had any form of a discussion or been a part of a discussion with the Prime Minister dealing with anything that deals with economic development, the Prime Minister is one of the individuals that constantly raises the issue of Indigenous people, concerns, and making sure that we advance the...
Order, and the time expired.
Resuming debate. Reprise débat. The Honourable Member for North Island, Powell River.
Thank you, Mr. Speaker. Imagine waking up one morning in beautiful British Columbia. The sun is out, the birds are chirping, and you can see the mountains, the forest, and if you're lucky, maybe even the ocean from your home. Life on the surface is actually pretty good, but that scenic reality masks a much deeper and much darker anxiety. The title to that home, that deed that you signed however long ago, may no longer mean what you thought that it meant. The financial investment that you built your entire life around, your home that you spent your entire life saving up towards, may no longer belong to you, at least not in the same way that you thought that it did. I wish I could say this was just some sort of reoccurring bad dream for many BC homeowners. The truth is, however, is that this uncertainty is already their reality today. This past August, the BC Supreme Court issued a landmark ruling that has since reverberated across the province and in time will undoubtedly reverberate across the entire country, recognizing Aboriginal title over 800 acres of riverfront property in Richmond, BC, including over the personal homes of individual citizens, declaring fee simple title invalid and ruling Aboriginal title a, quote, prior and senior title to the land. What this all means, well, no one really knows, which is a big part of the problem. But the ruling, which is now known as the Cowichan decision, has shaken BC politics to its core. And because around 95% of BC was settled without formal treaties, the consequences of this decision are not limited to 800 acres in Richmond, but potentially nearly the entire province itself. And while the decision is, of course, being appealed, and while the result of that appeal remains unclear, the consequences of the ruling are already being felt today. Homeowners are now being taxed on property that legal status is uncertain. Some are having difficulty selling their home, while businesses and industry groups have pulled billions of dollars in investment out of British Columbia as one of the key guardrails of the rule of law begins to break down. When a citizen pays their taxes, follows the law, maintains their property, and still cannot be certain that they own their own home, something has gone profoundly wrong. Private property rights are not a luxury, not an appendage to our system of government, not some kind of optional add-on to our society, to our democracy. They are quite literally the foundation on which Western civilization, capitalism, and our economy are built on. They form the basis for your savings, for your security, for your independence, for your autonomy as a human being. Without them, you own nothing. You are a slave to your government or whatever other powers there may be. And to have them infringed so suddenly, so brazenly, so harshly, without compensation, flies in the face of everything that it means to be Canadian. But it also wakes up a very important fact, that Canada is one of the few democracies in the world today without property rights enshrined in our Constitution. Left out of the Charter of Rights and Freedoms in 1982 by our old Prime Minister, Pierre Elliott Trudeau. And decades later, we are now living with the consequences. As a member of Parliament for a riding in British Columbia that itself is comprised of entire communities and homeowners facing similar legal uncertainty, it is my duty to speak out for my constituents and articulate my position and my views on this issue. For me, the defense of private property is and always will be a red line. It is not and should never be up for negotiation. It is in every way a fundamental human right, and we must never submit to trade it away simply to appease or placate the latest ideological fad or in the name of political convenience. Every citizen must know that their government will do whatever it takes to ensure that Canadians can trust that what they own is truly theirs without exception. Unfortunately, that is the exact opposite of what the Liberal government in Ottawa and the NDP government in BC has actually done. First, in 2018, the Liberal government instructed its lawyers, the Crown Counsel, to abandon their own citizens, ordering them to discard the long-held legal argument that the granting of fee simple private property took precedence over or extinguished any Aboriginal title claim. That directive remains Liberal Party policy to this day. Second, after the bombshell Cowichan ruling, the Liberals should have immediately halted any further agreements or treaty negotiations with First Nations unless explicit protections for private property were included. Instead, again, they did the exact opposite, pushing ahead with the controversial Musqueam Agreement that essentially recognized Aboriginal title over much of Metro Vancouver and nearly 1 million Canadian homes, with zero explicit protections for private property. And a member of Parliament, it should be noted, within their caucus, who has called for, in his words, the return of unceded land. Then they went ahead and negotiated 3 new, unprecedented sort of quasi-treaties, otherwise referred to as living agreements, all of which involved huge transfers of land and money and resources to individual First Nations, again, with no explicit protections for private property included. And when the Liberals and NDP are pressed on these contradictions, on their claims that they too support the private property rights of Canadians and will defend them at all costs, what is their rhetorical defense? They claim that they are appealing the Cowichan decision and hope that they will win. Well, Mr. Speaker, hope is not a strategy and prayers are not a plan. And the uncertainty created by their actions are already having real-world effects today. This Liberal government must act to restore certainty to homeowners now. They must act to restore confidence to businesses and industry and reverse the billions of dollars in investment that is fleeing British Columbia. And just as importantly, they must act to prevent the further fraying of the social fabric between Indigenous and non-Indigenous Canadians that their policies have caused. You know, before writing the speech, I actually looked up the dictionary definition of reconciliation. And you know what it is, Mr. Speaker? It's the act of causing two people or two groups of people to become friendly again after a falling out, an argument, or a disagreement. In other words, bridging divides and moving forward together. Well, this is precisely the opposite of what the Liberal and NDP have managed to accomplish over the last 10 years. Exactly the opposite. Driving a wedge between Indigenous and non-Indigenous Canadians, playing identity politics and prioritizing virtue signaling and rhetoric over tangible, real-world results. Instead of creating a framework that brought Canadians together as one, I see an agenda that has driven them further apart. Breeding resentment and frustration between communities instead of bridging divides and moving together as one country, as Canada. The vision behind our nation from the very beginning has always been one of working together toward a common goal, of achieving together what we could not accomplish on our own. We need to once again harness that vision to bring back and realize that mythology of Canada that includes as an essential component the mutually beneficial partnership between Indigenous and non-Indigenous Canadians from the fur trade to the War of 1812. But for that partnership to truly flourish, private property rights must remain sacrosanct. There must be no equivocation on the part of the government. They must never allow fee simple title and the rights of private property owners to be abridged or to be up for debate. In each new agreement with First Nations, these rights must be enshrined. In each and every court defense, the case to defend these rights must be made, and if absolutely necessary, if the courts continue to interpret legislation or the Constitution in ways that undermine Canada's sovereignty, our economic viability, or the rights of individual citizens, then whatever changes to that legislation or even the Constitution, however difficult, must be done. Thank you.
Questions and comments? Question comment. The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. Many concerns about that statement, but wondering if the member opposite has read the Musqueam Agreement. The Musqueam Agreement doesn't reference private property because it doesn't deal with private property. Agreements don't reference everything it doesn't deal with. We only talk about things that the agreement is about. So just wondering if the member opposite has read the Musqueam Agreement. Thank you, Mr. Speaker.
A member for North Island, Powell River. Motion.
Thank you, Mr. Speaker. You know, I agree with the member across the way. It doesn't mention private property, and that is the problem, is there are no explicit protections for private property in the agreement, and we're currently in a legal scenario. We're in legal limbo as we await the appeal process of the Cowichan decision. As we have said as the Conservative Party, as we have demanded, every new agreement, every new treaty with First Nations must have explicit protections for private property. It is a fundamental human right, and that is what we are going to continue to push for on this side of the aisle.
Questions and commentaires.
Questions and comments. The Honourable Member for Gaspésie-Les-Îles. Thank you very much, Mr. Speaker. I'd like to thank my colleague, who I appreciate greatly, for his speech. And when I listened to him, I was wondering what is he really proposing? What we see in this process is that the Conservative Party is attacking the guideline number 14, saying that we didn't provide a description. And when you read this guideline, it's possible for the Attorney General to plead for explicit title claims. But now they're talking about stronger property protection. I just want to be sure, are they asking us to reopen the Constitution and to write property rights into the Constitution?
Member for North Island, Powell River.
Thank you, Speaker, and I thank my honourable colleague for the question. The first thing to do is to remove these guidelines that have legal guidelines that have restricted our Crown Councils from defending private property rights with all of the tools in their toolkit. Number two, there should be no further agreements or treaties made with First Nations without explicit protections for private property embedded within. And then as far as what comes beyond that, what has been my position, as I believe is also the position of my colleagues, is when it comes to defending private property, whatever it takes. Obviously, we are going to and support the appeal of the Cowichan decision through the courts, but there is no step along this way, along this path, where we are going to allow the private property rights, the fundamental human rights of our fellow Canadians to be abridged and to be up for debate.
Questions, comments. No member for Okanagan, Lake West, South Kelowna.
Thank you, Mr. Speaker, and I'd like to thank the member for North Island Powell River for his intervention today. And all throughout today's debate, Liberals continue to say that it's Conservatives that are being divisive, that are creating misinformation, among even worse items. Now, the mayor of Richmond, Mr. Brody, Malcolm Brody, wrote in a letter from the city to all the landowners that were affected. The city of Richmond was the only party at trial arguing that the Crown grants of fee simple necessarily extinguish Aboriginal title. The federal and provincial crowns were each laboring under litigation directives that constrain their ability to argue extinguishment. So, Mr. Speaker, my question to the member is this. Does the member believe that the mayor of Richmond, Malcolm Brody, is offering misinformation and being divisive, or is he simply calling out both the federal and provincial governments for their failures to make arguments to protect BC's private property owners' rights?
Honourable member for North Island, Powell River.
Thank you, Mr. Speaker. I thank my honourable colleague for the question. What the mayor of Richmond is doing is he's simply stating the facts as they are. This federal government and the provincial government in BC failed to make legal arguments to defend private property. That is a fact. But what is maybe even more inexcusable is after that court decision was made, they continue to go out and sign agreements, whether it's treaties in British Columbia or the Musqueam Agreement, that did not explicitly protect private property in this new era of legal uncertainty that we now find ourselves in. That is not fair to homeowners in BC. That is not fair to private businesses. And we need to get a government that is actually putting the private property rights of Canadians first.
Hear, hear, hear. Debate. Please do that. The honourable member for Pitt Meadows, Maple Ridge.
We're talking today about a very important issue that's impacting all British Columbians and has implications for all Canadians: property rights. So in 2021, the census, 2/3 of British Columbians households owned their own home. And it's 66.8%, and it's about the same throughout the country. 1/3 are renters, and a good many of those that are renters want to eventually own, but it's become increasingly difficult under the past decade, under the Liberals, due to the cost of housing, rising inflation, and less disposable income to pay for things like groceries, for gas, taxes, let alone down payment towards a home. Mr. Speaker, people work hard to pay down their mortgages. Decades. I remember one worker I spoke to not that long ago telling me he just working 7 days a week, hours and hours, very long days, just to keep a roof over his family's head and to keep their home. Nothing fancy, he told me. He told me he can't give his body a break. I think of myself when I was a new teacher, buying a condo, working long hours, extra hours to go towards the mortgage. I think of seniors, Mr. Speaker, who have spent a lifetime paying down their mortgage and want to use it as a nest egg to provide financial resources and security for their retirement and pass it on to their children and grandchildren. I don't like saying this, but this is being undermined today. In British Columbia, we sometimes have earthquakes, small earthquakes. It's good that we haven't had large ones for many, probably over 100 years. I've felt them. There's tremors and there's foreshocks, there's aftershocks. But the foreshocks around the world sometimes indicate that a big one's coming and shouldn't be ignored. Private property rights, there are some shocks happening. And they can be ignored by the Liberals. They can just ignore it. Oh, nothing's happening. Same old, which is what we hear from them. But there's something dangerous that is looming. That's already here. Mr. Speaker, private property rights are often considered as one of the foundational elements of a free and stable economy. It's important because it impacts people's economic freedom, their personal security, and investment. For generations, Canadians have understood a basic principle. If you lawfully purchase a home, if you hold title to your property, if you invest your life savings into a piece of land, not just your life savings, but your sweat, your work, your hours, that the law protects that ownership. That certainty is not a privilege. It is one of the cornerstones of democratic society. It's what allows families to build a future. It allows farmers to invest in their land. It allows businesses to create jobs and communities to grow. Where certainty in property rights, where there's uncertainty, confidence erodes, investments dries up, families hesitate, communities stagnate. And this is a big concern. I had a booth at a home show over the past weekend for several days, talked to hundreds of people, and this topic about property rights came up over and over again unsolicited. It's not just what the Liberals call fear-mongering. It is what people are feeling in the community, and it's not some bad dream they're having. What is it? It's a reality. There's things that are happening. And the Liberals have been asleep at the switch. That's a train switch. You know, which way the train goes, Mr. Speaker. I know it's maybe an old expression. But they're more than asleep. Their incompetence. Their incompetence, very much so, is a key reason that we find the mess that we're in. Last August, the Cowichan Tribes versus Canada decision of the BC Supreme Court threatened the private property rights of landowners in British Columbia and potentially in other provinces. In one act, the judge deemed the Aboriginal title has prior and senior rights over fee simple home ownership over 800 acres in Richmond worth $1 billion. It's setting a precedent that other judgments can be made on. That is the concern. That's a big concern. It sets a precedent that can expand. It's already serious enough. This ruling has shaken the foundations of British Columbia's economy and sparked fear among landowners province-wide. As Conservatives, we're bringing this up. What we're hearing in the community, what places like Richmond and the owners are saying. I've met with different ones, farmers in their land who've spent generations in their land clearing and working and spending the money and how this is all being threatened. And they poo-poo us, Mr. Speaker. They say, oh, you're just barking up a tree. We're not barking up a tree, Mr. Speaker. This is serious, and they need to take it seriously. And they can't just say, oh, it's under the courts. It's in the court's hands. Let's just forget about it. All's good. Just fall asleep. Go back to sleep. Well, we're not going to go back to sleep. We're going to fight for this. We're going to fight for landowners. We're going to fight for homeowners. We're going to fight for our communities. And we're going to try to wake up the Liberals because they've gotten us into this situation. British Columbians bought their homes, paid mortgages, and followed the law. But because the Liberal government directed its lawyers not to argue for property rights in the Cowichan case, the judge didn't protect private property. They didn't make an excuse. And you know what? The Liberals will say, oh, but we are fighting for it. But you know what? They didn't actually intervene and say they would appeal the court until the very last day. I'd say, well, I guess we better do this. This might not be very good for us electorally. That's what they're thinking of. It's all electoral. It's all speech. Under the Prime Minister's leadership, the federal government continues to maintain the same legal directive adopted in 2019. Litigation Guideline 14. That directive led Ottawa to abandon the argument in defense of fee simple title in British Columbia, including in the Cowichan case. Mr. Speaker, it's still on their website today, unless they took it out this morning. It's on their website today as far as not encouraging the lawyers, government lawyers, to stand up for fee simple property. They're saying we're fear-mongering. Not true. They're trying to minimize something very serious situation that British Columbians find themselves in. They say we're being racist. It's not true. Mr. Speaker, Conservatives believe in reconciliation with Indigenous people. It's essential. It's a moral obligation, a constitutional responsibility, and an opportunity to build a stronger Canada founded on mutual respect and shared prosperity. But reconciliation cannot succeed if it's built on ambiguity, secrecy, and legal confusion. What does this all mean what's going on here for private property owners? What does it mean for municipalities? What does it mean for the future land claims and development projects? Because it's impacting. It's impacting. British Columbia has been an important engine in Confederation, in economy, but it is not the same. We're struggling here economically, development. You know, when you don't have the development, when businesses are afraid of expanding, that has an impact on jobs, and lack of impact on jobs impacts taxes, revenues, which impact healthcare and everything else. Thank you, Mr. Speaker.
Questions and comments? Comment here. We probably have time for one question. The Honourable Minister.
Thank you, Mr. Speaker. I would like to acknowledge that, yes, I also speak to many residents who are concerned and have questions. But the important thing is to talk with residents and to explain the issue and not to stoke the fear and the confusion. In December 2025, the New Brunswick Court issued a decision on Aboriginal title, which ruled differently. So we have two court cases, two different decisions, and that's why we've appealed Cowichan, because there is a need for further clarity. But, Mr. Speaker, I haven't met a Conservative yet that's read the Musqueam Agreement. Section 5.1 of the Musqueam Agreement specifically states that it's not a land claims agreement. Can the member opposite please explain, if this isn't explicit enough, what would it take? Thank you, Mr. Speaker.
The Honourable Member, in about 45 seconds or less.
Mr. Speaker, they're ignoring what's happening. Do you think that the businesses, the homeowners, are just making things up, that they can't renew their mortgages, or businesses can't get loans? Are they making that up? That's in the law. It's on what's happening. It's the uncertainty. It's what's not in the treaties and the agreements. And so this causing problems. It's causing problems within the Lower Mainland. It's causing problems within other First Nations. Like, it's a mess, and you can put that on the Liberals. Thank you.
Order. It being 5:25 p.m., it is my duty to interrupt the proceedings and put forthwith every question necessary to dispense of the business of supply. The question is as follows. Mr. Schmale, seconded by Mr. Van Popten, moved that 1. The Cowichan Tribes v. Canada decision created massive uncertainty around fee simple property, the legal basis on which Canadians and businesses alike own their lands, homes and lands. 2, this decision is already having significant impact on home values and the financing of projects. 3, may I dispense? Yeah. Wonderful. If a member participating in person wishes the question be carried or carried on division, or if a member of a recognized party wishes that the motion be adopted by a recorded division, or invite them to rise and indicate to the chair, the honourable member.
Speaker, we would like the recorded division.
Order. Pursuant to Standing Order 45, the division stands deferred until Monday, May 25th, 2026, at the expiry of the time provided for oral questions. And I see the member for Winnipeg North is rising on a point of order. The honourable member.
Thank you, Mr. Speaker. I suspect if you were to canvass the House at this time, you'd find unanimous consent to call it 5:30 at this time, so we could begin private members' hour.
Is there consent to see the clock as 5:30? Agreed. It being 5:30 p.m., the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business consideration at report stage of Bill C-230, an act to amend the Financial Administration Act and to make consequential amendments to other acts, debt forgiveness registry, standing in the name of Mr. Chambers.
There being no motion at report stage, the House will now proceed without debate, putting the question on the motion to incur in the bill at report stage. Mr. Chambers, seconded by Mr. Albus, moves that Bill C-230, an act to amend the Financial Administration Act and to make consequential amendments to other acts, debt forgiveness registry, as amended, be concurred in at the report stage. If a member participating in person wishes the motion be carried or carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I would invite them to rise and indicate it to the chair, the honourable member for Simcoe North.
I believe we'd like to carry this on division, Mr. Chair. These are the...
Is it agreed to carry it on division? Agreed. I therefore declare the motion carried on division. Mr. Chambers, seconded by Mr. Albus, moves that Bill C-230, an act to amend the Financial Administration Act and to make consequential amendments to other acts, debt forgiveness registry, be now read a third time and do pass. Debate. The honourable member for Simcoe North.
Thank you very much, Mr. Chair. It's an absolute honor to be with you here tonight and all of my friends from all sides of the House because it is an important day for taxpayers, but it's an important day when you are a member of Parliament and you have the honor and the opportunity to bring forward legislation that makes amendments to the statutes of Canada. It is a lottery system. I was lucky enough to be given the opportunity to be chosen early in that lottery, and I wanted to pick an idea that I believed would have widespread support in this chamber. And I would like to thank all of my colleagues from all sides of the House in getting the bill to this stage, which included passing the bill to go to committee, a lengthy committee study, and some thoughtful amendments from in fact, all parties at the committee table, and bringing it back to the House. So I believe, and it is my hope and sincere pleasure to see this bill carry forward here this evening. And I want to thank those individual members, which I will return to later, but to put aside the partisan politics. You know, we tangle in this chamber from time to time on some very controversial issues, but at least on this issue, with respect to greater transparency for taxpayers, this is an issue that I think you'll see unites all members of this chamber from each party, no matter their political affiliation. Bill C-230 really will create a registry for the government to disclose every time that it writes off large debts that corporations, not individual taxpayers, but that corporations who have their debts waived off, those amounts and identities of those corporations will be published in a corporate registry. That will enhance the level of transparency that taxpayers deserve from our tax collecting authorities. The reason this bill is here before our chamber is because we noticed in the public accounts that there were large amounts year after year being written off. And upon inquiry, members of Parliament from multiple parties, including the government side, had probed the government on additional information. We were met with not great answers and a lack of transparency and a suggestion that we could not receive, parliamentarians could not receive this information because of the privacy provisions of the Income Tax Act. And so, given the opportunity in drawing that high lottery number to bring forward a private member's bill, I thought, well, why don't we change the law and change the privacy provisions in the Income Tax Act and require the government to disclose this information? After all, I think it's a matter of the public interest when large debts that are owed by corporations are written off by the government. In fact, just a few years ago, 10 corporations, just 10, had a total of $1.1 billion written off between all 10. A lot of people go to work hard every day and they pay their taxes honestly, and they fret about filing their taxes on time, and they worry that they might have made a mistake. And they do so honestly and in good faith because they know that paying taxes helps pay for this wonderful, beautiful country that we have and all the social services that we all enjoy. But they are frustrated because they learn that while they're working hard to pay their taxes, that the government is unable to collect millions and indeed billions of dollars each year from corporations that corporations owe the government. And so that is the real basis for which this idea came to the floor of the House and was proposed as a private member's bill. I would say I learned my lesson in the last Parliament. I believe that I had a wonderful idea to increase the penalties for money laundering offenses, but I didn't have as much time to work with all members of the chamber to make sure that it was in a position that would receive broad-based support to have it pass. So this time, I wanted to do my homework. I consulted with my own team, my own colleagues who encouraged me to continue. I consulted with members from other parties who thought that on its face it was a good idea, and so here we are. So I appreciate the opportunity to address this very important issue, but I appreciate the opportunity that my colleagues have given me to recommend this bill that, of course, made it to committee, and as I said, had some thoughtful amendments along the way. Now, there was an amendment at committee about the threshold. We increased the committee recommended increasing the threshold from $1 million to $2 million. And while I don't believe that we are at an ideal state, I think that in this environment, we can hold out for the perfect and get nothing, or we can make some compromises so that we all can have some level of say and influence over a bill and actually move and make progress on behalf of taxpayers. So I'm happy with where we landed, although I would have preferred to keep a lower threshold. In fact, even some members on the committee wanted the threshold to be as low as $100,000. But I think where we've landed is an opportunity to start this registry in a way that will give taxpayers more transparency about how their money is being collected and indeed effectively how it is being used. I would also like to commend the work of Senator Percy Down in the Senate, who has been not just encouraging me along the way, but has his own bill that will also increase transparency requirements at the CRA that he has passed 3 times from the Senate and will come to this chamber later next month before we break for the summer. And so this issue and these 2 bills, they actually go hand in hand, but this chamber will have time to opine on Senator Down's bill at a later date. Now, I do think it's important to consider the process. I mentioned we saw the public accounts. We saw amounts going up. We asked for more information. We then submitted an order paper question. That question was not answered in the House. It was not answered at committee, but a friend in the other place, Senator Wells, was kind enough to submit a similar question, more detailed question, and from those answers was the genesis and the basis for which we designed this bill, because it outlined the number of corporations and the amounts that had been written off. So that is the way the process worked in order to get this bill. It was some hard research, some asking questions, collaboration, and really an opportunity for us to use all of the tools in this chamber in order to find out more information and then propose a law to fix it for the benefit of taxpayers and indeed the country. So it is my great honor that I'm standing here tonight with this opportunity to propose a change to the statutes of this country. When you are elected, as I mentioned before, many people could be here for multiple years, indeed decades, and not have the opportunity because it is a lottery system. And I took that opportunity very seriously, and I wanted to put something forward that I thought would have widespread support from all members in this chamber. And of course, I can't help but recognize that in the new environment that we are currently in, with respect to the government now controlling a majority of the seats in this chamber, I have still felt good cooperation and collaboration from members of the government, including the parliamentary secretary and the House leadership team, in order to, which I believe, advance a good piece of legislation and a positive contribution to public policy in this country. I believe it is time that taxpayers have more transparency because we need to hold not just the government accountable, which I find to be an important part of my role here as an opposition member, but we also need to hold accountable the agencies with which the government entrusts to carry out the fundamental activities that that agency is supposed to carry out. The Canada Revenue Agency's primary objective is to enforce the Income Tax Act and collect the monies owing to government. And so this bill will bring a level of transparency and accountability to those activities at the Canada Revenue Agency so that all members of Parliament from all parties, and indeed all Canadians, will have greater line of sight and transparency into the activities of the Canada Revenue Agency. And we have to acknowledge that the agents and the employees of the Canada Revenue Agency, by and large, work very hard day in and day out to complete their duties. I will say at the same time, I think they have been unfairly burdened with additional activities and requests from the government that have asked them to do things that are far outside their core mandate. And so I think this bill will also help refocus resources at the Canada Revenue Agency so that they can get back to fulfilling the objectives of their core mandate. It would be inappropriate for me at this time to not recognize some individuals who helped me along the way. I have to pay special tribute to our legislative drafters who fielded many late-night questions and phone calls that were outside of business hours because they were helping me get this bill into a good shape before it had to be tabled back in September. That is Marie-Claude Hébert and Marie Danek. They did fantastic work. I don't think people understand that, while many government ministers and departments have armies of lawyers at their service, members of Parliament have wonderful resources that are able to support us in our role, but those resources are quite small in number, but they pack a mighty punch, and they have been very busy supplying members in this chamber with great ideas and legislative work at private members' bills that members introduce on a daily basis, and that is done by a very capable and thoughtful team here in the House of Commons. Thank you. The member from Calgary Midnapore, who's been fantastic to work with as our shadow critic. The member from Louis Saint Laurent, who has been our shadow critic for CRA. The member from Calgary Rocky Ridge, who originally turned me on to this idea a few years ago, and he deserves a great round of applause because he has been an advocate for greater transparency at the CRA. I mentioned the parliamentary secretary earlier, and although we've tangled many times on the Finance Committee, they actually moved me off that committee maybe because of those tangles, but we did find a way to work together well together. And I joke, but we do end up working on things in collaboration that we think will enhance this country and do great things for taxpayers. The Minister of Finance, who I also have many criticisms for, was very gracious to set me up with his staff to work on this bill, and we did receive some amendments, as I said, and I worked with them, and that is Sean Matthew O'Neill, who I appreciate very much for his help during this process. And there's one individual, finally, I'd like to thank, is Jay Gamma, who's an individual from Edmonton who's been on this idea as well and been talking about this idea for a couple years. And I would be remiss in my final minute if I did not pay tribute to the late Jim Flaherty, for whom was a close mentor of mine. And I'm wearing green today in his honor. And if it were not for him, I would not be standing here in this place. So I appreciate the opportunity to have this bill be voted upon, and we'll see where it goes tonight. But I want to thank everyone in this chamber for their support and their collaboration in doing something good, which I believe is in the best interest, in the public interest, and the best interest for citizens of this country. Thank you very much, Mr. Chair.
Here. Questions and comments. Question commentaire. The Honourable Parliamentary Secretary of the Government House Leader.
So thank you, Mr. Speaker, and I do applaud the member for just his general approach in dealing with Bill 230. I think that he's identified an issue that has been a priority for the government and has put forward something in which, by working in a collaborative fashion, as I say, might have made some changes at that committee stage that he would have maybe liked to have added a little bit more value from his perspective to. But the idea of working in collaboration to deliver for Canadians. And I do applaud him for taking that initiative. It's more of a comment than it is a question. I think that hopefully we'll see more collaboration on private members' bills and government bills in general for the benefit of all Canadians.
For Simcoe North.
Thank you very much, Mr. Chair. I certainly appreciate the comment from my honourable colleague, who is no stranger to standing up and speaking in this House, but I appreciate that he took the time to not just meet with me about my bill, but to discuss an opportunity with which we could maybe see this proceed, which I think is an example for all of us that if you have an idea that we think is good for the country, but that has widespread support, that we can toss aside some of the partisanship from time to time and work in the best interest for all Canadians in this country.
Questions and comments? Question et commentaire. The member for Calgary Crowfoot.
Thank you, Mr. Speaker, and I thank the member for his kind words when he identified me as under my former riding name. But it was, yes, I'm very pleased that he's been able to move this legislation. It's important, and the reason it's important is because we have actually seen a deterioration in the information available to parliamentarians over the last number of years, where they actually disclose even less information than they once did when we make inquiries through the order questions on the order paper or through the access to information system. So there is a real need for this, and the problem is becoming more urgent, not less. And so if he would like to comment on the reason why we need this legislation.
The honourable member for Simcoe North.
Indeed, the wonderful member from Calgary Crowfoot did identify, at one point, the Canada Revenue Agency used to disclose what the single largest write-off was in a particular fiscal year. That practice all of a sudden changed. But from my understanding, the Income Tax Act privacy rules didn't change, the Privacy Act rules didn't change, so it did not make much sense that the government or the Canada Revenue Agency would provide less information to the public and to this chamber than they did previously. And so that really was a significant driving factor into why this bill is here before this House tonight. Thank you.
Question et commentaire. L'honorable député de Gaspé.
Questions and comments, the honourable member for Gaspésie, Les Îles de la Madeleine, Listigouche.
Je veux saluer la contribution du.
Thank you, Mr. Speaker. I thank my colleague for this bill. We in the Bloc Québécois feel positively about making our democratic system more transparent. We think it's a good idea for taxpayers to know when the government forgives debt. So I commend him really on this bill. And he's gotten cross-partisan support, which is significant. There was the Chrysler example. A $2 billion loan was forgiven. If something like that happens in the future, if there's loan forgiveness in the future and we find out about it, how will that change public discourse?
I'd like to thank my honourable colleague for that question, and I believe as a first-term MP and is doing a wonderful job in his role and bringing his expertise here. Yes, if there are large write-offs in the future that exceed the threshold, that information will become public, which then means parliamentarians and the public gets more information about how their tax dollars are being used or not collected, which means we can then refocus the resources at their agency to ensure we recover the money from corporations that are owed, or we pass laws to make it more difficult for corporations to skip out on their tax bill. And I would also just like to mention at this time the member from Abitibi-Temiskaming, who was a wonderful addition to our work on committee that helped this bill get here. Thank you.
Resuming debate. Reprise débat. The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Mr. Speaker. And it's actually a pleasure to be able to stand and rise and speak to Bill C-230. I made reference to the efforts from the member opposite in regards to bringing forward the legislation. The government sees the legislation as amended, Mr. Speaker, as something that's very much a part of what it is the government is wanting to see happen. More accountability, more transparency, protecting the integrity of the CRA and the system, because it's of the utmost importance. When we take a look in terms of the issue of collaboration that we made reference to in the form of the question, you know, I like to think that in the last week or so, we've actually seen private members' bills. Today we're talking about 230. We had Bailey's Law that was passed through. We had legislation, and again, another conservative piece of legislation that we were okay with in getting it off to committee. I believe it was just yesterday, Mr. Speaker. And today, and that was with regards to silver alerts. Today, we're talking about another important piece of legislation. The principles behind it is very sound. At the end of the day, people or Canadians don't mind paying taxes as long as there's a sense of integrity within the system, and most importantly, there's a sense of fairness, Mr. Speaker. People are prepared to pay the taxes as long as they feel that it's fair and equitable. When we often talk about taxes, people are very much concerned about nowadays how it is government might be able to assist on the issue of affordability and the importance of taxation policy is absolutely critical during different types of business cycles that a nation goes through. That's one of the reasons why we have to have the confidence of the citizenry in regards to taxation policy. So that in this case, a year ago, just over a year ago actually, the Prime Minister, for example, gave the tax relief on the carbon tax. Then it was followed by a substantial tax cut that provided support for 22 million people. We have the rebate portion from the GST, recognizing the issue of groceries and essential items being converted over into a new program, a new benefits program. 11 million Canadians are going to benefit by that. Taxation and taxation policy makes a difference. It matters. And that is not possible unless we have the confidence of Canadians in the sense of that the system is fair and there's accountability and there's transparency. This is what it is the government has focused a great deal of attention on. And when we look at Bill C-230, it adds value to that, Mr. Speaker. And what was really encouraging, I've had the opportunity, in particular over the last week or so, to amplify the word collaboration. You know, the government is very much focused on recognizing where there's value in private members' bills. And we would look for the Conservatives in recognizing the same thing in terms of government bills. Where there's value, we should try to get through the House, bring them into committee, allow them to get through the third reading, and ultimately see the passage of legislation. Canadians want parliamentarians of different political stripes to work together, recognize where we can have a social policy change or a shift or a modification, whatever it might be, and to act on it. And that's exactly what's happening here this evening, where we have now before us legislation that ensures more accountability for those corporations that ultimately get written off in terms of money owed to CRA. Money owed to CRA that is not collected has an impact on our general revenues. I think there is an obligation for government to ultimately show where it can that transparency, at the same time respect privacy law concerns. We need to be sensitive to the privacy laws that we have. The legislation that we have before us deals with that. It affords CRA and the government, ultimately, to provide more information. I believe it's $2 million. There was an amendment that was brought forward in terms of the threshold. I'm not 100%, but I think it's around that $2 million mark. And that means having that registry, having that data. Information is so critically important, not only from a government's perspective, but also from an opposition perspective. Because if it's done in the way in which it could be done, Mr. Speaker, the real winner is actually the taxpayer. Because they should have, as I say, that sense of taxation policy and where it is that we're falling short. When you think of corporations and small businesses in general, a vast majority, Mr. Speaker, pay their taxes, and at the appropriate time, they pay their debts, and they're able to make sure that their contributions, or through those contributions, we all benefit by it. As a society, we benefit. And that's why, when we talk about that accountability and transparency, there is a percentage that's there, a very real, tangible percentage, where revenues, a significant amount of revenue, is in fact lost. Having a better understanding of where that's coming from, it could be everything from the types of companies, all sorts of things can be drawn out if you have that information being made available, while at the same time respecting privacy laws. We all benefit by that, Mr. Speaker. And as I say, for us, when I say us, I could use the word collectively, but for the government of Canada, particularly our new Prime Minister, the issue of accountability, transparency, is applied when it comes to government expenditures and the collection of the finances that we get in many different forms, Mr. Speaker. It's being responsible with tax dollars. It's ensuring that at the end of the day that there's smart decisions that are in fact being made on behalf of the taxpayer. And it's recognizing that there's no doubt when the registry is fully up and operational, there's likely going to be a great deal of attention drawn to it. That attention is not going to be all good, Mr. Speaker. We recognize that in government. But we have standing committees that can actually contribute in a very positive way by going through the types of documents that we're able to draw out and improve the system. I realize that my time is closely coming to an end, Mr. Speaker, but I just want to emphasize one other thing, and that is in regards to the incredible people that actually work for CRA. The Canada Revenue Agency is second to no other agency, I would ultimately argue, in the world in terms of being able to support, to the degree in which they support, those private people, individuals, the people we represent, to the businesses, and so forth. It is an incredible task that they have. It's something that I personally wouldn't want, Mr. Speaker, but I applaud the efforts in which I would ultimately argue 90% plus put in and day out, so that governments at different levels are able to have the monies that are necessary in order to provide those absolute essential services, whether it's healthcare or provide supports to grow the economy, Mr. Speaker, all of which are absolutely critical, and the reason why it is that taxes are so important. But at the end of the day, we want transparency, we want accountability, we want the taxpayer to know that they have a system that they can have confidence in, and this government will always push for people paying their fair share, Mr. Speaker. Thank you.
Resuming debate. Reprise du débat. L'honorable député.
The Honourable Member for Saint-Hyacinthe, Bagot-Acton. Thank you, Mr. Speaker. I'm happy to be here to speak to this bill. I sit with my colleague on the International Trade Committee. We work very well together. I was there the time the Minister of Industry testified in committee, and my colleague really hounded the minister and was very intense with her about Stellantis. And I'm sure that was partly behind my colleague's desire to bring us this bill. Now, on October 22nd, 2018, this was written, It's not very current, but this is called the Liberal government writes off $2 billion loan to Chrysler. This was from CBC News. And the article also says, just under the title, "We are still in the dark." A loan granted to them in 2019 during the economic crisis to Chrysler. It was $2.6 billion, and it simply disappeared discreetly. It was waived, and to get information about that, you had to really dig deep into the public accounts of 2018 just to find out about that. So the government was not exceptionally transparent about that. The bill before us today, C-230, I'd like to say right off the bat that the Bloc Québécois will be supporting it. This bill would enhance federal government transparency by creating a public debt registry. It will be a searchable online database for bills, for loans $2 million or more, which are waived, written off, or forgiven. Why is this necessary? Well, because the Canadian government really has a tendency to not be transparent about debts it writes off. As with the Chrysler case, we had to change this in committee. Especially, we debated the threshold and other types of amendments. So we improved the bill in committee. The bill was already perfectly fine, but we improved it even further. The government will be required to create the registry within 18 months of this bill receiving royal assent, and the government will also have to protect private information and confidential information. The president of the Treasury Board, though, will have to justify any data being protected for confidentiality reasons. 230 would amend the Financial Administration Act to ensure that the president of the Treasury Board institute a debt registry for debts which have been written off. And the bill would also make amendments to other acts. So let's go through the goals of the bill.
We're adding a clause about management of public finances so that the Treasury Board has to establish a online database for a trust or a person or individual when the value of the debt is $1 billion or more, for example, in the case of Chrysler, and also require under federal law when the debt expires, whether the debt is partially or fully waived. If no payment is made, they must be in the registry. And in 2008 with Chrysler, the government, if it believes it will not be able to recover its money, then they decide to remove it from its books, the debt. For example, if the company goes bankrupt, a partial write-off would be if they decide to write off part of the amount of the loan, and then the remainder is refunded. So if the company is on the brink of bankruptcy and the company can only recover a fraction of the loan, and sometimes a write-off occurs when the person owed the money. Sometimes they make an error. And this is a good legislation because the registry will have a certain amount of information, and it'll include names, the name of the trust or the company or the individual. Or if it's a numbered company, we'll have to have its recognizable name, not just the number on the register. And if a person is subject to a waive, or if the loan is waived or forgiven, they will have to provide information to the Treasury Board, and this registry will be formed within 18 months of this law act coming into force. So all of this makes good sense, and we know that the government already has all the data required by this act in-house, and we'll be able to find the total amounts of debt forgiveness by departments and the number of ministerial approvals, i.e. the number of times the minister has approved a write-off for debt forgiveness, and the act under which this debt is eligible, but no details will allow us to identify the company, the amount lost by the company. For example, in 2025 public accounts, Volume 3, Section 2, we see which department approved write-offs or loan forgiveness. We see the total for 2024-2025. We know the government wrote off more than $7 billion in debts, including $7.3 in forgiveness. But the rest, we don't really know the details about, and this is a problem. We also know, for example, that under the OAS Act, the government also wrote off a certain amount in 2024-2025. These are large amounts, and the public doesn't have access to this information. The government can't know people can't know the details of what happened and under what legislation this was possible. And we're talking about several $billion. And this is major that we don't know the details around this. And with this bill, C-230, we'll now be able to have the information which will help us as parliamentarians to do more work on this, journalists as well, and the greater public will be able to know more. Some experts as well will have more information. It could be useful for them to know how certain companies behave, and this is good news, especially since this bill, C-230, will not add extra work for public servants because it won't cost a fortune either to implement, because the government, given all the information that is requested, it has compiled in-house. Making it public shouldn't be too onerous. It should be quite simple. So in conclusion, Mr. Speaker, the Bloc is in favor of this bill, and we will support it at third reading. Thank you.
Reprise du débat. The honourable member for Calgary-Midnapore.
Thank you very much, Mr. Speaker. Merci beaucoup, Monsieur le Président.
Thank you, Mr. Speaker.
It's an honor and a pleasure to rise on behalf of the wonderful citizens of Calgary-Midnapore and speak on their behalf. The citizens of Calgary-Midnapore recently went through something all Canadians went through, and that is tax filing date. Yes, the end of April. And so, of course, this is the time where we all must do our duty to society and pay our fair share of taxes. At least this is what we are supposed to do. Now, of course, there are always those who make the decision to not file their taxes. There are those who perhaps cannot pay what they owe or are reluctant to pay what they owe, certainly a problem that compounds over time. But the majority of Canadians, certainly more than the fair share of Canadians, want to do the right thing, and that is pay their part to society, contribute to this incredible nation that we live in. And one way we do that is by paying our taxes. And so I want to thank the member for Simcoe Grey, who had the foresight to recognize that there was this lack of oversight in Canadian society, that there are corporate members who are not necessarily doing that for one reason or another, that they owe this amount of taxation to our society, but are not paying it, and it is not being recognized that they have not kept their commitment to Canadian society and not having paid these amounts. So I just want to take a moment and thank the member for Simcoe Grey, who just went through so much effort, not only to recognize this as as a problem. He is an expert in finance. I've been in his office when he has CNBC on and is following the financial markets, and so it's not a surprise to me that he would have this type of thinking that this should be recognized as something that needs to be fixed. I also want to thank him for taking the time to work with the other parties to gain the collaboration to bring this bill forward, and to see it to success onto this stage within our process and within the House, because this is something very rare and special to do. I myself have never drawn higher than 238 in the private member's bill draw, so I'm very grateful that, first of all, he had this good fortune. Secondly, that he was able to see this idea, and third, that he had the tenacity, the persistence to work through this bill with the government. And I'd also like to recognize their piece in this collaboration. Of course, as a sitting member of the Public Accounts Committee, we went through this bill in detail. We thought about all of the different aspects that would have to be considered. There was compromise on all parts, and I want to thank the member for his compromise in that regard as well, because it's very easy to get very stubborn when it comes to your legislation or something you think should be a part of the bill or accurate, and to not want to include that. But he went beyond that as well. So, of course, we know that the Canada Revenue Agency is responsible for collecting debts owing to the government, but in recent years, the CRA has been waiving debts owing to the government in record numbers. In last year, the government wrote off $4.7 billion. They forgave $10.9 billion. In remissions, they had $0.4 billion, and in waivers, they had $2.6 billion, for a total of $18.4 billion, which at this point would actually be close to 25% of the deficit that we had not only this year, but last year, and at a time where we are encroaching upon $1.63 trillion by 2030 in national debt. Every single dollar counts. And so I'm grateful that this member saw not only this as the right thing to do to society, to pay your fair share, for corporations to pay their fair share, but also at this time where we are in need of such fiscal prudence and responsibility. And so everyone is required to pay their fair share at this time, and that includes corporations. Now, the member for Simcoe Grey is not the only one who recognized this lack of oversight, this lack of acknowledgement of those who are not paying their fair share. We had media outlets such as the Globe and Mail, Bill Curry, of course, who has done an excellent job of following Public Accounts Committee, the Treasury Board. Speaking of which, I'm going to do a little promo here, Mr. Speaker. On June 2nd, I'm looking very much forward to taping with the Arrive Can team the Arrive Can second year anniversary, and we'll be distributing that come the end of June. But Bill Curry has been fantastic in terms of following stories such as these, as well as CBC News also did a story on the $133 million written off that was owed by a single taxpayer. So this definitely is something that needed to be addressed. And write-offs and waivers for taxes owing to the government were done in secret because of privacy provisions in the Income Tax Act. And so the member wanted to bring these numbers to light. And historically, while the CRA spends a lot of time pursuing small businesses and ordinary Canadians who owe minor amounts to the CRA and to Canada, some of these major corporations had gone unaccountable and unnamed. And so this legislation does that. So what this legislation does is it creates a public registry that would require the Treasury Board to publish annually a list of corporate entities that have debts owing to government waived, forgiven, or written off. And the amount that we had put forward originally we were thinking somewhere, the member was thinking somewhere to $1 to $5 million, and the number that was landed upon was $2 million, which is certainly a substantial amount, but I think also a good amount that really provides corporations an incentive to pay their taxes so that they do not end up on this list as well. The contents of the public registry must include the following information in relation to each debt: the name, including any business name of the corporation, the trust company or partnership that owes the debt or obligation to which His Majesty has a claim, the specific amount that was waived, written off, or forgiven, the period to which the amount relates, the act under which the debt, obligation, or claim arose, and any other information that the President of the Treasury Board may require. So the enactment amends the Financial Administration Act to require that the President of the Treasury Board establish and maintain this public registry of certain large debts and obligations owed by businesses to His Majesty, as well as claims by His Majesty against businesses that have been waived, written off, or forgiven. And it also makes consequential amendments to other acts. Some observations relative to this, Mr. Speaker: in 2023-2024, 11 companies received $1.2 billion in combined write-offs for tax debt and other obligations, and 11 companies accounted for nearly a quarter of the $4.9 billion in write-offs in fiscal year 2023-2024. So this is a small number of bad players that we're talking about here. So this being passed is a huge step in the direction of transparency. And certainly on this side, we have always attempted to fight for transparency, whether it is in the appointment of a parliamentary budget officer who will always stand up for transparency and call this government out on things which do not appear to be accounted for. And of course, we advocate against tax increases and new tax measures for everyday Canadians. We believe, why should corporations get enormous debt write-offs when they target the little guy for significantly smaller amounts? So in summary, I just want to thank again the member for Simcoe Grey for bringing forward this legislation. It is the right thing to do in society, to pay your fair share that is owed to Canada, that is owed to your fellow citizens. And also, we are unfortunately in a terrible fiscal position with significant debt as well as deficits, $65 billion this year alone, deficits for the last 15 years. This is a piece of legislation, Mr. Speaker, that looks to remedy this. Thank you very much. Merci beaucoup.
Resuming debate, reprise débat. Therefore, I offer the honourable member for Simcoe North 5 minutes for right of reply.
Thank you very much, Mr. Chair. It's a pleasure to see you in the chair tonight, and I want to thank you for your hard work as well and counsel along the way on this bill. It's my pleasure to have listened to some very thoughtful speeches from my colleagues in this place and my friend from the Bloc Québécois who shares a committee spot with me on international trade. And I certainly appreciate his advice and counsel on that committee. And he himself has a private member's bill he's introduced with respect to forced labor that we're looking forward to supporting them on to get through a chamber and come to a vote. I would say that with respect to the overall objectives of the bill, I just mentioned that bringing integrity back to the system so that Canadians have trust in it is important. And as mentioned from my honourable colleague from Calgary-Midnapore, yes, there have been many journalists, including Mr. Bill Curry from the Globe and Mail, who has had a specific focus on this issue, which also helped keep this issue front and center around my mind. And there are a number of great members on the public accounts who I would not be able to mention whether they're here tonight, but I was very thankful that they brought their thoughtful questions to committee to help it get here. In fact, this was the first bill that went to public accounts in almost 25 years, as I'm told, the researchers at the Library of Parliament. So we weren't quite sure what we were doing there, but we were guided very well by the analysts and the clerk and the great chair in the honourable member from St. John, St. Croix, who did a great job and even had an amendment of his own that helped get this bill over the line. And I would be remiss to not mention my staff, Roman Chelyuk and Kyla Canzanese, who is no longer in my office, who now works at the mothership in the whip's office, controlling all the things that we do in this place. But I want to thank them for their wise counsel along the way. And as mentioned by the member from Calgary Midnapore, yes, the deficits are large, but Mr. Speaker, Mr. Chair, we are here to help. I am here to help. This bill is here to help, and I certainly appreciate the opportunity to bring it forward here this evening. And of course, one can never forget to thank the most important people in their lives, which is our families, my wife and my children, Davy and Cooper, who are probably not watching this at home, but we'll share the clip with them later. But I appreciate the opportunity again to stand here to have, it's an honor to have a chance to propose changing statutes of this country. I certainly appreciate and take this issue with great respect and hope that we have moved the ball forward in progressing on this very important issue on behalf of taxpayers. It is indeed, I think, a matter of the public interest. With that, Mr. Chair, I was always told to quit while I'm ahead and to take the win when you can have it. And so at that point, I believe I'll ask that this House adopt this bill.
The question is as follows. Mr. Chambers, seconded by Mr. Albas, moved the Bill C-230, an act to amend the Financial Administration Act and to make other consequential amendments to other acts. Debt forgiveness registry be now read a third time and to pass. If a member participating in person wishes the motion be carried or carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I would invite them to rise and indicate it to the chair, the honourable member for Simcoe North.
I ask that this bill be carried, Mr. Chair.
Agree to carry the bill. Agreed. The motion is carried.
Third reading of this bill. Troisième lecture de ce projet de loi.
Order. In accordance with Standing Order 38, a motion to adjourn the House is now deemed to have been moved and seconded at this time. Therefore, the question is that this House to now adjourn. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and congratulations to my friend from Simcoe Grey. Those who are watching it starting at late show won't know what just happened. But in any case, that was a good moment. I'm speaking tonight to a question that I asked in question period on January 28th, and it related to what the government had announced as intended cuts to the civil service. Now, the reason I asked the question on that date was I was particularly concerned because within my riding of Saanich Gulf Islands and elsewhere on Vancouver Island, we were getting news that people involved in the critical work of emergency response in the case of oil spills were already receiving their pink slips. They were being told that they were to be removed from their position, and it appeared to be everyone in that department. We have since found out, and it was the same day that I asked the question in question period, January 28th, that the Public Service Alliance of Canada held their own press conference to say that they were informed that there would be about 8,000 workers of the Federal Civil Service who were also to be terminated. Since the time I asked the question, it's now confirmed that about 800 of those people are from Parks Canada. Today I heard from concerned constituents that an interpreter within Gulf Islands National Park, an essential connection for the visiting public on Saturna Island, that position is being terminated. I mean, the list goes on. Many workers within Environment and Climate Change Canada, particularly those who do critical work in understanding and tracking what we're doing to respond to climate change, which is less by the day, so there's less to track. But there's no question that we're seeing significant cuts to the civil service. We are seeing some reduction in an area that I'm very concerned we could see cuts in federal spending, which is the billions of dollars spent on outside consultants. Again, back to the Public Service Alliance of Canada, we have civil service workers with expertise. And if they are put in the role of delivery, they're a lot less expensive than asking Deloitte or McKinsey or others of the billion-dollar management consultants that are all around the world that have been getting too much of the public purse in Canada to do the work that we should be doing internally with our own public service and public sector workers. I saw a recent statement that the Government of Canada in Budget 2026 was going to cut by 20% the amount they're spending. That still, by my calculation, leaves us spending about $4 billion on outside consultants for-profit agencies from outside of Canada for the most part. But what are we cutting here? So again, the cuts in science, the cuts in agriculture research stations across Canada, the cuts in the Ocean Protection Plan, which appears no longer to exist. We're looking at significant cuts across the board. As I said, the Public Service Alliance of Canada says they're estimating 8,000 workers. Now, the government says most of that, and the answer I got that day, by the way, on January 28th, the minister himself stood to answer, which is somewhat unusual. So President of the Treasury Board did stand to answer my question and did say that there were going to be cuts that would be done through voluntary measures. But I rather think, as ever, when a government is putting through significant cuts that affect the services that Canadians want, that they do tend to downplay it and say, well, let's do it by attrition. Let's find some people. We could give them a buyout package and encourage them to leave now, knowing that their job is hanging by a thread anyway. I never did get a clear answer to my concern about specifically the workers who are supposed to be ready, although we know if there was ever a Dilbit spill of diluted bitumen, we don't have the technology to clean it up. But I hope tonight we can get a clear answer. Thank you, Mr. Speaker.
Secretary, the President of the Treasury Board.
Thank you, Mr. Speaker, and I'd like to thank the member for her question. As you recall, government made a clear commitment to Canadians to be fiscally responsible and disciplined to the federal budget. We were also elected on a mandate to spend less on government operations so that we can invest more in workers, in businesses, in defence, and nation-building infrastructure that will grow our economy and strengthen the country. As part of this effort, government launched a comprehensive expenditure review to meet this commitment to responsible, cost-effective spending that delivers results for Canadians. This review required federal organizations to bring forward savings proposals to spend less on day-to-day running of government by targeting programs and activities that are not core to their federal mandate, that are duplicative, or are not aligned with government priorities. Organizations also considered ways to work more efficiently, leveraging existing and emerging technologies such as artificial intelligence where it makes sense. Budget 25, tabled last November, presented the results of this review, which identified savings across government of $13 billion annually by 28-29. This will include decreasing the size of the public service by approximately 16,000 full-time equivalents. It will also look to reduce 1,000 executive positions over the next 2 years. The reductions are being managed with fairness and compassion, relying on attrition and voluntary departures to the greatest extent possible. And that is why we have the early retirement incentive. Organizations are required to follow established workforce adjustment policies outlined in collective agreements, or in the case of executives, career transition measures. Both set out clear processes to support and supports for employees who may be affected. In a workforce adjustment situation, Mr. Speaker, there are specific provisions governing how this is done that are co-developed and negotiated with bargaining agents. Indeed, the government is leveraging all available tools to limit involuntary departures, and this includes the proposed early retirement incentive, a program that will provide an opportunity for eligible employees to retire without penalty for early departure. These reductions are being carried out fairly and responsibly in line with government's obligations as an employer. They are part of a necessary and major recalibration in government spending that will redirect funds to investing in Canada. They are what this moment calls for, Mr. Speaker, and an investment in our future. Thank you.
The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and my honourable friend, the Parliamentary Secretary. Forgive me if I'm not impressed with this government's attempt to run balanced budgets when we now have a $66.9 billion deficit. We also know that where there are funds that could be accessed through reasonable shifts in taxation, such as a wealth tax. Those opportunities are being avoided. So is to the financial transaction tax that would affect nothing but multiple billionaires. We also see an increase, a boost in subsidies to fossil fuels. And there is a real cost in the climate impacts that will happen across Canada, not to mention specifically the one I keep trying to find an answer for, cuts to the workers who should be ready in the case of emergency oil spill emergencies. In fact, we don't have people to maintain the vessels that were purchased for the oil spill emergency, what I would call greenwashing of saying we're prepared. And with no ocean protection plan, where are we now for the impacts of the Build Canada Strong major projects?
Mr. Secretary.
Thank you, Mr. Speaker, and I can assure the member that as government goes through this process in a fair and compassionate way, we are also, Mr. Speaker, committed to ensuring that the services that Canadians rely on, that Canadians will get. We are absolutely committed to Canadians, to providing better services for Canadians, but also being fiscally responsible. Thank you, Mr. Speaker.
Kamloops, Shuswap, Central Rockies.
Thank you, Mr. Speaker. On April 17th, I asked a question of the government, and the response provided by the Minister of Housing and Infrastructure and Pacific Economic Development was unacceptable, which is why we are here now for this debate this evening. On April 17th, I state, quote, that after more than a decade of Liberal policies, life is unaffordable. The latest MNP Consumer Index report states 70% of British Columbians say rising prices for food and gas are straining their finances. Liberals voted against reducing taxes that increase the cost of gas by 25 cents a litre. They voted against removing taxes on food that drive up the cost of groceries. Then I asked the government, why won't the Liberals provide Canadians with some relief by adopting our Conservative plan to cut taxes on gas and food to make life more affordable for Canadians? My question was on fuel and grocery costs, things that Canadians need and purchase every day. In response, the Liberals decided to put up a housing minister who parroted pre-processed Liberal talking points about housing. By refusing to deliver reliefs that are within their reach, this Liberal government is refusing to recognize the problem, refusing to make life more affordable, and forcing more Canadians to be reliant on government rebates just to put food on the table. Mr. Speaker, when I had a group of students in my office this week, they were genuinely concerned for their futures because of the massive increases, not just in their cost of their education, but in the cost of daily living. And they have almost given up on the dream of owning a home like their parents were able to achieve. Mr. Speaker, I don't know what it takes for this Liberal government to realize their inflationary policies are part of the problems that these students and other Canadians are facing. The Liberal government could remove the fuel standards tax and the industrial carbon tax to instantly reduce the cost of fuel and groceries for Canadians. But they continue to make things worse with inflationary spending that Canadians are forced to repay with interest. And speaking of interest, the debt this government has piled up will mean roughly $3,400 for every Canadian family. That will go toward federal debt interest this year alone. Just interest, not repayment of the debt. So I will repeat my question from April 17th once more, this time in hope that the government will give Canadians an answer they really need and deserve instead of pre-processed talking points from the minister's office. Why won't the Liberals provide Canadians some relief by adopting our Conservative plan to cut taxes on gas and food to make life more affordable for Canadians?
The Honourable Parliamentary Secretary to the President of the Treasury Board.
Thank you, Mr. Speaker. And government is well aware that affordability is the single most pressing issue for Canadians, and that's why we focused on delivering targeted support where it matters most. The world is changing rapidly and not always for the best. It's increasingly fragmented, complex, unstable, and for far too many, it's also more expensive. We can't control the conflict in the Middle East or the war in the Ukraine or the tariffs that are transforming global trade. But what we can choose to respond to is building the strongest economy in the G7 and providing targeted supports to those who need it most. And over the past number of months, we've supported Canadians with concrete measures to make everyday life more affordable. Essentials like groceries more affordable. We introduced the Canadian Groceries and Essentials benefit. This measure builds on the GST credit and will provide additional support for more than 12 million Canadians, starting with a one-time top-up on June 5th. Combined with a 25% increase in the benefit over 5 years, as of July, a family of 4 will receive up to $1,890 a year, or a single individual $950. The lower cost for Canadians, to lower cost for Canadians, we've suspended the federal fuel tax on gasoline, diesel, and aviation fuels until Labor Day. This measure is expected to reduce the cost of filling up at the pump by more than $5 on a 50-litre tank. Benefiting more than 25 million Canadians, it will reduce operating costs for truckers, businesses in the food, agriculture, housing, and construction industries. And we've also lowered the first marginal personal income tax rate from 15% to 14%, providing tax relief for 22 million Canadians. In 2026, this change means savings of up to $420 a person, or $840 for a two-income family. More than 6.5 million Canadians can now access affordable dental through the Canadian Dental Plan. We've made the National School Food Program permanent to provide meals for up to 400,000 children each year. This program saves families with 2 children participating in school up to $800 on groceries. First-time homebuyers are saving up to $50,000 through the removal or reduction of the goods and services tax on eligible new homes. Canadians are now paying less in banking fees as well, Mr. Speaker, with the changes that we've made to banking fees in this year's budget. We've also expanded access to low-cost and no-cost bank accounts for Canadians, up to 50% more debt transactions at a cost of no more than $4 a month. These measures are making life more affordable for Canadians. In the spring economic update, Mr. Speaker, we announced the intention to reduce the contribution rate to the Canadian Pension Plan base rate from 9.9% to 9.5% effective January 1st of next year. And this was achieved due to the cooperation of all provinces, Mr. Speaker. We look forward to introducing more measures and making life more affordable for Canadians.
A member for Kamloops, Shuswap, Central Rockies.
Well, Mr. Speaker, more pre-processed talking points from the Minister's office. No real answers for Canadians. The Parliamentary Secretary said that they're aware of the affordability issue. But are they aware that this government is responsible for it? The ever-increasing deficits. This year's deficit 2 times what former Prime Minister Justin Trudeau would have done. Billions of dollars now being paid out in debt payments. He mentioned what they can't control, the war in the Middle East, external issues, but they can control liberal taxation and liberal deficit spending. Why will they not take the steps that they can take? This Liberal government could take steps to relieve the pressure on Canadians. Why won't they?
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. The opposition party, Mr. Speaker, can control certain things. We know what they would do, Mr. Speaker, if they ever formed government. They would get rid of the $10 a day childcare. We know this because they voted against it. We know that they would get rid of the dental plan because they voted against it. We know that they would get rid of the increases to old age security. They voted against that. We know that they would get rid of the school food program because they voted against that, Mr. Speaker. They voted against reducing taxes for first-time home buyers. On this side of the House, we are working to make life more affordable for Canadians. We hear a lot of talk from the Conservative Party, Mr. Speaker, but we don't see action. The only action we see is voting against programs that would make life more affordable for Canadians.
Yeah, member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. Tonight I'm following up on a question that I asked about the crisis in youth unemployment. Mr. Speaker, life is very challenging right now in this country, especially for youth and for young families. People that are struggling to get their start in life struggle to access employment. They struggle with housing affordability. And this makes it difficult and leads to delays in family formation. We know statistically that if you ask women how many children they want to have and compare that to our current fertility rate, there's a gap of almost 1 child per woman. That is, many Canadian families are not having as many children as they would like to have. And I think that has a lot to do with challenges in employment, challenges in housing affordability, these basic challenges in getting started in life here in Canada because of how difficult those startup costs are. And the youth unemployment crisis is a big part of it. And I think it's very clear that what the government is doing or says they're doing in this regard is just not working. Listening to question period today, they want to celebrate allegedly this initiative or that initiative, but the overall numbers paint a clear picture, which is a metastasizing, unprecedented youth unemployment crisis that is connected to and contributes to challenges that families are facing as well. Speaker, Conservatives have taken a very constructive approach to the employment file. We have developed and offered the government concrete solutions to these problems. Obviously, the government is the government. They have the power to implement these things, and we don't. But we have put constructive solutions on the table and asked the government to implement all or part of what we put forward. This fall, we put forward the Conservative Youth Jobs Plan, a clear plan addressing the youth unemployment crisis, with proposals to unleash the economy, to fix immigration, to fix training, and build homes where the jobs are. Now, just today, we've announced another suite of policy initiatives, this time targeting the challenges that young families are facing. We're proposing substantial parental leave reforms that will make life easier for those who are trying to start a family. These policy proposals are flexible parental leave, allowing a person on parental leave to pause and resume that leave. We've proposed learning on leave, allowing anyone to take courses of study while they're on parental leave so that they can upgrade their skills and strengthen their ability to meet the labor market again once their leave is over. We've also proposed a caregiving exception to EI parental leave benefit clawbacks. This would allow somebody who is caring for their own children to also do paid caregiving work on the side. Perhaps while you're watching your own child, your neighbor pays you to watch their child as well. Removing the clawbacks associated with earning in this situation would increase the availability of childcare, in many cases which, notwithstanding the exaggerated promises of the government, simply is not available to many parents. So we are working hard to propose constructive solutions to the very real and practical challenges facing youth and young families today. I'd like to know why the government hasn't taken the opportunity to embrace these solutions. I think it would be a political win for them, and it would be a win for youth and families. Will they take on these good ideas that we proposed?
Secretary. Thank you, Mr. Speaker. We're always prepared to look at good ideas, Mr. Speaker, but we are also acting and putting in place measures that really make a difference for Canadians. We couldn't agree more that Canadians are looking for hope and real solutions. Preparing Canadians for good jobs is a top priority of ours, especially during these challenging times. We're renewing Canada's workforce strong, a Team Canada strong. It's a $6 billion promise to protect our workforce and protect our capacity to grow the workforce, because without skilled workers, we cannot meet the moment. That's why under the Team Canada Strong, we will recruit, train and hire up to 100,000 new Red Seal workers in the next 5 years. This is critical because within 7 years, there will be more than 410,000 vacant skilled trades positions across Canada. There's no time to waste. Team Canada Strong will expand our union training and innovation program so that union-run training centres can upgrade their facilities and invest in modern equipment. Small and medium-sized businesses will be supported when they hire new first-year apprentices. The Build Canada Apprentice program will help employers hire and train apprentices, providing them with up to $10,000. And once certified as a Red Seal trade person, they will receive a $5,000 completion bonus. The new apprenticeship training grant means that apprentices can receive an income top-up of $400 per week while they're getting technical training. This comes out of a total payment of $16,000 per apprentice. But we know that there's more that needs to be done to weather the current storm. That's where the labour market development agreements and the workforce development agreements come in, Mr. Speaker. These represent $2.9 billion annual investment in training and employment assistance services to help hundreds of thousands of Canadians upgrade their skills and find employment. Our programs help workers complete their studies, build their skills, and access opportunities that lead to successful careers. Since 2019, Canada Summer Jobs has helped more than 600,000 young people find summer employment. This summer, the program will support up to 100,000 jobs for youth between the ages of 15 and 30. All told, we've supported over 175,000 opportunities for youth and students this year under the Student Work Placement Program, the Youth Employment and Skills Strategy, and the Canada Summer Jobs. In 26-27, the Student Work Placement Program will support up to 55,000 work-integrated learning opportunities with employers for post-secondary students. Over 34,000 employers and 420 post-secondary institutions have participated in this program, Mr. Speaker. We are focused on delivering the results that Canadians need and creating the opportunities that will strengthen the economy.
Member for Sherwood Park, Fort Saskatchewan.
Mr. Speaker, that wasn't really an answer to what I asked. Here are the facts. We have a metastasizing youth unemployment crisis in this country. There are various factors, many factors of government policy that are contributing to it. We have put forward constructive solutions in the area of supporting families that I talked about today, reforming parental leave, and also in the area of addressing youth unemployment. We've been very constructive and clear with the government. They say they're willing to listen, but they don't really listen or respond to these constructive proposals we put forward. Now, the member spoke about changes that the government's made in training. Look, here's what the government did in the last budget. They rendered ineligible vocational institutions to receive student grants. So you study at a university, you can get a student grant. But if you study at a vocational institution, preparing you for a specific vocational career where there are shortages, the government cut that out. So what we've suggested is that they not discriminate against students at vocational institutions. Will they at least listen to that constructive idea?
Parliamentary Secretary.
Thank you, Mr. Speaker. It is interesting to hear the member talk about people who don't listen and are not tuned into the Canadian public and the needs of Canadians. It is the Conservative Party that voted against reducing the tax on first-time homebuyers, making it easier for young Canadians. It was the Conservative Party that voted against $10 childcare, making it easier for Canadians. It was the Conservative Party that voted against a reduction in income tax, helping 22 million Canadians. It was the Conservatives that voted against the Canadian Child Benefit, Mr. Speaker. It is interesting to hear the member talk about people who don't listen. The Conservatives have not listened to the Canadian public and what Canadians need, and vote against every opportunity in this legislature to make life easier for young Canadians.
Order. The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 o'clock a.m. pursuant to Standing Order 24-1.